All right, we're live streamed. Thank you, Miss Anna. Okay. All right. Good morning.
Madam Hearing Examiner, you're coming through loud and clear now.
I crawled out of that well.
You did.
Actually, what I did is I went back and looked at the sound settings, and one of the other speaker options had been selected after the luncheon hour, and apparently it was not the I'm loud and clear option. Okay, if parties don't have any procedural issues, we are on YouTube. Just going to get some clarification in the record as when we begin. I've got that we've got 3 minutes till we begin, and then we can resume our evidentiary portion of our hearing. One of the things I will address, I've been reminded by our most excellent court reporter that parties have not put in the Dropbox the conforming exhibits to yesterday's, at least when he last looked, of yesterday's rulings. Okay. One other thing before we begin, parties should start thinking and collaborating if you can reach agreement as to when parties believe that they can have post-hearing brief writings, whatever. I envision 2 rounds, an initial and a reply a week after the initial briefs are filed. As the parties know, there is an expedited transcript in this matter. So, like I say, if you all can talk about that, that would be good. Ms. Beatles, you have procedural issue before we begin?
Yes, good morning. Just in response to what you just said, what are your preferences or constraints, considerations around brief scheduling?
Well, I was kind of waiting to see what you all were going to say. I thought what I was going to get is from the parties, oh, we have this case, this case, this case, and this deadline, deadline, deadline. And yes, Elizabeth, we do celebrate holidays. And so I don't really have any particular constraints at this point.
All right. Thank you
Okay.
for that feedback.
Very well. Mr. Lee, how are we doing?
Good, Judge.
Are we ready?
Yes, Judge.
Okay. Thank you, sir. Good morning. We are returning from our evening recess in case number 24-00266UT. This is in the matter of the joint application for approval to acquire New Mexico Gas Company Incorporated by Saturn Utilities Holdco LLC. My name is Elizabeth Hurst. I am the designated hearing examiner, and along with me is my co-hearing examiner, Patrick Schaefer, and our court reporter, Mr. Lee. Should anyone need anything to do with the transcript, they'll have to contact Mr. Lee to get directly. Let's go ahead and get our appearances as requested onto the record this morning, beginning with staff.
Good morning, Madam Hearing Examiner and all the other interveners and applicants. Nicholas Rossi for staff, along with Ryan Friedman and Katie Lang.
Good morning. Let's see. Mr. Harris.
Good morning, colleagues. Brian Harris on behalf of the New Mexico Department of Justice.
Good morning. Mr. Freeman.
Morning, everyone. Jelani Freeman on behalf of the federal executive agencies.
Good morning. Ms. Lynch.
Good morning, hearing examiners and colleagues. Kara Lynch with CCAE and Prosperity Works, here with my colleague Charles DeSalin.
Thank you and good morning. Ms. Beatles.
Good morning. Sydney Beatles for Western Resource Advocates.
Thank you. Mr. Yar.
Good morning.
Mr. Gould.
Good morning, Madam Hearing Examiner, colleagues. Joseph Yar on behalf of New Mexico Affordable Reliable Energy Alliance NM area. With me here also is Mr. Gould.
Good morning. Thank you. Ms. Nanasi.
Mr. Nasi said she wouldn't be here this morning.
Oh, that's right. She did. She did announce before close last night that she would be away. Thank you, Mr. Lee. I think joint applicants.
Good morning, hearing examiners. Rick Alvidrez And with me are Dana Hardy and Will Dubois on behalf of the BCP applicants in this case.
And
Thank you.
Madam Examiner, Tom Domi, Brian Haverly, and Juliana Hopper on behalf of Amera and New Mexico Gas Company, and also Nicole Strausser, General Counsel for New Mexico Gas Company, is appearing in this case.
Thank you, sir. Good morning. Okay, I think I got our appearances. We are, as I indicated, returning from our evidentiary portion. I had a couple of procedural matters before we begin. I thought I had admitted, but I'm going to make double sure. Joint applicants filed their response to the third bench request yesterday. This bench request asked the joint applicants to memorialize on paper any additional commitments it may have made beyond those that were set forth in the record and joint applicants' response to the first bench request. Hopefully, parties have had the opportunity to review joint applicants' response to the third bench request. And is there any objection to admitting joint applicants' response to the third bench request? Hearing none, joint applicants' response to the third bench request is admitted into our evidentiary record. And if I could ask, please, for the joint applicants to please put their responses to the three bench requests in the Dropbox today, I would appreciate it.
Yes, ma'am, we'll do that.
Okay. Additionally, I would also like to request that the versions of the testimony that were admitted into the record yesterday be placed into the Dropbox today. The conforming versions. Additionally, there have been 3 requests for offers of proof under 1.2.2.35M. And before our evening recess, I did rule, and I'll just remind people that under section M, that an offer of proof for the record may be made and shall consist of a statement of the substance of the evidence to which the objection has been sustained. The commission or presiding officer may require offers of proof be submitted in writing in question and answer format. And I did require that the offers of proof be submitted in writing in question and answer form. That's going to have to be done prior to the conclusion of our hearing so that those can be attached
Judge,
to.
hold on a second. My machine just froze. I'm gonna have to restart. Just give me a second.
Yes, sir.
Test. Judge, give me half second, just one
Yes, sir.
minute. Judge, I have to open a new file. It'll be 2 more minutes.
Yeah. Why don't we take a 5-minute recess and we'll come back at 9:20. How we doing, Mr. Lee?
Good, Judge. The last thing I got was the commissioner or presiding officer may require officer proof be submitted in writing in question and answer format. And I did require that officer proof be submitted in writing in question and answer format. That's going to have to be done prior to the conclusion of our hearing so that those can be attached. If you'll start from there, I'm good to go.
Okay, we have 1 minute. All right, sir. If you're
Ready,
ready. Great. We're
Go
back
ahead.
on the record after a brief recess. I believe technical difficulties have been remedied. And based upon where we stopped, all I need to add to that sentence is admitted into our record. So that's what I wanted to say about that. Mr. Yar, I see you have your hand raised.
Yes, Madam Hearing Examiner, thank you. What I'm hoping to do is get a little bit of clarification so that we conform to what your requirements are for the offer of proofs. Let me start by the testimony of Mr. Chris Walters. My understanding is your ruling was the exhibits CCW2 and CCW3 were not admissible.
That's right.
And then I guess where I'm trying to get my head wrapped around it is how would you like us to present that to the court? Do you want us to, from my understanding from last night, was to strike out all of the exhibits because it was all testimony. I mean, it was all deposition transcripts, and then have a note of some sort on the front of it saying these are not being allowed into the record as evidence. Is that correct?
Well, you can submit your testimony, resubmit your testimony with a note on the front that says any reference to attachment 2 or 3 in the testimony, or whatever you want to say, I would just put a note on there that says attachment 2 and 3 were not admitted.
Okay.
And then that way the reader will know, if they read that whenever there's a reference, I mean, yeah, you probably should go and red strike every time that reference is made in the testimony.
Okay.
Just the little red lines.
Yep.
Okay.
Okay. And then we would be submitting that as a new NM area exhibit, whatever the following number is. I think it's 46 or 47, correct?
Whatever your number is for that testimony,
Uh-huh.
I think you can use.
Okay.
Because I admitted that number except for those 2 attachments.
Very well, Your Honor. I understand.
Now, your offer of proof should say it's not an evidentiary exhibit. Is that what we wanted to do, Mr. Lee? Let's go off the record here for a second. Should it be the next following exhibit, or should it just be separate offer of proof NM area 1?
If exhibit 1 is the actual exhibit and the offer of proof is, I would make it 1A, to be honest, Your Honor. Unless that is not acceptable. Or 1O for offer of proof, or 1 OFP. Are you there, Judge?
Yeah, no, I'm yes, sir. 1 OP?
Yes, sir. Yes, ma'am.
Okay. All right, unless there's an objection, yeah, let's do it that way, Mr. Yar. And for the record, Ms. Nanasi and whoever, if there's an offer of proof, you want it NM area, OP, and then whatever number it is.
Okay,
Okay,
got it. Following up with that, we did have an offer of proof, a second offer of proof for exhibit NM area exhibit 18 and 23. Those were the full transcripts, Madam Hearing Examiner, of the deposition of Mr. Tuminello and also Mr. Baudier. What I think we were waiting on from your honor was that whether or not it would be easier for the record just to produce the first page of those transcripts, or I should say, the pages that show that they were under oath, or did your honor? I know the BCP applicants had objected to both ways, but your honor had reserved on making a decision on that, and I think I just want to get a clarification on how we wanted to approach that offer of proof and how to submit it, your honor.
so you want to offer all four exhibits?
Yes, that's right. Yes, ma'am.
Okay, and I have not ruled, I don't believe, on 18 and 23.
That is correct, Madam Hearing Examiner.
Okay. So if you're offering NM area 18 is what?
Is the deposition of Mr. Hold on, I have my little master list here somewhere. I believe it's Mr. Baudier, his full deposition. That's correct.
Okay. And is there any objection to NM area 18?
Madam Hearing Examiner, yes, the joint applicants object to.
I'm sorry, who is speaking?
Brian Haverly, sorry, Mr. Lee, and we objected originally, and we continue to object to the admission of that exhibit.
And you're saying you already set forth the basis of your objections
Yes, Madam
previously?
Yeah.
Okay.
Mr. Waugh did that on behalf of the joint applicants previously.
Okay, so there's nothing new with regard to NM area 18. Based on what I've heard and the rules of evidence, the rules of civil procedure, I am going to deny admitting the transcript of a witness who was available at the hearing to be questioned with regard to NM area 23. That is what, Mr. Yar?
That is the deposition of Mr. Peter Tuminello.
And Mr. Haverly, joint applicant, also objected to the admission of NM area 23. Is that correct?
Yes, Your Honor, that is correct. We laid out our objection yesterday on the record, and we continue to object.
And for the same reasons that NM area 18 was objected to, as well as the rationale for objecting partial pages of a transcript of a witness who appeared and could have been cross-examined on their testimony. NM area 23 will not be admitted. Mr. Yar, anything further?
Yes, Madam Hearing Examiner. Another point of clarification. Thank you for your ruling. I believe Your Honor had indicated that the offers of proof have to be uploaded by the end of the hearing. And I just want to make sure I understood that. Is that correct, Madam Hearing Examiner?
Yes,
Okay. Sorry.
right. They're gonna have to be uploaded into the Dropbox. And so yeah, yes.
Okay. Thank you, Madam.
Before the hearing ends.
Right. With regard to the exhibit, Mr. Walter's testimony that is now has parts of it that are stricken, Your Honor had indicated that you wanted those uploaded by the end of today. Madam Hearing Examiner, I'm requesting that if we could have until tomorrow by noon to do it. We're a little shorthanded today on our staff. And the requirements are going to be a little bit tedious. And so we just request, instead of having it uploaded by the end of today, if you will indulge us and allow us to file it by noon tomorrow, Madam Hearing Examiner.
Well, my court reporter would have liked it last night since it was admitted yesterday. So you're actually getting a break by doing it today. Do it as soon as possible, Mr. Yar.
Will do, Madam Hearing Examiner. Thank you.
Very well. Anything procedural that we need to take care of? Hearing nothing, pursuant to agreement, we're going to take a witness out of order. Mr. Rossi, you have a witness, sir.
Yes, I do. Thank you, ma'am. Staff will call Dr. Bryce Zadalis.
Hello.
Hello there, Dr. Zadalis. Welcome back.
Thank you. Thank you for accommodating my schedule.
Hope your child gets well soon, sir.
He's better now. Thank you.
Excellent. Mr. Lee, would you please swear the witness?
Dr. Zadalis, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir.
Go ahead, sir.
Thank you, ma'am. Hello, Dr. Zadalis. Always sounds like a silly question, but could you please state your name for the record?
Yes, my name is Bryce Zadalis.
And how are you employed?
I am currently on contract with the New Mexico Public Regulation Commission, serving many of the same functions as a public utilities economist.
Did you prepare testimony for this proceeding?
I did, yes.
Do you have a copy of Staff Exhibit 4, the prepared direct testimony of Dr. Bryce Zadalis?
I do, yes.
Is there an attachment BZ1?
There is.
Let's talk, we'll get to the attachment later. Let's talk specifically about your testimony. Is this your sworn testimony in this matter?
It is.
Is the testimony in Staff Exhibit 4 prepared by you?
Yes.
If I asked you the same questions today, would your answers be the same?
Yes.
Are the answers true and accurate to the best of your knowledge?
They are, yes.
Now let's talk about that attachment BZ1. Is this the joint applicant's response to staff's 7th set of interrogatories, specifically 7-1, 7-2, 7-3?
Yes.
Is the full interrogatory and the affirmations of the witness, Ryan Schell, included?
For those specific interrogatories, yes.
And were they relied on you when preparing your testimony?
Yes, they were.
Do you reference this exhibit on page 6 of your testimony?
I do, yes.
At this time, staff is moving to admit Staff Exhibit number 4.
Any objection to what's been identified as Staff Exhibit 4, Dr. Zadalis pre-filed testimony as affirmed by him here today? Hearing no objection, Staff Exhibit 4 is admitted. Mr. Rossi?
I have no further questions for this witness at this time. I tender him for cross-examination. Thank you.
Thank you. It is my understanding that gas company / Emera reserved 10 minutes of cross-examination for Dr. Zadalis. Mr. Dome?
Thank you, Madam Hearing Examiner. Dr. Zadalis, my name is Tom Domi, and I am the attorney for Emera and New Mexico Gas Company in this case. Nice to meet you.
Good morning, Mr. Dome.
As I read your testimony, it is my understanding that you are the primary staff witness on the question of the severe weather fund. Is that correct?
For the Severe Weather Fund, yes.
Tell me a little bit about how this idea came up. Was it your idea to propose the Severe Weather Fund?
It was a collaborative venture, an organic venture. Whenever we were approaching our analysis of the joint applicant's application or the BCP applicant's application to acquire New Mexico Gas Company, staff took the perspective of in the event that this application was to be approved, or even, in our quest to find additional benefits within the context of the application, what could staff ask for? How could we come up with additional proposals that could further benefit New Mexico Gas Company customers in the event that this transaction goes through? And so the idea of a severe weather fund, like I mentioned before, it was a collaborative endeavor. Myself, as well as some ranking members on staff, some higher ups in the utility division. We looked back through the last several years of New Mexico Gas Company's operating history to ascertain whether or not there were any sort of problems that arose that affect New Mexico Gas Companies, and to some extent could have impacted New Mexico Gas Company as well. And the one big one that we saw was the Winter Storm Uri in 2021, and the attendant $100 million costs essentially for New Mexico Gas Company's acquisition of swing gas, or purchase of swing gas, I should say, during Winter Storm Uri, that was subsequently passed along to New Mexico Gas customers. So we thought to ourselves, could there be a mechanism that would reduce a total potential future liability in the event that another such event was to take place and to affect New Mexico Gas customers?
So in this case, the first time that you raised this concept was in your testimony in September of this year, right?
That is correct.
You didn't raise it in the earlier staff testimony in this case.
So for the earlier staff testimony, Mr. Domi, I was not actually, I did not file testimony early on. I was serving more in a consulting role, helping to edit testimony, provide some insights, develop discovery. But it was really over the summertime between the original application, the revised application, that we had some more time. I had more time to actually take a look at some of the issues that could affect New Mexico Gas customers moving forward.
So I think the answer to my question was yes, you did not raise it.
We did not raise it earlier on, no. Yes, in the revised application.
Let me ask you another question. Did you raise the prospect? Well, when did you start working in a consulting basis for staff?
I've been working on a consulting basis with staff since, I think it was December 2022, January of 2023. And I've had my contract renewed since then. But for the most recent contract, that began July 1 of 2025.
Okay. Did you look back at the record in the Uri case, the Storm Uri case?
In part, I did review some of the final order material as well as the recommended decision.
Did you observe that staff did not propose a severe weather fund in the Storm Uri case?
I did see that was not proposed, yes.
Did you discuss that with staff as to why they did not propose this in the Storm Uri case?
We didn't discuss that internally. We did not discuss that internally.
Did you have that question in your mind, why they didn't raise it earlier?
No, we viewed this new case as an opportunity to actually address some of the issues that might not previously have been addressed.
When did you first begin to consider a severe weather fund?
I think it was over the summertime of 2025, sometime between like June and July.
Did you reach out to any of the other utilities in New Mexico, gas utilities or electric utilities, and discuss what you had in mind?
No.
Did you consult with New Mexico Gas Company before filing your testimony as to what you had in mind?
I don't know if it's admissible in this particular proceeding, Mr. Dome, but we did obviously engage in settlement discussions where this issue was brought up.
And I wasn't asking about the settlement discussions. I was just asking about, did you reach out and discuss your concepts with any of the other utilities or with New Mexico Gas Company to get their take on this suggestion?
Only in the setting that I previously referenced.
If your severe weather fund is adopted, do you anticipate that it would also be applicable to the other utilities in New Mexico?
I wouldn't. It depends on the facts and circumstances associated with any sort of future, acquisitions of those utilities, and what the commission decides is actually going to be applicable. Could it be? Potentially. Potentially not, though.
So by your answer, are you saying that before it's applied to other utilities, it would have to be raised in an acquisition case?
I'm sorry, Mr. Dome, I can barely hear you. Are you saying in your answer
That it would only be applicable to, or made applicable to other utilities in acquisition cases?
It wouldn't necessarily have to be. Staff could petition the commission to apply this sort of concept elsewhere. However, Mr. Dome, I will say again, the acquisition case herein, we view this as an opportunity to propose something new and to propose something that could benefit New Mexico Gas customers.
Did you have a chance to listen to Sudeen Kelly's testimony, Ms. Sudeen Kelly's testimony?
As a matter of fact, I did not. No, I'm sorry. I've been with a sick child for a few days now. Sorry.
Okay. All right. Did you read the transcript of Ms. Sudeen Kelly's testimony?
I've not been able to do that, no.
I want to paraphrase at the risk of an objection, but I'm going to paraphrase Ms. Kelly's testimony. And before I ask that, are you aware that Ms. Kelly was a former NMPRC commissioner?
I am aware of that, yes.
And a former FERC commissioner?
I am aware of that, yes.
Paraphrasing her testimony, she testified that the idea is interesting, the idea that you proposed is interesting, but that it is undeveloped, and there's a question in her mind about whether or not it should be reserved to a different proceeding where it can be more fully developed.
Objection. He's already stated he didn't hear the testimony.
Dr. Zadelis, did you read her rebuttal testimony?
I did read the rebuttal testimony.
And did she criticize your proposal?
My understanding is she did not go into the depth that Mr. Dome just provided. It was more of a passing criticism saying this was not something that was a requirement for the transaction itself to be approved. That's my understanding, my paraphrasing of her rebuttal testimony.
Well, your response, he said that he didn't hear the testimony, but I'm going to overrule the objection because Dr. Zadelis, I'd like to know if you have a response to that.
Would Mr. Dome be able to please restate the question?
Basically, he just wanted to know that he said she testified that it was interesting but that was undeveloped and might be better in a different proceeding.
Okay, yes, I can speak to those two issues. To the first issue about it being undeveloped, as I point out in the testimony, what staff is asking for in this particular case, first and foremost, is for the $12.5 million worth of non-ratepayer benefits be set aside into the proposed severe weather fund, and subsequently for the various stakeholders to this particular fund, as well as New Mexico Gas stakeholders overall, participate in a working group to flesh out the exact details regarding how is this fund going to be accounted for, when can it be dispersed, among other issues. So with respect to the idea of it being undeveloped, we do want to reserve some of those more critical issues, more in-depth issues for the working group. And then to the second issue about this potentially requiring a different case, I do mention that in my testimony, as this is quite a new proposal. Again, I will repeat the same answer that I previously gave to Mr. Dome, is that we view the acquisition case as a vehicle to make a proposal to address an issue that New Mexico Gas customers had previously faced, and to see if there's any part of this acquisition proposal that could be used to benefit those same ratepayers and to address the issue that we identified. So I would say that from the standpoint of it being undeveloped, that's intentional, because we do understand the fact that there could be a requirement that for the overall severe weather fund to be fully fleshed out, that might require a different case docket. Nevertheless, what we're asking for in this particular case, at the core of our ask, is that the $12.5 million in non-ratepayer benefits be earmarked for the severe weather fund to benefit New Mexico Gas customers.
Mr. Dome, you got 1 minute.
Mr. Zadal, Dr. Zadal, have you contemplated the subsidization issues raised by your proposal?
Could you please define subsidization?
Subsidization between customers over the period of time that the fund is being funded and then paid out?
So with respect to the initial funding, Mr. Dome, it's cost-free to ratepayers, because essentially the money is coming from the applicants in this case. And so this might be the one time in which staff, as well as New Mexico Gas Company, can put together a proposal to address a long-term issue at no expense to ratepayers initially. With respect to the AMA, I think that's what you referenced, the AMA and the storage contracts.
That's not what I was referencing, Dr. Zadal. What I'm asking is, if the customers, and I respectfully disagree with your statement that it's cost-free to the customers, but the customers who pay into the fund in year 1, and then the fund is not paid out until year 10, when the customer group is different, that's a subsidization issue, isn't it?
You can't testify, Mr. Dome. Ask him a question.
Okay, is there a subsidization issue that is created because of the difference between the funding on year 1 and the payout in year 10?
No, not to our belief, since the money is coming from an acquirer as opposed to coming from the customers themselves.
I think I'm out of time, Your Honor.
You are. Are you stopping or are you borrowing?
Oh, I can borrow a little bit, I guess. No, I can't. I've only got 5 minutes on those. I think I'm stopping. I'll let others finish this questioning.
Thank you, Mr. Dome. I believe that the joint applicants reserved 20 minutes for Dr. Zadalis.
Yes, Your Honor.
Go ahead.
I guess it's good afternoon where you are. Is that right, Dr. Zadalis?
Yes, it is. Just about good evening. Is this Mr. Alvidrez?
About to introduce myself. I'm Rick Alvidrez on behalf of the BCP applicants in this case. I wanted to follow up on a few matters that Mr. Dome mentioned. I mean, the issue of the increase in gas prices due to severe weather goes back to 2021, right?
Specifically to the increase in swing gas prices, yes, there have historically been other winter weather events, though.
Okay, but none to the extent or that have required New Mexico Gas to come in and seek to have special arrangements around its purchase gas adjustment clause in order to provide a more levelized cost to customers, right?
So specifically to swing gas, the one event is the 2021 event, yes.
Okay, and NMGC isn't unique. The other privately owned gas companies had the same situation, correct?
I am not aware of their situation. I've only testified in this particular case related to gas.
So in the course of your work, you didn't look at what the other gas companies experienced with regard to gas costs and Winter Storm Uri?
No.
Okay. Since this matter has been around since 2021, why didn't staff seek to implement a severe weather fund in NMGC's last rate case that was filed in 2023?
I can't speak to that. I was not testifying in that particular case. I can't speak on behalf of staff historically.
And
I can
go ahead.
I can only speak for right now, Mr. Alvidrez.
Okay, so you also could not explain why staff didn't seek to implement a severe weather fund in the NMGC's last PGAC continuation filing in 2024 then, right?
I could only provide speculation, nothing definitive.
Okay. Well, don't you agree that if this is a problem which extends across the other privately owned gas utilities, that it's something that should be addressed in the context of a broader rulemaking?
I think there's various venues through which this issue could be addressed, and we're using the opportunity right now to try to address it. Well,
is this acquisition regarded opportunistically by staff? Because it's a situation where there will be benefits put up, and staff is thinking, well, we'll take some of those benefits and use them for this fund.
Again, I think that staff's thinking right now is to maximize any sort of benefit to ratepayers by providing them both with short as well as long-term benefits. And part of that is staff's proposal to redirect some of the non-ratepayer, non-NMGC customer benefits to the potential benefit of New Mexico Gas customers moving forward.
So in the public notice that was sent out with regard to this case, there was nothing about a proposed severe weather fund, was there?
To my knowledge, no.
And likewise, there was nothing about changing the split for the AMA and related contracts from 70-30 to 85-15 as staff is proposing, right?
Not historically. I do reference in my testimony that further administrative notice concerning changes to the AMA and storage contract splits may require administrative notice.
But my question to you was, there was no notice with regard to this case concerning that, right?
Yes, not in this case.
And you haven't presented any customer surveys or customer data indicating that customers want a severe weather fund to be established, right?
Mr. Alvidrez, I think that customers would like to have any sort of potential future liability reduced. As I point out in my testimony, $12.5 million reduction to $100 million liability. Historically speaking, that does provide some ratepayer benefits. I think they probably would say this is a good thing.
Okay, please answer my question. You haven't done any survey or gathered any data that suggests that customers want a severe weather fund, have you?
No.
And staff's proposal for the severe weather fund was presented in this case after the intervention deadline, right?
Could you remind me of when the intervention deadline was, Mr. Alvidrez?
I believe it was back in April of this year.
So given that this testimony was filed on the 26th of September, the answer is yes, it was presented after the intervention deadline.
Okay, and there's never been another merger or acquisition case in New Mexico where a severe weather fund has been imposed as a condition for approval, right?
I wouldn't consider it imposed, but there has not been any severe weather fund that's been approved of in the state of New Mexico. No.
Work with just a little bit. Could you state that answer again?
Yes, to my knowledge, there's not been another severe weather fund that has been approved of in the state of New Mexico. No.
Well, you seem to take issue with my characterization of having this, condition that's imposed, but isn't that in fact what you're proposing in this case?
I think, overall, if you read my testimony overall, one of the first statements I make is that subject to approval of this of the case overall, this is a condition that we would like to see applied. So there are things that staff first and foremost wants to see the BCP applicants commit to, as well as other conditions be imposed in this particular case prior to the severe weather fund itself being approved of.
But no other parties have proposed a severe weather fund as a condition in this case. Isn't that correct?
That is correct. It's our idea.
Can I have you go to page 6, beginning at line 9 of your testimony?
Yes.
You
yes. There? Yes, I am.
There you're pose the question, could NMGC also benefit from this fund? Do you see that?
Mm-hmm. I do, yes.
And then on lines 15 through 17 of your answer, NMGC incurred approximately $35,000 in consultant fees, $131,540.92 in legal expenses, $188,633 in financing costs, and over $5.7 million in interest charges, correct?
That is correct.
Isn't it true that customers paid the bulk of the financing costs and interest charges that you referenced there?
They did pay the bulk of them, but not all of them.
And isn't it also true that NMGC will incur legal and other costs in connection with your proposed working group and whatever follow-up proceeding is necessary to develop the specifics of the administration of the Severe Weather Fund?
It depends on whether or not they're using internal or external legal counsel, I believe. So I'm not sure. I can't speak to that. It's a hypothetical.
Well, isn't it true? It's still a cost either way, whether they use internal or external counsel.
Mr. Alvidrez, you're breaking up a little bit.
I said, isn't it true that it's a cost to them either way, whether they use internal or external counsel?
Oh, hold on, Mr. Alvidrez, just breaking up some. Sorry.
Can others hear me all right?
I'm gonna have to ask.
Yes, sir.
Mr. Alvidrez, are you still there? I'm sorry, it looks like my internet connection's a bit unstable. Where's it, Mr. Alvidrez is?
Nope, we can hear him, Dr. Zadalis.
Are you able to hear me, Dr. Zadalis?
Yes, I think it's a little bit better now.
Okay.
Could you repeat that? I'm sorry.
I will repeat my question to you. I said, isn't it true that regardless of whether the legal costs are internal or external, gas companies still incurs those costs?
They do incur those costs.
And also, an element of your proposal is that the asset management agreements and the storage optimization contracts will be changed. The revenues will be changed from a 70-30 split to an 85-15 split, right?
That's staff's proposal, yes.
And that will cost New Mexico Gas many millions of dollars over the years, will it not?
Of potential hypothetical revenue.
What do you mean potential hypothetical revenue?
In the event that revenue is actually realized, if you do change the split and business development activities, the AMA, the storage contracts are still generating that revenue, then there would be additional. Sorry.
Breaking.
Can you guys hear me?
Yes. Can you,
Okay,
in
so-
the event revenue is realized and you change the split,
In the event that the revenue is realized and you change the split, there would be, under staff's proposal, additional monies that flow to the severe weather fund, and that would not actually go into the pockets of New Mexico Gas Company.
Well, you're proposing to reduce New Mexico Gas Company's share of those revenues, are you not?
We are, yes, for the benefit of customers.
And that can run into the millions of dollars, right?
Potentially,
Sure.
depends on how well the contracts are doing.
And staff doesn't stop there, right? Staff wants another $100 million or whatever the acquisition premium is going to be placed in a regulatory liability for distribution to customers later on, right?
Objection to the form of the question. Mr. Alvidrez is testifying.
I'm asking
Mr.
about,
Alvidrez?
yeah, I'm asking about what staff is asking in this case. Let me
Mr.
ask.
Alvidrez,
Hang
You-
on. Well, it's actually a compound question. You asked two questions.
All right. I'll restate. Do you understand that staff is also proposing that a regulatory liability be set up, alternatively in $100 million amount or whatever the acquisition premium is?
Objection beyond the scope of Dr. Zidal's testimony.
I'm asking if he knows.
Yeah, I think the witness can answer the question if he knows. The objection is overruled. Go ahead, Dr. Zizales. If you know, answer the question.
although I did not testify to the acquisition premium, I believe that is what the testimony, generally speaking, what the testimony of Dr. Larry Blank advocates.
So what is the regulatory basis that staff believes would authorize the commission to require NMGC to establish the severe weather fund to pay for gas sold to customers at NMGC's sole expense?
Our position is that it provides a long-term benefit in terms of a regulatory basis. The commission has discretion over formulating various regulatory accounting orders. If it sees fit, this would likely be included in that to have the 12.5 million that we've advocated go into the severe weather fund be set aside specifically for the long-term benefit of customers. So the commission has discretion to do this, in our opinion.
But again, you're also proposing to require this change in the AMA split, right?
We are asking in the testimony for a commitment for that to be changed.
And you indicate that the severe weather fund is, quote, not a legislative prerequisite for approval of this transaction at page 13, lines 6, lines 7 and 8 of your testimony, correct?
I do say that, yes.
And under staff's proposal, the severe weather fund would be initially funded by redirecting all the $10 million in proposed economic development funding offered in this case, along with the $2.5 million in charitable contributions, which are included as part of the regulatory commitments in this case.
Is that a question, Mr. Alvidrez?
Yes, that's what you're proposing, right?
Yes, that is what we are proposing, yes.
And you would acknowledge that such benefits as economic development by utilities have been features in prior acquisition cases in New Mexico, right?
I can acknowledge they have been, yes.
And is it staff's position that all the monetary regulatory commitments in a utility acquisition case must go to customers?
I can't speak for what staff's advocacy moving forward will be, Mr. Alvidrez. However, within the context of this case, staff is advocating to maximize, in its view, the long-term benefits to customers by establishing the severe weather fund.
And that would include all or part of the rate credits in this case, right?
Staff, as I point out in my testimony, I use the word it could use rate credits to more fully fund the severe weather fund. However, my testimony advocates specifically for the 12.5 million. That's how I've accounted for the establishment of the severe weather fund, to have the $12.5 million worth of the non-ratepayer benefits be redirected to the fund for the long-term benefit of NMGC customers.
So staff is not proposing as a condition for approval of the transaction in this case that all of the rate credit monies be deposited in this fund.
As I
Correct?
point out in my testimony, it is an option if the commission is amenable to this particular proposal. However, what staff is asking for is that the 12.5 million go into the fund.
So where would this fund reside?
Again, Mr. Alvidrez, that's going to depend on the regulatory accounting treatment for this. I think that proposals for where exactly it would reside, I presume you mean in terms of on the balance sheet of NMGC, that can be determined within the working group. That can be one of the issues.
And you also leave open the question of what conditions would satisfy the requirement for the release of funds, correct?
We do. We want to hear from the stakeholders.
And the stakeholders under your working group are NMGC staff and the Department of Justice, New Mexico Department of Justice, right?
Among others, as I pointed out in my testimony, yes, those are the three key ones.
And you propose that this working group have its first meeting 5 business days after approval, if the transaction is approved. Is that correct?
As soon as possible, that would be good. Yes. So if I said 5 days, I believe I did. That's good.
So that would even be before the transaction closed.
Yes, to try to get some of the high level details associated with this fund fleshed out. I think getting a jump start on things that would be good.
So in footnote 8 on page 10, you posit that if economic development grants or transfers were a central issue in utility acquisition cases, that you would expect the New Mexico Economic Development Department to participate in commission proceedings involving utility acquisitions, correct?
I do say that, yes.
To participate in proceedings.
In commission proceedings involving utility acquisitions.
I do say that, yes.
And you agree that it takes time and resources to participate in complicated utility acquisition cases, do you not?
It does.
And like the NMPRC, other state agencies have constrained resources.
Potentially, yes.
And likewise, charitable organizations would have constrained resources in many cases.
Potentially, yes.
Are you aware that economic development groups such as the Greater Albuquerque Chamber of Commerce and the Albuquerque Hispanic Chamber of Commerce provided live public comment with respect to this transaction?
I believe I saw something in the Albuquerque Journal about this, but in terms of live public comment, I'm not sure.
But that is another way of the public to make their desires known to the commission, correct?
Informally, however, what's binding is the formal submissions here.
Right, I agree.
You got 1 minute, sir.
So are you aware that since filing the joint application, the joint applicants have proposed an additional $5 million for job training and apprenticeship programs at high schools and colleges in New Mexico?
I believe so. Quite a bit has changed, yes.
And is staff proposing that this additional $5 million be used to fund the severe weather fund?
Given that this testimony was filed prior to the newly updated commitments that the BCP applicants have made, I can't speak to that. That could be something to be determined, but staff's position is 12.5 from the revised application, the initial revised application be moved over to the severe weather fund.
All right, I think that's my time. Thank you very much, Dr. Zadalis.
Thank you, Mr. Alvidrez.
Thank you, Mr. Alvidrez. I believe the other party that reserved cross-examination time for Dr. Zadalis is FEA. Mr. Freeman.
Yes, thank you. Hi, Dr. Zadalis. I'm Giovanni Freeman, and I'm representing the federal executive agencies. So I had a couple questions concerning your written testimony. And where I wanted to start was on page 3 of your written testimony. In
I'm there, Mr.
describing, oh, thanks. In lines 3 to 9, for the question and answer, and describing the purpose of the testimony.
I'm sorry, Mr. Solani, speak up a little bit on lines 3 to 9.
Yeah, sorry. On lines 3 to 9, in describing the purpose of your testimony, is it correct that you are articulating the staff proposal for the creation of a severe weather fund that will provide long-term benefits to gas company customers?
Yes, I do state that.
And in developing the proposal, was there any analysis done regarding if all gas company customers would benefit from the severe weather fund?
So our view is that the severe weather fund and the impetus for the severe weather fund, which is extraordinary gas price hikes as a result of severe weather events, those are issues that affect New Mexico gas sales customers. I do know you represent the transportation customers, so this is very much a New Mexico gas sales customer centric proposal that we've created.
Thank you for that. And I understand that. So, but I guess the question was, when developing the proposal, was that taken into consideration that this benefit wouldn't benefit all gas company customers?
We were solely focused on mitigating severe weather impacts on gas prices, so the answer would be no.
And I guess, do you believe that all gas company customers should receive benefits from this transaction if approved?
I think to a certain extent, all customers should receive benefits, whether or not those benefits are equitably distributed. I guess there's various methodologies to do that. I think you and your clients have discussed that at length in this hearing. But we do believe that there should be benefits that accrue to all customers. However, again, Mr. Freeman, we're focused, specifically on addressing this severe weather issue.
Sure. Can I now get you down to page 10 of your testimony?
Yes, I'm there.
And so on page 10, you explain that not all New Mexicans are gas company customers, and I believe that's your rationale that the economic development and charitable contributions that the joint applicants are considering benefits should be replaced by the severe weather fund because that severe weather fund can be captured at the ratepayer level. Is that correct?
Yes, I believe so.
And a part of that also is that it seems that your analysis takes into consideration the first element of the 6-part test. It shows that the needs be directly captured at the ratepayer level. Is that correct?
Yes, a strict reading of that first factor uses the term, I think, either customers or ratepayers. So we were quite strictly reading that in our analysis in this case. So yes.
And so I guess going along with that same reasoning, would it hold true that monetary inducements that result from the transaction should be shared as widely as possible to all gas company customers?
I think
reasoning.
Could you repeat the second part of that question? Sorry, Mr. Freeman.
The second part was that, well, I'll just start over. And so I was trying to ask, in terms of that reasoning that you put forth in terms of the economic development and charitable contributions, not, potentially being captured at the ratepayer level. The question is, should that same reasoning hold true, that, the monetary inducements that result from this transaction should be shared as widely as possible to gas company customers?
We do believe that they should be widely shared. Again, our rationale for this particular fund is looking at the risk associated with severe weather and its impacts on natural gas prices. So certain customers have that exposure, other customers do not.
And in both your testimony and in your testimony here today, is it accurate that you've admitted that there's a bit of, I guess, ambiguity around the commission's authority to, I guess, sort of fully construct what this severe weather fund will look like? And so in your testimony, you do note that if it's necessary, that a new case docket just to look at the severe weather fund should be open. Is that correct?
I do testify that there might be limited authority within this particular docket to fully flesh out the details of the severe weather fund, and that a new case docket might be needed in order to go through all of the various details. Again, as I mentioned to Mr. Alvidrez earlier, we're looking to have some of the non-ratepayer benefits be earmarked for the severe weather fund. That's what we're asking for in this particular case.
Okay. And in terms of the proposed working group, I know listed there is the gas company staff and NMDOJ. What others would you think would join this working group?
Mr. Freeman, obviously FEA, to the extent that they might have some skin in the game as concerns severe weather and its impacts on New Mexico gas, on New Mexico gas prices. They could be a part. We're not necessarily prohibiting anybody prospectively from being a stakeholder, but I would presume the various parties to this particular case could have an interest in working through the details of the severe weather fund, FEA included.
Do you think there's other parties currently now that may be interested in either being a part of the working group or this proposal, where if there was a separate proceeding, they would have the advantage of being able to, intervene and create a full record in that separate proceeding?
I would hope so. I would hope they would take the opportunity.
Can you tell me some of the advantages, if there are any, for the commission having a separate proceeding where those interested interveners could participate and then possibly be a part of the working group?
I think fundamentally it would reduce the workload on the current hearing examiners in this particular case. And it would probably reduce the time that this particular case would take to completion, both recommended decision as well as final order. I believe in my testimony, I do allow for a multi-month time period over which we'd hope to sort out the fundamental details of the severe weather fund and provide a proposal to the commission.
I think that's all I have for you, Dr. Gonzalez. Thanks so much for answering my questions.
Thank you, Mr. Freeman.
Thank you, Mr. Freeman. I believe that's all of the cross-examination time that's been reserved for Dr. Zadalis. Sir, I have a few questions for you.
Yes, ma'am.
And I'd like to start with page 3 of your testimony. And I think you've already been asked about this statement, but I have a different question. And the question posed at line 3 is, what is the purpose of your direct testimony in this case? And you begin on line 4. The directive that I am following in this case is to advocate on behalf of the public interest by ensuring that, should this acquisition be approved, new, long-term benefits will accrue to the New Mexico Gas Company ratepayers. That's your testimony, sir?
That's what I try to advocate in this testimony, yes.
Would you define for me what your concept in your testimony is of long-term benefits?
So the concept is a source of monetary benefit that customers could avail themselves of on a go-forward basis. So really and truly beyond 1 year out, which is, I believe, the duration of the rate credits in this particular case. So it's something that will be held in perpetuity, essentially, from which customers might be able to derive benefits given, in our estimation, a severe weather event that causes significant gas price spikes.
So if I heard you correctly, to you, a long-term benefit is longer than 1 year, up to and including forever.
I believe in my testimony, Madam Hearing Examiner, I do discuss long-term benefits a bit more. I say, we would like to see some benefits that match essentially the holding period that an acquirer has for its acquired company. So in this particular case, it could be 10 years. However, with the severe weather fund, that is something that we see just remaining in play for as long as the New Mexico Gas Company is around. So there's two elements there, if I may say. One is to develop a benefit that matches the duration of the prospective holding period. And then given the nature of our proposed severe weather fund, that would just so happen to continue beyond the 10 years that BCP is committed to holding a New Mexico Gas Company for at a minimum, or Saturn Holdco.
Hey, I thought I understood what you said, but then your last sentence, I think you just qualified it. I thought I heard you say the 10-year holding period, or as long as gas company is around. But then didn't you just qualify it by adding Saturn Utility Holdco?
If I may, I'll rephrase if that's possible, Madam Hearing Examiner. Again, how we envision a very strict definition of long-term in the context of an acquisition case is a benefit that matches the duration of the proposed holding period. Our severe weather fund, because we believe that should exist in perpetuity, it both matches the duration of the joint applicants, Saturn Holdco, BCP applicants, proposed holding time of New Mexico Gas Company, and then some. So I guess there could be, other propositions that only last for 10 years, but ours, given the nature of the problem we're trying to address here, just so happens to both go through the holding period and then continue on beyond that.
But as you have quantified the benefit, the monetary benefit to the program that staff would like to see arise from this case is the $12.5 million contribution to be the initial monetary contribution to the fund, correct?
To be the initial, yes, to be the initial monetary contribution, yes.
And Dr. Zadalis, do you understand that with reference to your testimony on page 5, you are answering the question posed at line 4, why is staff requesting that the severe weather fund be authorized for creation as a condition to joint applicants acquisition of New Mexico Gas Company? And your answer begins on line 13 on page 4, continues on page 5. And what I'd like to ask about begins on line 4, and where you're talking about the commitments and my question, sir, is you testified joint applicants have made 88 commitments at lines 5 and 6. That's your testimony?
I believe at the time those were the commitments attached to their, I think it was their GDP, their amended GDP.
And you understand that they've made additional commitments in their rebuttal testimony and during this hearing, don't you?
I do, yes.
Does that change your testimony in any way?
In terms of the direct monetary benefits for New Mexico Gas customers, in terms of the rate credits, that remains the same. I know there are some new low-income programs that have been developed. Obviously, those will target a subset of the overall ratepayers. That's a positive thing in staff's opinion. But in terms of the more traditional items, it was really, we were just looking at the rate credits in this particular testimony.
Okay.
But that has changed, Your Honor. I only have the ability to file direct testimony, so.
Is that because of limited resources on staff's behalf that you didn't file rebuttal?
Well, it would have been sort of rebuttal, I believe, to their rebuttal
Yes.
testimony, which I don't believe that staff normally does. That was not recommended to me by our attorneys. So and the subsequent bench requests that you've received additional commitments to, those have obviously taken place during the hearing, and I don't believe there's been any time for further testimony, written testimony.
Sir, in page 7 of your testimony, I think it's that testimony you were alluding to earlier that further talks about and quantifies long-term customer benefits. Is that right?
Yes,
Dr.
I do
Zadalis?
discuss. Yes, yes.
And the question posed at line 22 on page 6, does staff believe that long-term ratepayer benefits need to be considered separate from, but alongside their short-term counterparts? And your answer begins on page 7 at line 1, yes. And you continue. I'd like to look at line 17, where you say, indeed, examples of possible long-term benefits exist in the record of past acquisition in MPRC acquisition cases. That's your testimony, correct, sir?
Yes, I do state that.
Are you referring to any specific NMPRC acquisition cases?
So Your Honor, the reference that I make here is a reference to a reference that was made by a previous hearing examiner in my referenced certification of stipulation dated 1 November 2021 for, I believe, the P&M Avangrid case. And those are all examples that the hearing examiner at that particular citation cited back to in other acquisition cases.
Okay.
So I did
You
not,
had just, go ahead, sir.
No, I'm finished. Sorry, Your Honor.
Oh, no, you had just had cases plural, and I saw your footnote was to only one case. So I'm just wondering if you had any other acquisition cases in mind. And your answer is no, you're just citing to that case.
Citing to that case because that specific reference cites multiple other cases.
Would, in those examples of those possible long-term benefits that you include in your testimony, the very first one includes sound operational track record, extended bill credits, quality of service commitments, and reconstituting boards to be composed mainly of independent directors. That's your testimony, correct, sir?
I do state that, yes.
Couldn't at least 3 of the 4 be constituted or be considered to be maintaining the status quo?
If Your Honor would like to take argument with previous hearing examiners writing, then the answer is yes. I do see that. I can understand that.
Well, I'm just, Dr. Zadalis, I'm asking for your opinion.
Okay. I don't want to get cross with 2 hearing examiners. No, I can see that. A sound operational track record, obviously, that's something that any utility would expect to have, whether it be the acquired entity or the acquiring entity. Extended bill credits, obviously, those normally only take place in the context of an acquisition case. Quality of service commitments, quality should always be high. That can be viewed as status quo. Maintaining independent board, large number of independent board of directors, that's generally commonplace too.
Are you aware that, there are parties in the case that basically argue that maintaining the status quo isn't a sufficient legal or factual justification for the commission to approve this transaction?
I am aware of that, and I believe that based on the 6-factor test, there's a need for additional new benefits.
And I think they've already asked my questions on the components of the working group. I guess I wanted to know a little bit more about number 4 on page 9. You're answering the question from page 8, line 4. What specific authorizations is staff requesting as concerns the severe weather fund? Your answer begins on line 5, goes on to page 9, continues through line 2 of page 10. But I'd like to concentrate on line 6 on page 9. Item 4, require a commitment from the joint applicants and gas company to, as soon as possible, adjust pursuant to requisite administrative notice, the customer-NMGC split for benefits flowing from both asset management agreements, parenthetical AMA, and storage optimization contracts, parenthetical storage contracts, from 70/30 to 85/15 in favor of ratepayers. And you footnote And then you footnote that if that would need a new docket, then you'd be supportive. That's your testimony, sir?
Yes, however, I believe the footnote for that specific reference states this adjustment would represent an ancillary, though
That does.
important, further benefit to customers from
Sorry,
this
I'm
acquisition.
sorry, can you read the footnote again? I believe the
Yes.
that specific reference states,
That specific reference, footnote number 7, states this adjustment would represent an ancillary, though important, further benefit to customers from this acquisition.
Yes, that is the correct footnote. I apologize. What would so you're saying that well, let me back up. According to your testimony, there is currently in place asset management agreements, correct?
Yes.
What
Yes.
are they?
So New Mexico Gas is obviously, they're going to be much more conversant in this than me. However, my understanding of the asset management agreements as well as the storage contracts is that New Mexico Gas is essentially allowing some portion of whether it be their gas capacity or system to be utilized by third parties, and they're deriving income from the third parties' usage of those, whether it's physical infrastructure or of committed gas volumes that New Mexico Gas isn't necessarily using.
And with these particular contracts, the revenue from those contracts is split between gas company and its ratepayers?
Ultimately, yes.
And currently it is a 70-30 split?
Yes, 70% of the ultimate benefits monetary benefits go to customers, and the remaining 30% is held by NMGC.
And your recommendation is that the proportions change to an 85% benefit for customers and a 15% benefit for gas company. Is that correct?
Yes.
Okay. And then with the footnote, you're saying that the 15% shift increase to ratepayers would be could be construed as a further benefit to customers that could result from the acquisition case. Is that right?
Yes, conceptually, that is correct. In this specific case, we'd look for that incremental, so the 15% increment, basically, to go to fund the SWF. That's what we would propose in the working group. So those benefits would be the long-term benefits, or adding to the long-term benefits, I should say.
But would that be a quantifiable benefit right now in terms that? So let me back up. Gas company did not agree to your proposal, did it?
Not in rebuttal testimony.
Did they agree to it during the course of the hearing?
To my knowledge, no. But I don't know if they've fully disagreed with it. Or ruled it out, I should say, as a possibility.
You think you're being a bit optimistic?
I could be, Your Honor. I absolutely could be. Again, staff just, we want to try to address a problem that's happened in the past.
Okay. Well, based upon their testimony, if they haven't accepted it, yet, as you testify. If they had, could you have put a dollar amount on that as a ancillary benefit?
So in terms of funding the SWF, I believe that I calculated that incremental 15% there based off of how much money those various business development activities are currently bringing in could provide anywhere between $3 to $5 million a year. And if business development activity was to blossom, it could be more than that.
$3 to $5 million more per year?
That's what I wrote in my testimony. Yes, that's on page. Hold on. Yes, that's on page 14 of my testimony.
Okay.
I say 3 million in the text of the testimony, and then in the footnote, I point out that given recent upswing in AMA source and storage contract income, that number could be in excess of 3 to 5 million.
So your testimony at page 10, why is staff proposing the redirection of the joint applicants offered multi-year contribution to economic development and charities in a one-off immediate contribution to the severe weather fund? And then your testimony answering that is from line 7 to 17. Essentially, my understanding of your testimony is that you're trying to target New Mexico gas customers, not New Mexico, not all of the people and entities that are in New Mexico. Is that correct?
Yes, our testimony is based off of a strict reading of that first part of the 6-part test, heretofore referenced 6-part test.
And by virtue of how you see the money being potentially allocated from the severe weather fund, you're really only considering, as I believe as you answered Mr. Freeman, you're really only considering the sales customers, right?
Yes, given that the impetus for our proposal was Winter Storm Uri, which affected the sales customers as a result of them having to acquire swing gas.
So you're saying that it did not affect transportation customers?
I don't know the answer to that. If transportation customers are procuring gas third party, perhaps they incurred some sort of price impact. But in terms of the price impact of utilizing New Mexico Gas's system, I don't know if there was any impact. FEA would probably be able to elaborate on that more, Your Honor.
Oh, another question I had with regard to you're still answering that question on page 11, and to put it in context, at line 5 on page 11, you say staff believes the joint applicants can abide by this proposed distribution schedule because, and so then you're given the reasons why. And I'd like to focus on item C at line 13. These contributions combined represent an, arguably, de minimis financial sum relative to both the instant acquisitions equity usage portion, and then you say what that is, and the 6 billion of assets under BCP management joint applicants control. And then you go on to describe and then footnote it. That's your testimony, correct?
It is, yes.
Do you understand the structure of the transaction and and the funding with regard to the infrastructure funds in this case?
At a very high level, I would not say to the extent that some of the other witnesses do understand this. I think here, Your Honor, what I wanted to do was just provide a comparison to say, you know, if there was 12.5 million that needed to be dispersed right now, you know, BCP, given the fact that they've very generally said, oh, we'll get this money within 7 years. Well, you know, a year is within 7 years. That given the 6 billion of assets under management and that the 12.5 is a relatively small commitment relative to the amount of equity that they're using to purchase New Mexico, TECO Energy in this case, and subsequently New Mexico Gas Company, that they would be able to you know, fill the severe weather fund.
Would your answer change if the limit is 2 billion? If the money under BCP management is not available to gas company and it's a lesser amount, say $2 billion under the infrastructure funds?
I don't think I would be necessarily so concerned about that from the extent that, you know, if BCP has made a monetary commitment, I guess there's the presumption that they will be able to fulfill that monetary commitment. So they must have the belief, and perhaps this is something that, you know, we should ensure, but that the commission should ensure, but they must have the belief that they're capable of paying out what they're committed to paying out. So I wouldn't necessarily be as concerned with respect to a reduction in the figure associated with their assets under management.
Sir, page 12 of your testimony. Question posed at line 2, does staff believe an initial 12.5 million capitalization of the severe weather fund is sufficient to benefit and protect New Mexico gas customers in the event of future extraordinary swing gas price spikes relating to the extreme/severe weather? Your answer begins on line 5. Staff does not perceive a preliminary contribution of at least 12.5 million towards the severe weather fund to be Lilliputian. That's your testimony?
It is, yes. I wanted to use that word.
Can you define that word in the context of your testimony?
It means very small. So we do not view, even though the size of the Winter Storm Uri event was $100 million thereabouts, we do not view a contribution, an initial contribution of 12.5 million to be a very small sum relative to the scale of a potential problem.
And is it your understanding, Dr. Zadalis, that is it your understanding that during the severe weather event, also known as Uri, that there were hundreds of millions of dollars that that the commission heard about with regard to that event?
You know, I'm only familiar with New Mexico Gas Company's situation. I do know from research, utilities in Oklahoma, for instance, incurred billions of dollars worth of liabilities.
Thank you, Dr. Zadalis. That's all the questions I had for you. Mr. Lee,
Thank you,
is it
Madam Chair.
appropriate for our break? I think we'll take our 10-minute morning recess and then we can come back and see if there's any redirect for Dr. Zadalis. We'll come back at 11. Remember, the YouTube is on. Thank you.
Mr. Lee, are you with us?
Go by. Yes, sir.
I just wanted to mention that for some reason my real-time transcript has stopped as of 10:30.
My internet went out, but I believe it's been corrected now. And what I can do is send you a rough draft of the first 60 pages at lunchtime.
No worries, no stress. I don't think that'll be necessary. I just wanted to find out if it was my issue or another source of disruption. So thank you for letting me know.
You bet, Judge.
So mine is out too. Is there a way that it's gonna start again?
Repopulate. You're gonna
Uh-huh.
get a brand new file. If you sign in, you should be able to sign in again, and you'll pick up the rest of the transcript. Can you give that a try at this moment?
I just went back, but I don't have a password.
1, 2, 3, 4, 5, 6. Let me go back to the other file because I don't see and it should repopulate.
Okay. What's our session code, Mr. Lee?
I believe it's 1, 2, 3, 4, 5, 6. The session code is 53.
Do you want to give that over the YouTube?
It's proprietary. It's 534.
Okay, I'll look for it in the email, Mr. Lee. That's fine.
All right, let me.
We'll give it a try on my end.
Test. Oh, nuts. I got to restart one more time. Or no, I don't. Hold on. I don't know why my internet went out.
Yep, I've got it back.
Yeah, me too, Mr. Lee. I'm all set. Thank you.
All right, just a moment for me, please.
Oh, the joys of technology.
Yes, ma'am. Okay, I'm ready, Judge.
All right, let's go back on the record. We had our morning recess. Mr. Rossi, any redirect for your witness?
Yes, ma'am, I do.
Go ahead, sir.
Thank you. Dr. Zadalis, do you recall when you were talking with Tom Dome, he was asking you a little bit about Winter Storm Uri, and you mentioned that back in 2021, it cost $100 million. Do you recall that conversation?
I do, yes.
In your testimony on page 6, you cover a number of the costs that were also came out of that storm. Is that correct?
Yes, I do.
What are the drawbacks of how what are the drawbacks of handling severe winter storms or severe storms the way this has happened?
In this particular case, there was a separate case docket that was issued to recoup or I guess to litigate, whether or not New Mexico Gas Company could actually recover the monies that it used to purchase the swing gas during Winter Storm Uri. So that incurred consultant fees, legal expenses. In addition to that, specific to this particular event, Winter Storm Uri, I believe that New Mexico Gas Company had to take out a short-term loan. So there were financing costs, interest charges associated with that. I believe Mr. Shell earlier testified that some of those interest rate costs were passed along to customers, and there were other interest rate costs that New Mexico Gas Company had to eat.
So then who pays for each of these different costs? Is it shared? Was it split?
For these particular costs, some of them were paid by the customers, and with respect to the interest charges, some of them were paid by New Mexico Gas Company.
Can you compare that to your proposed severe weather fund? What are the benefits instead of doing of handling costs like that through the severe weather fund?
So I think the main benefit would probably revolve around the interest rate charges. Of course, this is contingent upon how the monies in the severe weather fund would be dispersed. But if in the event that in lieu of a loan, some of the monies, or in addition to a loan, some of the monies from the severe weather fund could actually be used to finance the swing gas purchase, then conceivably you could have a reduction in interest rate charges, all other things equal.
Hold on just a second, Mr. Rossi. Dr. Zadalson, I meant to ask you this and I didn't, but I mean, I know the specifics of the severe weather fund are open for potential setting or discussion by your work group. But did you have a plan, since you want that 12.5 out of this case? Did you, until the severe weather fund could be set up, did you have a plan for how gas company was going to treat that 12.5?
In terms of from a regulatory accounting perspective, or in the event of a winter storm taking place in the meantime?
In the event, well, I'm mainly thinking, did you recommend? I didn't see it. If you did, that it be put in some kind of interest bearing account, or you're just going to have them sit there with $12.5 million in the bank not doing anything?
So, Your Honor, we did discuss that internally. An interest-bearing account could be an option, whether or not that comes with some attendant, cost of capital, balance sheet issues. I guess that can be determined at a later instance. But probably more likely than not, having it in some sort of interest-bearing account, if that's the most cost-effective way to actually manage the money, then that's what we would want. And we did have those conversations internally. That was something we were thinking.
But it didn't make it to the testimony at this point.
It's not in this testimony, no.
Okay.
Because I wanted to leave a little bit of scope for the working group in the event that there would be a better proposal, one that was more cost effective from what staff was initially thinking, for the monies to go go towards what the better proposal would be in the event that there actually is a better proposal. But I think an interest-bearing account's probably the most effective way.
Okay, thank you.
Of holding the money.
Very well, sir. Thank you. Mr. Rossi?
Thank you, ma'am. Excuse me. When you were talking with Mr. Alvidrez, he was asking you about the costs of a case of the working group, for example. Would you see your working group as being an NMPRC case discussion similar to other ones that have happened in the past?
Potentially, it could be quite unique since this is a new fund that's being proposed. But if it was to be in a separate docket, then yes, it would be, in a new case, I guess.
And if it's a new case, would then anyone who's interested, similar to other cases, be able to intervene?
They would be able to intervene. My understanding is yes.
And we'd be happy to have their, or is it correct to say we'd be happy to have their input?
As I point out in my testimony, Mr. Rossi, staff believes that it is in the public interest in terms of formulating sound public policy if the various stakeholders to New Mexico Gas Company and to this prospective fund would actually participate in the working group. So yes.
Now, of course, there are costs with having another case opened. Do you agree with that?
Yes, those would obviously be subject to review in a future rate case.
Currently, the way we end up covering costs on a severe weather instance, for example, Uri, that case definitely had some costs, and you mentioned that on page 6 also, right?
I did, yes.
Okay. And right now, anytime there is a severe weather incident, we end up with a new case and new costs if it's handled in the same way as Uri. Do you agree with that?
I do, yes.
Okay. When you were talking with Mr. Alvidrez, he asked you about prior cases where were there any other types of cases where a severe weather fund or something like that was imposed? Do you recall that conversation?
I do, yes.
Are you aware of any other cases where something similar was proposed?
So I think in the testimony of Mr. Shell, I can't remember the exact page, but he says that in case 3056, so I believe that's the case from the late 1990s, in his rebuttal testimony for the revised application, he makes reference to case 3056, and he says that I'm paraphrasing here. I don't have the testimony immediately in front of me, but that previous staff attempts or previous commission attempts or contemplation of a severe weather like type fund have been passed over. I did go through subsequent to the filing of the rebuttal testimony that particular case, and if the severe weather like fund that Mr. Shell is referencing is the so-called price management fund from case 3056, my reading of both the recommended decision and the final order is that that particular fund was actually accepted by the commission.
So there is a similar fund back from the 1990s, or a similar approval from back in the 1990s.
Its operation is different, but the general problem-solving benefit, I guess, of the fund is the same. Yes, it seeks to reduce the impact of gas price spikes on customers.
Now, to be clear, case 3056 mentions PNM. We're talking today about the NM gas. Can you explain that?
My understanding is that at one point in time, they were one and the same.
So that case was when they were one company.
Yes.
Okay. If I could have one moment to go through my notes. When you were talking with the hearing examiner about the AMA and sharing, do you recall that conversation?
I do.
So currently the AMA shares 70% with customers, 30% with NM Gas. Is that your understanding of it?
It is.
And what's your proposal? Can you walk us through that quickly?
So the proposal is to change the split between the customer benefits and NMGC's benefits from 70-30 to 85-15, meaning that 85% of the AMA storage contract business development benefits flow to customers, and 15% continue to flow to New Mexico Gas Company. And staff's thinking, of course, this would be subject to debate and recommendation from the working group would be that that incremental 15%, the 15%, the 70 up to 85 would go towards funding on a prospective basis the severe weather fund.
So the purpose of this change is to get a permanent way to fund the SWF. Do you agree with that?
Yes, I do.
Okay. What happens if that change doesn't happen, if we didn't change the 70-30?
Then unless the working group makes a recommendation, this is all assuming that the acquisition is approved and that staff's SWF proposal is also approved. But if the working group does not make a determination that any of the 70% that customers currently get right now is going to go into the fund, then the fund would just be a lump sum amount, paid out within a staff specified time period.
So it wouldn't have a way of filling.
Not
Is that a
as
question, Mr.
So it
Rossi?
wouldn't have a way of,
I apologize, I sort of left out the modifier. There wouldn't be a way of filling the fund, is that correct?
not unless another recommendation was put forward. No.
Okay. If the fund was still funded through the AMA, but the percentages weren't changed, would that be a detriment or a benefit to NMGC versus to customers?
Obviously, if more money went to NMGC, they would say it's a benefit to them. Yeah, if less money went into the SWF, there would still be some accrual of long-term benefits under our proposal. So that's really a contingent answer there.
Okay. But if the fund is, or if the AMA split is changed from 85 or changed to 85-15, do you believe that's a benefit would you call that a benefit in this acquisition?
I would consider it to be generally speaking a benefit, and specifically a long-term benefit.
Thank you. I have no further questions for this witness.
Thank you. Mr. Dome, anything further?
Just a couple, Your Honor.
Go ahead.
Following up on Mr. Rossi's questions about the comparison on, well, starting with on the testimony on page 6, where you have the costs that the company incurred during Storm Uri. Then you were asked to did you do a comparison between those costs and the costs that would be incurred if the fund was created?
We did not.
What did he ask you?
Is that a question? You asked me whether or not we did a comparison
I don't
between.
understand. I don't understand what you blurted out at me.
I said we did not know.
Oh, okay.
Sorry.
That is anticipating my question. You did not do that cost comparison, correct?
We did not compare side by side the costs that were incurred as a result of the, I guess, the amortization, securitization, essentially, of the Winter Storm Uri costs versus how much participating in a working group might cost.
Don't you think that's critical to analyzing whether or not this is a viable, cost-efficient way to change operations of a gas utility and the things that are involved in your proposal?
We would love to see a proposal drafted by a New Mexico gas company concerning, what the costs might be, but anticipating, the cost of a securitization amortization case versus participating in a working group, which may only take a couple of sessions, that could be substantially less.
It may or it may not, correct?
It's up in the air right now.
I was listening to your answer to this question about whether you did this comparison, and these are the words I picked up in your answer. Would probably, contingent upon, could be, conceivably, to be determined unless a better proposal is reserved or received. So you really don't have any firm notion as to what or how this severe weather fund will be organized or funded, correct?
Objection as to form.
No, I'm going to overrule it. I think it's a fair question.
No, I think we do absolutely have a firm proposal. One is for the initial funding to be sponsored by redirection of the non-ratepayer benefits towards the severe weather fund. Two is to establish a working group that meets very quickly to flesh out the specific details necessary as regards the regulatory accounting treatment and the operation of this fund moving forward. And then third on that list is to adjust the AMA and storage contract splits to benefit the customers via the severe weather fund. And as I noted to the commission, as I noted to the hearing examiner, I've said in other questions, in response to other questions, the working group, we want to provide flexibility in there to make a recommendation, because we do believe that sound public policy is created whenever we have multiple stakeholders participating.
So the ultimate size of this fund is undetermined, correct?
And when you say ultimate, is that time contingent or?
This is a yes or no question. The ultimate size of this fund is undetermined in your mind, correct?
So if ultimate refers to the initial contribution, then that's 12.5 million.
No, that's not my question. My question is the ultimate size of the fund. I understand that the 12.5 initial funding is a number that you've thrown out there. The ultimate size of this fund is undetermined in your mind.
At some future point in time?
When
you say ultimate,
yes,
that means
the ultimate size, yes.
Conceivably, the way that we've structured it right now, it's that it could keep increasing, yes. But there's no cap. We've not come up with a cap or anything, if that's what you're asking about.
That's what I'm asking.
Okay,
and the speed with which it's funded has not been determined by staff in this case.
The speed with which it's funded is going to be contingent upon the flows from the AMA as well as the storage contracts. So, year over year, we've calculated, 3 to 5 million of benefit accruing.
Mr. Hold on. You're cutting each other's off, and I don't appreciate it. Let the witness finish answering the question. Let the attorney finish asking the question, please. You can finish your answer, Dr. Zadalis.
As long as Mr. Lee caught what I was saying at the end, I think that was the end of my answer.
You answered the speed with which it's funded is determined by the AMA as well as the storage contract. Year over year, we have calculated 3 to 5 million benefit accruing.
Yes. So, each year we would expect about 3 to 5 million based on the current operating business environment to be contributed into that fund.
Anything further, Mr. Domi?
No, I have nothing for the.
Very well. Mr. Alvidrez?
Yes, Your Honor.
Did you have anything further based on the redirect or my questions?
I do, just to
go ahead.
So, Dr. Zadalis, hearing examiner Hurst was asking you questions about how you define a long-term benefit. Do you recall those questions?
I do, yes.
And you would come up with something longer than a year that would foreseeably go in perpetuity, but at least as long as the commitment for a company to hold the utility, right, as long-term.
So what I testified to in my testimony is that the definition of long-term relates to matching the duration of the investment hold, which in this case would be 10 years. But because we've developed a proposal for the Severe Weather Fund, which just so happens to possibly exist in perpetuity, so long as New Mexico Gas Company is operating, then that specific definition of long-term gets extended beyond the duration of the holding period.
So under your definition of long-term, if the joint applicants propose to spread the rate credit out over 10 years, that would meet your definition of a long-term benefit. Same amount of money, but spread out over 10 years.
On a net present value basis, the answer to that would be no. If they were to extend rate credits, meaning have an initial offer of rate credits and then follow those on with subsequent rate credits, then the answer would be yes.
So that is kind of illustrates my point. I mean, some benefits are better for customers if they're paid out more immediately. Isn't that correct?
It can be, yes. I won't argue with the net present value, indicating that value is boosted in the here and now if you receive the money now.
And when you look at what the joint applicants have proposed, they're proposing that all the rate credits be paid out within a 12-month period, right?
I have seen that, yes. I think you're referring also to the updated 22.4 million, correct?
Either way, it's to be paid out over 1 year, right?
Yes.
And that contrasts with prior cases where the payout was over a longer period of time, prior acquisition cases involving NMGC where that payout was over a longer period of time, right?
Perhaps I'm not that familiar with some of these prior New Mexico Gas Company acquisition cases.
Okay, you talked about the $3 to $5 million that would flow into the severe weather fund as a result of the change of the revenue split on the AMA contracts, right?
Yes.
And that 3.3 to $5 million would come out of NMGC's revenues that they're currently receiving, correct?
It would, yes.
Those are my questions. Thank you very much, Your Honor. And Dr.
Thank you,
Zavala.
Mr. Alvidrez. Dr. Zazales. Thank you, sir. Appreciate your time. You are excused.
Thank you, Your Honor.
I believe going back into the order of examination of witnesses, Ms. Beatles, you have another witness.
Yes, thank you, hearing examiner Hurst. Is he admitted into the?
He is. Mr. Freeman?
Madam Mayor Examiner, I'm sorry, I was a little too slow before you dismissed the witness.
Oh,
but
I apologize.
But it's actually fine. I'm okay.
I
It's fine.
apologize. I had my my counter phone here right over your column.
It's
in
okay.
my-
I think we've gotten enough. But thank you.
Okay, I apologize. All right, we have Mr. Kinney, Ms. Beatles.
Thank you. Western Resource Advocates calls Michael Kenny.
Thank you. Mr. Lee, would you please swear the witness?
Mr. Kenny, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Good morning.
Morning.
Go ahead, Ms. Beatles.
Thank you. For the record, could you please state your name and employer?
My name is Michael Kenny, and I'm employed by Western Resource Advocates.
And what is your position with Western Resource Advocates?
I am the Building Decarbonization Manager.
Do you have before you a copy of your revised direct testimony filed on September 26, 2025 that we have labeled as WRA Exhibit 1?
Yes.
And do you have any changes or corrections to WRA Exhibit 1?
No.
If you were to answer today the same questions in that exhibit, would your answers be the same?
Yes.
And are they true and correct to the best of your knowledge and belief?
Yes.
I move the admission of WRA Exhibit 1.
Mr. Kenny, were the attachments to your exhibit prepared by you or under your direction and control?
Yes.
Is there any objection to what has been identified as WRA Exhibit 1, the revised direct testimony of Mr. Kenny as affirmed by him here today? Mr. Kenny, what is the attachment to your exhibit MLK 13?
Are you referring to the spreadsheet?
I am not. Attachment exhibit MLK 13 as I see. Well, there's I believe is entitled The Future of Heat.
Yes, that was a study paper that I cited in my testimony that I attached as Exhibit 13.
And did you discuss it in your testimony?
Yes.
Okay. Pursuant to my previous ruling with regard to exhibits, I believe under the rules of evidence that expert witnesses can discuss external documents, whether they be some type of learned treatise, pamphlet, etc., that the expert witness testifies to and about and utilizes as the basis of their opinion. I do not believe that extends to attaching the whole paper as an exhibit to testimony, unless the witness is the author of that paper. And some claim
May I?
under the evidentiary rules could be made. And just to, well, I won't go ahead and yes, therefore, my ruling is that the attachment should be stricken from WRA Exhibit 1. Ms. Beatles?
Yes, I looked into the rules of evidence briefly, and first, as you know, Commission Rule 1.2.2.35 states that the presiding officer shall consider the New Mexico rules of evidence, but is not bound by those rules. And Rule 703 does allow admission of such articles if it helps, allows admission of evidence that may otherwise be inadmissible if it helps evaluate the expert's opinion. We believe this article does serve that purpose. Mr. Kenny, and also, let me back up for a minute. Rule 705 requires experts to disclose facts or data underlying their opinion. So, I mean, I believe that this article was attached in order to help explain his reference and discussion in his testimony of thermal energy networks. It's part of the basis of his understanding and knowledge about the networks. We believe there's no prejudicial effect. However, if ultimately you rule that it should not be included, that is not anything I'm going to fight because we were just trying to be helpful by offering it as an attachment.
I appreciate the sentiment, Ms. Beatles, in trying to assist the tribunal. And again, the ruling is not that he can't testify, which he has indicated he does testify about this article. So again, I'm not saying I believe that he can testify as to sources of that help inform his or craft his opinion. And he said he has done that. What the difficulty I have with all of these attachments from articles that parties want to place in the record is that I believe that they confuse potentially the record with other facts and statements in these papers. And I don't believe that's helpful to the tribunal. I believe that potentially it sets up a confusing record and potentially more work for the parties and the commission, that parties will try to rely on things that weren't in the testimony but were in articles and argue that that was evidence and not the witness's statements. Additionally, I believe that potentially you're setting up a violation of the right to for confrontation. That if parts of articles are being argued as being evidence, and the authors of those documents are not in the hearing subject to being questioned upon their opinion, then I think potentially again, I think there might be some kind of due process violation allegation. So while I appreciate again the sentiment that we want to be inclusive and let you know, I think by the witness's own testimony, they are testifying in their expert opinion that they relied on this article, so that the parties know and will have had an opportunity to go to that document and help them formulate potentially any cross-examination they might use. But to actually attach an article that could be viewed as an acceptance by the commission in totality as evidence in the record for everything it stands for, I believe is a prejudice that I'm not, in potential harm, I'm not willing to accept on behalf of the commission. Therefore, with that explanation, I'm going to maintain my ruling and deny exhibit MK13 and ask that you strike it as an exhibit to Mr. Kenny's testimony. Go ahead.
I have a compliance question. So
Yes, ma'am.
would that mean it's acceptable to cite to the article in the footnote, but not attach it as an exhibit?
Yes, ma'am. And if I have not been clear in the record, let me attempt to clarify what how I see the most efficient way to do this. Whether it's a deposition, whether it's pages from a deposition, whether it's an article, a treatise, the rulings that I have made so far in this case I'm not saying that the expert witness's testimony utilizing those out of court documents, those hearsay documents, I'm not saying the witness's testimony on them isn't admissible, or reference to the document is not. I'm not saying that's not admissible. I'm saying that attaching the document as an exhibit is not admissible. Therefore, in this instance, I'm asking you to remove the exhibit that has been denied admittance from the testimony, to put that copy back in the Dropbox without the denied exhibit. And if you want, you can indicate through red strike through and a footnote or a note on the exhibit that says MLK exhibit 13 is testified to in the witness's testimony, but was not admitted as an attachment to his testimony. So, and I guess if you have anywhere in the testimony that says see attached exhibit 13, then you probably want a red strike through the C attached, because it's not.
I didn't mean to belabor the matter, but that was very helpful. And my legal assistant is listening closely.
And I appreciate that, because actually, Ms. Beatles, hearing examiner Schaefer and I have had that discussion about whether it's clear to the parties, especially after hearing from Mr. Yar this morning, where it appears, based on a review of the testimony from this morning, the way he characterized my ruling might be interpreted that I was denying testimony contained in the deposition. That's not true. I'm only denying, in your instance and in the deposition document instances, that they can't be attached as exhibits. And then additionally, with regard to some of the other rulings that I've made on any E attachments. So if we're clear, excellent. And we've sworn the witness. Any objection to what's been identified as WRA Exhibit 1, excised attachment 13? Hearing none, WRA.
Sorry, this is Brian Haberly.
Mr. Haverly.
I think your ruling would also apply to Exhibit MK4, which is a draft report. That was prepared by GTI Energy, and it has nothing to do with the acquisition itself. It's a draft report that was produced in discovery. Hearing your ruling here, I think that would also be inappropriate to put into evidence as an exhibit. I don't have any objection, obviously, to Mr. Kinney relying on a draft report to the extent he wants to in his testimony, but I think it's not something that he wrote. And I think that hearing your discussion just now, I think that would also confuse the record, cause issues in the record, especially since it's a draft. So I would object to MK4 as well and request that be excised from his testimony as well.
And according to his exhibit list, MK-4 is a CCAE interrogatory 1-17 with joint applicants exhibit CCAE 1-17B.
Oh, I'm sorry, Madam Hearing Examiner. I was going off of what was produced in when they filed it. An MK4 to his testimony was a GTI Energy report. So if I have the wrong one, I apologize.
Ms. Beatles, can you help us?
I understand that WRA Exhibit MK-4 is New Mexico Gas Company's draft hydrogen testing report.
Okay, wait, what happened? Do I have the wrong exhibit list?
Well, Madam Hearing Examiner, if it might help, I think MK4 is just attached to his testimony. So it would be his testimony exhibit and then one of the attachments to his testimony.
So, and
Hang
Madam
on.
Hearing Examiner, I believe that report was provided by Gas Company in response to a CCAE interrogatory.
Okay, I get it. Hang on. Do-do-do. Where do you, okay, there's two. Like, how long is that? How long is two? Oh, I don't see a number, Miss Beatles.
Are you scrolling through his?
Yeah, I'm scrolling through his testimony and it looks like I'm on like page 46 of 112. And it says joint applicants response to CCAE's first set. But I don't see that as, I don't see that identified as MLK-4.
So, Madam Hearing Examiner, this is Brian Haverly. If I could maybe help, what got loaded up to the Dropbox looks like that there was a little bit of an overlap in the designations of at the top. I have it as page 140 of the PDF, and it starts with at the very top right-hand corner, it says JA Exhibit CCAE 1-17B, page 1 of 41.
You're talking about the response.
What I have from the Dropbox, Madam Hearing Examiner, is just the report as MK4, and it's page 140 of 326.
Yes, I see that as PDF page 140. And there's an overwrite, as Mr. Haverly said, that it was our testimony exhibit MK-4, but it was overwritten by, or it overwrote our label of his testimony in general, which is WRA hearing exhibit 1.
Yeah, okay. Anyway, okay, so this is a report offered by as part of an interrogatory response. There's been an objection to inclusion. basically we're trying to use the same. I understand you, Mr. Haverly. You're trying to use the inclusion of the separate document as your argument for why the interrogatory response shouldn't be accepted?
The derogatory response, I don't have an objection to that we do have a draft. I have a objection to the fact that we're putting a draft report that was generated for a different case into the record as an exhibit, as if it has met all the evidentiary requirements to be an exhibit in this case. Again, it is a draft prepared by other people and has a whole lot of stuff in here about hydrogen and testing hydrogen, which is not something that the joint applicants are using this draft for or this report for in this case. So I think that it's improper to have a draft by people, which is GTI Energy, who are not in this case, and who are opining on things in draft format for propositions that the joint applicants aren't proposing in this case.
Even though it's gas company's draft report?
It was generated by gas company, it is true, or generated for the benefit of gas company. That is true, but it is a draft. It is not the final report.
And you say it was offered in another case?
It arises out of another case, Madam Hearing Examiner. If you recall I believe the 21 rate case, gas company committed to studying hydrogen effects in appliances, and this is a draft of that. The study has not been finalized.
Ms. Beatles, your response?
Yes, I do believe there's a difference between a business or industry article that a expert witness attaches to his or her testimony to support a statement, as opposed to this, which is a study that was prepared on behalf of one of the applicants and presumably at their direction, and it's clearly labeled as a draft. So I think that signals to any reader of the record that this is not the final report, and there may be different or refined, findings and conclusions ultimately, but we are not offering it to support any findings or conclusions out of that study. We're just offering it to support our statements about the activities of one of the applicants to study potential hydrogen blending.
Does your witness testify about this?
Yes, on page 15.
Okay. Anything further, Mr. Haverly?
No, we stipulate that he testifies about it, but again, it's a draft, and that's my position that that's an appropriate exhibit. But Madam Hearing Examiner, I rest on that.
Okay. All right. I'll think about it. I'll look at it over lunch. Any other objection? I will take the admission of WRA Exhibit 1, attachment MLK4 under advisement. Otherwise, the WRA minus MK13 is admitted. Ms. Beatles?
I pass the witness for cross-examination. Thank you.
Very well. Mr. Haverly, I believe that gas company reserve 15 minutes for Mr. Kenny.
Yes, ma'am. Thank you. Good morning, Mr. Kenny. How are you doing?
Good morning. I'm doing all right. I think I caught the same cold that's going around the YouTube channel as everybody else, but
Oh, I'm sorry to hear that, sir. I'll try to be quick. Mr. Kenny, would you please go to page 4 of your testimony, starting at line 15?
okay.
And the question there is, which areas of approval do you focus on in your testimony? Next line down, you have an answer. I do not focus on a specific item for approval, period. Rather, my testimony is concerned with the overall risk this acquisition represents for ratepayers as it pertains to decarbonization, capital investments, and strategies. Did I read that correctly, sir? That is your testimony?
Yes.
All right. And then would you please go to 28, sir? And let me know when you get there, please.
Okay. I'm there.
Okay. Line 2, going through line 5, the question you posed to yourself, based on the policy risks you discussed above, what is your recommendation regarding the proposed acquisition? Question mark. Next line answer. I recommend the commission deny the proposed acquisition unless NMGC and BCP agree to significantly different decarbonization investment strategies. Is that your testimony, sir?
Yes.
Okay, so it's my understanding is you are focused in your testimony on decarbonization. Is that correct?
That was the lens for my testimony. Yes.
Thank you, sir. Would you please go to page 10 of your direct testimony?
Okay.
Okay. On line 3, you have the following question. Please describe New Mexico's current clean energy policies. Did I read that question correctly?
Yes.
Okay. Next line 4, answer. New Mexico has goals to achieve statewide GHG emissions reductions of at least 45% by 2030 compared to 2005 levels. You see that?
Yes.
And that's your testimony, sir?
Yes.
And
Did
there,
you say 45%, counsel?
I'm sorry, would you repeat that, Mr. Lee?
You said, the quote, did it have 45%?
45, yes, sir.
Thank you, sir. Go ahead.
All right. And for that proposition, Mr. Kinney, you cite to the New Mexico Executive Order 2019-003 entitled Executive Order on Addressing Climate Change and Energy Waste Prevention. Is that correct?
Yes.
And Mr. Kenny, you're aware that this executive order does not contain any language requiring the PRC to take any action in relation to gas utilities. Is that correct?
That is my understanding. It does not specify specific industries within the executive order.
And you're
Or
aware that, oh, go ahead, please.
Or I don't recall seeing the public regulation commissioned by name.
Are you aware that in section 4 of that order, at the end, there's a disclaimer?
Yes.
And that disclaimer says that the executive order is not intended to mandate the undertaking of any particular action. Are you aware of that, sir?
Yes.
Okay, thank you. So going back to your testimony on line 5, picking up after your footnote, you say, as well as statutory requirements in the Energy Transition Act for investor-owned electric utilities to achieve at least 50% renewable energy as a percentage of each utility's total retail sales to New Mexico customers by 2030, increasing to 80% renewable energy by 2040, and 100% zero carbon energy by 2050. Did I read your testimony correctly, sir?
Yes.
And you're aware that the Energy Transition Act is only applicable to electric utilities. Is that correct?
Yes, my inclusion of it there is to just generally describe New Mexico clean energy policies.
But you agree that it does not, that act does not apply to natural gas utilities like New Mexico Gas Company, correct?
That's right.
Then continuing on in your testimony on line 9, you say New Mexico adopted 2 regulations, advanced clean trucks and advanced clean cars.
I'm sorry, you broke up just a bit of it. On line 9, you say?
Sorry, Mr. Lee, I'll try to be louder here. On line 9, you say that New Mexico adopted 2 regulations, comma, advanced clean trucks and advanced clean cars 2, comma, which establish requirements for increasing sales of clean vehicles, and the state is currently evaluating low carbon fuel standard. Did I read your testimony correctly?
Yes.
And you are aware that New Mexico Gas Company is not in the business of selling cars, Mr. Kenny, is that correct?
No, I was not implying that with that statement.
Thank you, sir. Line 12 of your testimony, same page. For the built environment, as part of the U.S. Climate Alliance, New Mexico also pledged to install its proportional share of 20 million heat pumps by 2030. Is that your testimony, sir?
Yes.
There is no law in New Mexico that requires any set amount of installation of heat pumps in New Mexico, is there?
No, they are offered voluntarily through different utility programs, and there are tax credits available through the Sustainable Buildings Tax Credit for them, but there is no law mandating their installation.
And you cite for that proposition, this discussion about the 20 million heat pumps, you cite to a press release from the U.S. Climate Alliance. Is that correct?
Yes.
Thank you, sir. Mr. Kenny, would you please now go to page 25 of your testimony? Please let me know when you get there.
Okay.
Okay. Starting on line 5 of your testimony and going to line 17, you testify about thermal energy networks. Is that correct?
Yes.
And you continue to talk about thermal energy networks for the next few pages through 27. Is that correct?
Yes.
What is a thermal energy network?
It's in this context, it's a network of pipes that are placed into the ground with a solution to either absorb heat or dissipate heat connected to other individual pipes going to buildings. So these are, common in other countries. They're used in the US to provide either space heating, water heating to a building.
And is it your suggestion or recommendation to the commission that they pursue, or they ask the gas company to pursue thermal energy networks instead of some of the other ideas that have been raised by the joint applicants?
Yeah, it's my recommendation that New Mexico Gas and BCP consider thermal energy networks as one of the options. Yes.
And thermal energy networks, those use a non-combustible thermal median water. And I'm reading from line 7 and 8 of your testimony on page 25. Did I get that right?
I'm sorry, on
Yes.
page 75?
25, sir. Sorry. I will speak slower. I apologize.
Yes.
Okay. Mr. Kenny, do you have any knowledge of the number of miles of pipeline that New Mexico Gas Company currently operates for its gas utility?
Not specifically. I believe it's probably in the thousands of miles if you add up transmission and distribution.
Do you have a cost estimate as to what it would be to replace 1,000 miles of gas pipe so that with a thermal energy network?
Objection. It mischaracterizes the witness's testimony as though he is recommending like total replacement of gas company's system.
Mr. Haverly?
Madam Hearing Examiner, the witness has been proffered as an expert. He said that it was his recommendation that these things should be looked at, and I merely asked if he had an idea of the cost. I think that's a totally appropriate question.
Yeah, I'm going to overrule that objection. I think if you look at Mr. Kenny's testimony on page 25 at line 6, where he's asked to describe thermal energy networks, he testifies thermal energy networks can replace existing gas infrastructure. So I think it's a fair question. Answer if you know, sir.
It would not be, I think, practical to estimate the cost of replacing the entire system. The application that of thermal energy networks that I'm discussing here is usually at a smaller project scale. So if you're thinking about replacing a main that is serving a few number of customers, or if there's an opportunity for a new housing development or a new business park, to consider how a thermal energy network could be applied there rather than a like-for-like replacement of every mile of New Mexico Gas Company's infrastructure.
Mr. Kenny, you spent, would you tell me real quickly how many PRC cases you've testified in?
To date, I'd have to go check my resume for the exact number, but I believe it's 6 or 7.
And have you testified before other utility commissions prior to working in New Mexico here?
Prior to
WRA.
Could you clarify that?
Yeah, before you started working with WRA, did you provide testimony to any other utility commissions?
In my work at the Southwest Energy Efficiency Project, I believe I only testified in New Mexico cases, but provided comments in other dockets in other states.
Do you have an opinion, Mr. Kenny, about whether the commission's even able to regulate a thermal energy network?
Objection. Calls for legal conclusion.
Mr. Haverly?
Madam Hearing Examiner, again, this is his recommendation to the commission that this should be pursued. He's testified before at the commission. I'm just curious if this is something that he has an opinion about or thought about. I think it's a valid question since he's making the recommendation. I haven't asked him if he has a legal theory. I just asked him if he has an opinion on whether this is something the commission can regulate.
Ms. Beatles, knowing that we allow the some discretion for the expert witnesses to testify as to rules and regulations, do you not think this is a fair question?
I was just about to say I withdraw my objection.
Very well. Answer the question if you know, sir.
To my knowledge, there's nothing that would prevent the gas company from requesting to make a capital investment like this and having the commission consider that. many of these materials are, as I state in my testimony, similar to pipeline material that the gas company already uses and has approved depreciation rates for, and includes in their rate base. And the purpose of these is to provide predominantly space and water heating, which the gas company already provides to customers. So I don't see it as being outside the bounds of the services the company provides to ratepayers.
That's your time, Mr. Howerly.
Thank you, Madam Hearing Examiner. I appreciate the opportunity. Mr. Kenny, pleasure to see you again.
Nice to see you again.
Thank you, sir. I believe BCP applicants have reserved 15 minutes for Mr. Kenny.
Yes, Madam Examiner. Dana Hardy.
Ms. Hardy,
Thank you.
turn up the volume. Go ahead.
Is that better?
Yes.
Okay, thank you. Good afternoon, Mr. Kenny.
Good afternoon.
I'm Dana Hardy and I represent the BCP applicants in this case, and I have a few questions for you.
Okay.
New Mexico Gas Company is a regulated gas utility, correct?
Yes.
And as a regulated gas utility, New Mexico Gas Company is obligated to provide safe and reliable natural gas service to customers in its service area, correct?
I don't know if it's under statute specified it has to be natural gas, but everything else in that statement, yes.
Okay, but we've agreed it's a regulated natural gas utility, right?
Yes.
Okay. And New Mexico Gas Company will remain a regulated natural gas utility if this transaction is approved, correct?
To my understanding, yes.
And I'd like to refer you to page 7 of your testimony, and I'm looking at the question and answer at the top of the page. The joint applicants have committed to continue researching renewable natural gas, certified natural gas, and hydrogen, correct?
Sorry, could you give me the line number again?
It's page 7, starting at the top of it's your answer from
Madam
lines.
Hearing Examiner, there's a significant
Ms.
difference
Hardy,
in
it looks like
volume
she's
between Ms.
frozen.
Hardy and everyone else. I don't know if that's a problem for anyone else or if it's just something I need to deal with.
If Miss Hardy asked her question, I didn't get it. I got its page and then Miss Beadle spoke.
Okay. Again, try to project there, Miss Hardy, or they're
I do
having a
not have the
volume
judge.
issue with you.
Can anybody hear me?
Yes, Mr. Lee. Can you hear us?
Yes, I have no earthly idea what's going on. May I try something? Go ahead, Judge. I got its page from Miss Hardy and then Miss Beatles, and that's it.
Miss Beatles is saying she's having a hard time hearing Miss Hardy.
Can you all hear me?
Yeah, it is muffled.
Okay, let me try to switch something quickly and see. Is that better?
Yes.
Okay, perfect. Thank you. Sorry about that. To switch the
Okay.
source of my audio.
All right,
Okay.
you want to ask your question again, and I'll start your time back.
Sure, thank you. Mr. Kenny, I'm looking at the question and answer starting at line 1 on page 7. Are you there? Okay. And you recognize there that the joint applicants have committed to continue researching renewable natural gas, certified natural gas, and hydrogen opportunities, correct?
Yes.
Okay. And New Mexico Gas Company is already doing that type of research, isn't it?
Yes, that is my understanding.
the cost of that research are not being recovered from customers, are they?
Not at this time, no.
And if we look at page 9 of your testimony, lines 9 through 11, you state there, I am generally concerned that the acquisition would increase the likelihood customers pay higher costs for natural gas service due to capital investments in hydrogen, RNG, and CNG. Did I read that correctly?
Yes.
Before any such cost could be recovered from customers, they would be evaluated in a base rate case, correct?
Right now, yes, that would be the appropriate place to present them unless New Mexico Gas brought them forward as a separate case or through, say, their energy efficiency application. Yeah, there are a few different venues that exist today that I think those could come up.
Okay, but regardless of the proceeding, the commission would have to find that the costs are prudent before they could be recovered from customers, correct?
Yes, although I think as we heard in yesterday's discussions with Mr. Cebulko, it's not ideal for, say, the gas company to spend a lot of resources pursuing these alternatives if they're going to be found not to be prudent or get disallowed. I'd rather see their efforts go towards things that have greater greenhouse gas reduction potential and may have a lower risk of higher cost to customers.
And Mr. Kenny, regardless, the cost would have to be reviewed by the commission to determine to be prudent, correct?
Yes.
Okay, and parties could argue about that in the proceeding where the costs are sought to be recovered, correct?
Yeah, parties would have a chance to review those at the time.
Okay, and you talked about this a little bit with Mr. Haverly, but you recommend that New Mexico Gas Company pursue thermal energy networks, correct?
That they, pursue them as one of the options.
And you also recommend beneficial electrification, correct?
Yes.
Okay. And if you look at page 28 of your testimony, and I am looking at lines 8 and 9, and let me just get there quickly. You state, starting at line 8, and this is a quote, whether Emera Inc. remains the owner of BCP or BCP takes over, New Mexico Gas Company should pursue a coordinated beneficial electrification strategy with overlapping electric utilities. Did I read that correctly?
Yes.
And Mr. Kinney, your recommendations on beneficial electrification that you've made in this testimony apply regardless of who owns New Mexico Gas Company, correct?
They can be applied whether or not BCP is the owner or Emera is the owner, yes.
And your recommendations on thermal energy networks also would apply regardless of who owns New Mexico Gas Company, correct?
Yes, although I think what's important here is that we're considering should the ownership change and whether or not that is going to present a benefit to customers. And if what Emera is supporting with New Mexico Gas Company would be the status quo, and BCP is considering unchanging anything to do with that, then that's not a benefit, in my opinion, to customers.
Well, Emera hasn't proposed thermal energy networks, has it?
No, that's what I'm saying is that Emera is, the strategy that New Mexico Gas Company has proposed has been developed under Emera. So thermal energy networks, beneficial electrification are not things that I've seen under Emera's ownership.
Okay, and my understanding of your testimony is that you would recommend New Mexico Gas Company pursue those options, though, regardless of who owns the company.
Yeah, I think those would be beneficial to ratepayers.
Thank you. Those are all of my questions.
Thank you, Ms. Hardy. I do not believe that any other party has reserved cross-examination time for Mr. Kenny. I do have a few questions for you, sir.
Okay,
Again, like I say, welcome.
thank you.
And I realize that your testimony is limited to concerns regarding decarbonization investments. Correct, sir?
That is correct.
However, there's another witness in this case for WRA, isn't there?
Yes, yesterday we heard from Mr. Cibulco.
And I'm just wondering how that fits within your testimony. Whether or not so your ultimate recommendation is that that the commission reject the proposed acquisition, correct?
Yes.
But you've made some suggestions, and I just wondered if your suggestions are being made in the alternative. And by that, I mean, if, for example, BCP was to accept the recommendations that you set forth beginning on page 28, and I got my pages out of order. And further on in your testimony, ultimately, is that going to be enough to sway your recommendation?
I mean, I would need to see in writing how they take those recommendations from my testimony and apply them. I don't know. It would depend on what that looks like for me to say, does this drastically change my opinion of the acquisition?
Would your acquisition be the same no matter who the acquiring company would be?
I'm sorry, did you say would my acquisition be the same, or?
Would your recommendation be the same no matter who the acquiring company entity was that was going to acquire a gas company?
I don't believe so. BCP has stated that they are supportive of the strategies that New Mexico Gas is pursuing, and that is specific to BCP. You know, theoretically, there's another buyer out there who could desire different investment strategies of New Mexico Gas Company.
Well, how realistic do you think that is, Mr. Kenny, based upon the evidence in this case of the process that Emera went through and ultimately only ended up with one viable entity that made a bid?
I am not an expert in mergers and acquisitions, so I don't know what the world of potential buyers looks like, or how Emera worked through the list of interests that they had.
Okay, but But for us to be able to evaluate your recommendation, don't you think it has to be sort of have some thought to the evidence presented in this case, and if one accepts that Emera went through the process and that, you know, that the process was presumably appropriate to try to find potential bidders, and they only ended up with one. Don't you think the commission needs to consider whether, based on your recommendation, there actually is this pool of potential acquiring companies out there?
Sure, I think so. I guess my response was more to whether or not my recommendations would change if it was a different buyer, or would it be the same recommendation regardless of the buyer? I think if all we're doing is considering BCP as the only viable acquirer of New Mexico gas, then with my recommendations, I think we need to look strongly at, say, in tandem with what Mr. Zaboko is proposing with the integrated resource planning process, that these kind of investments, whether they be capital investments or decarbonization investments, should be looked at for prudency outside of rate cases, with enough time for stakeholders, for the commission, for staff to weigh the merits of them before resources are used.
There's been some testimony in with regard to the basically gas companies I don't know if I want to say revenue, but that their customer base increases are flat. And I'm wondering, the proposals that you make with regard to some other ways for a gas company to, I guess, decrease their carbon footprint. How should the commission consider those proposals if gas companies not necessarily increasing its customer base? How's gas company going to pay for these alternative ways to provide service?
I mean, in the case of, say, a thermal energy network, it would be, used in the same way as any traditional gas project. So kind of the example I briefly mentioned with Mr. Haverly, if the gas company identified a main pipeline that they wanted to, they knew they had to replace, or that there was an issue with it, they could consider what are the cost and benefits of replacing it versus installing a thermal energy network, or potentially relining the pipe. There are different pathways the gas company could assess what to do with that specific project. And that's something that I would, like to see before the commission, for stakeholders in the commission to weigh. For things like beneficial electrification, what I see with some other utilities, they offer those as part of their energy efficiency portfolio. So those are voluntary programs where customers would, they could receive a rebate for that equipment. But similarly, if the gas company knew that they might need to expand a particular section of their system to meet forecasted growth, that was going to, say, result in tens of millions of dollars of new capital costs, they could consider, well, if we partially electrified our customers in that area, not fully electrify them, but reduce their existing gas use a certain amount, could we avoid making those capacity expansion investments at a lower cost? So the costs are still there. The question is, does an alternative exist that would be a lower cost to ratepayers?
Do you think that some of the suggestions that you've made that result in, as you say, less gas sales is contradictory to the purpose of gas companies business?
I mean, they are a gas company, but at the end of the day, they are serving people with predominantly hot water, space heating, cooking. I think that is, to most people, that is what they serve, regardless of what fuel is delivering it. And if the gas company has the opportunity to earn a return on investments in alternatives, I don't think it in any way hinders their ability to exist or would be detrimental to their bottom line, to any revenues they would be generating.
So you think if they sell less gas, they're still going to have the same revenues?
Well, they don't make money off the gas, right? That's recovered through the fuel cost adjustment riders. So it's through the capital investments and mains and services and regulators and other gas equipment that they earn a return on. So if you allow the gas utility to earn a return, or say in the case of energy efficiency, a performance incentive that offsets the decrease in sales, there's still money to be made.
Or if you raise the rates on your ratepayers, then that's another way, if it's approved, for them to potentially increase the revenue, right?
I mean, if these investments were added to rate base, then presumably the rate customer sees could go up, but that would be dependent on the size of the whole pie, which, that would be specific to the case at hand.
Okay. And the $5 million that they committed, BCP committed to basically do research was not an acceptable commitment to you, correct?
Yeah, it came up without a lot of detail. So it's just very unclear to me what that $5 million would be used for. So I made some recommendations on the things that I would find it most useful to spend that money on.
Okay. Thank you, sir. That's the questions that I had for you. Ms. Beatles, any redirect of Mr. Kenny?
Yes,
Go ahead, sir, or ma'am.
that's fine. Okay, let me gather my thoughts really quickly. So Mr. Kenny, you were asked by Mr. Haberly about the governor's executive order on on climate and how it relates to New Mexico Gas Company. Do you recall that line of questioning?
Yes.
And what is your understanding of how it relates to New Mexico Gas Company?
I mean, in my opinion, the executive order is kind of I guess the background painting upon which we're all kind of acting in front, and the New Mexico Gas Company being an actor here in New Mexico should be trying to the extent it can to comply with that executive order. So while there's no direct requirement of the gas company to achieve any specific greenhouse gas reduction as part of the economy of New Mexico, they should be doing what they can to reduce emissions.
I mean, would it be reasonable for the commission to completely ignore the state's clean energy goals in examining this transaction or any other matter involving New Mexico Gas Company?
Objection, Brian Haverly.
Mr. Haverly?
That, Madam Hearing Examiner, I do believe wanders into a legal conclusion about what the commission should be taking into account in terms of executive orders when they're acting. So I believe that we've now ventured into a legal conclusion. So that's my objection.
Ms. Beatles?
I'm requesting his opinion as a regulatory expert.
Yeah, I mean, I think again, we do allow some latitude. He's not a lawyer. His opinion wouldn't be taken as one. So overrule the objection and answer if you know, sir.
Ms. Beatles, could you restate the question?
I will restate it and make it less leading. Should the commission consider the state's clean energy goals in evaluating this transaction and other matters involving New Mexico Gas Company?
Yes, I mean, climate change has real impacts on New Mexicans and New Mexico gas ratepayers. And so to the extent that there's a negative customer impact or ratepayer impact from the activities of New Mexico Gas Company or any regulated utility for that matter, then I think the commission should be weighing those impacts.
Does it relate to the public interest?
Well, yeah, and to the extent that the public is interested in not being harmed by climate change or by natural disasters exacerbated by climate change. So yes, if there is an increase in greenhouse gas emissions as a result of an action being taken by a utility that will result in additional impacts to the citizens of New Mexico, then I believe that would be captured under that public interest.
Ms. Hardy was asking you some questions about why you, and I'm paraphrasing, why you were so concerned about their references or pursuits into, I should say, their references or their interest of the applicants in potentially pursuing certified natural gas, renewable natural gas, or hydrogen when those costs wouldn't be recovered from customers unless approved by the commission. Do you recall that line of questioning?
Yes.
And so could you please explain why you are concerned about those references to those particular decarbonization strategies?
I think from the perspective of BCP being supportive of New Mexico Gas Company pursuing those, it to me just would limit what I think are more reasonable decarbonization options on the table, if those are the only three that they're going to consider. And, as I go through in my testimony through each of those three options, there are considerable costs and risks associated with those. And so to the extent that those are the options New Mexico Gas Company wishes to pursue and BCP will be encouraging them to do so, then I have concern with that.
By reasonable, would you recommend that the commission consider all or other cost-effective decarbonization strategies?
Yes, I mean, to the extent they're practicable, I think that should be a consideration, especially when there are discrete projects they can be applied to.
And then one last question. You were asked about the primary focus of your testimony, and you responded that you approached your examination of this transaction through the lens of decarbonization. Do you recall that?
Yes.
And is that at least in part in response to Mr. Baudier's direct testimony that BCP management expects its portfolio companies to develop their own policies to achieve carbon reduction goals?
Yes, that was one of my considerations when framing my testimony.
Okay, I have nothing further. Thank you.
Thank you, Ms. Beatles. Anything further, Mr. Howerly?
Very briefly, Madam Hearing Examiner. Mr.
Go ahead.
Kenny, earlier you had an exchange with the hearing examiner where you indicated that the gas company does not make money off of selling gas. Do you recall that exchange?
Yes.
Mr. Kenny, are you aware that that New Mexico Gas Company's rates are volumetric, or at least have a volumetric component?
Yes, I'm aware of that.
So the revenues that the gas company receives can be impacted by the amount of gas that the gas company sells through its system. Is that correct?
Yes, the throughput has an impact on the individual dollar per therm that a customer would see, given the way rates have been designed.
No further questions, Madam Hearing Examiner.
Thank you, Mr. Howerly. Ms. Hardy, anything further from you?
No, thank you.
Thank you. Mr. Kenny? Thank you very much, sir. Appreciate your time. You are excused.
Thank you very much.
I believe, Ms. Beatles, subject to item exhibit 4, attachment 4. And my ruling on that, is there anything further from WRA?
That's it. Thank you very much.
Thank you very much. I believe now is the appropriate time for luncheon. Let's come back at 1:30. And I believe in our order, we will now hear from CCAE witnesses. So with that, we are recessed until 1:30. Please remember the YouTube is on. Thank you. Mr. Lee.
Ready, Judge.
Very well, sir. Good afternoon. We are back from our luncheon recess and ready for more of our evidentiary presentation pursuant to the order of witnesses agreed to by the parties. I believe that CCAE has the next witness. Mr. DeSalen?
Thank you, Madam Hearing Examiner. I believe so too. Coalition for Clean Affordable Energy calls Ms. Angela Vituli as our first witness.
Thank you, sir. Good afternoon, Ms. Vituli. Welcome.
Good afternoon, Your Honor.
Mr. Lee, would you please swear the witness?
Ms. Virgilia, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am.
Thank you.
Go ahead, Mr. DeSalen.
Thank you. Good afternoon, Ms. Vituli. Could you state your name, please, for the record and spell it?
Yep, Angela Vituli, V as in Victor, I, T as in Tom, U-L-L-I.
And where are you employed?
Industrial Economics.
And what is your business address?
It's 2067 Massachusetts Avenue, Cambridge, Massachusetts, 02140.
2067.
Massachusetts Avenue.
And the rest?
Cambridge, Massachusetts, 02140.
Thank you.
Thank you, Mr. Lee. On whose behalf are you testifying today?
CCAE.
And that means Coalition for Clean
Coalition for
Affordable
Clean
Energy.
Affordable Energy, yes.
Okay, and have you prepared written testimony for this proceeding?
I have.
Now, I refer to you to a document that has been marked as CCAE Exhibit 1. Could you identify that, please?
Hold on one second. Just scrolling. So Exhibit 1 is my resume.
Excuse me, this is Exhibit 1. CCAE Exhibit 1.
Not your attachment.
Okay, so you mean my testimony itself then?
Correct.
Yeah, okay, yes.
Okay, so that is your testimony?
Yes, it
dated
is.
September 26, 2025?
Yes, it is.
Okay, and did you prepare it?
Yes, I did.
And is it true and accurate to the best of your knowledge?
It is.
And are there any changes that you would like to make to it?
Yes, I would like to correct some typos. So on page 2, line 9, Exhibit IEC-1 should be Exhibit AV-1. On page 5, line 4, 1.7 million should be 1 million. This does not change the calculation. On page 35, line 12, where it says, quote, at least much annually, it should read, quote, at least as much annually. Page 40, line 17, the word Caron, C-O-R-O-N, should be carbon, C-A-R-B-O-N. And on page 42, line 3, 2026 should read as 2024 there.
Okay, thank you. Now, with these corrections, do you adopt this as your direct testimony today?
Yes, I do.
Okay, now we get into the attachments. Are exhibits AV-1 through AV-17 attached to your testimony?
Yes, they are.
And can you identify exhibit AV-1?
Yes, that is my resume.
And did you prepare it?
Yes, I did.
And is it accurate and up to date?
Yes, it is.
Okay, then the next one is AV-2. Could you identify that?
Yes, that's the New Mexico Greenhouse Gas Inventory and Forecast from December 2024.
Okay, and did you rely on that document in preparing your direct testimony?
Yes, I did.
Okay, then let's look at exhibits AV3, AV6, AV7, AV9, AV10, AV11, AV12, AV13, and AV15. Those are all, are those all responses to interrogatories from the joint applicants?
Yes, they are.
Okay, and I might have gone a little too fast there, Mr. Lee. Did you get all of that?
Yes, sir.
Okay. And were these, did you rely on these responses in preparing your direct testimony?
Yes, I did.
Okay. Then let's look at exhibit AV-4. Could you identify that, please?
Yes, that's the New Mexico Building Decarbonization Roadmap version 1.0. And it was published earlier in 2025.
And did you rely on that in preparing your direct testimony?
I did.
And then exhibit AV-5, could you identify that?
Yes, that is an article entitled Oil and Gas Companies, Investors, and Policymakers All Have Important Roles to Play to Solve the Problem of Transferred Emissions in the periodical Sustainable Finance.
Okay. And did you rely on that in preparing your direct testimony?
I did.
And then exhibit AV-8, could you identify that?
Yes, that is the 2023 Amera Climate Transition Plan Update.
And did you rely on it in preparing your testimony?
I did.
And then could you identify exhibit AV-14?
Yes, that is an article entitled Maryland Regulators Say Columbia Gas Rate Settlement Balances Competing Interests that was
Sorry,
published.
Maryland. I'm sorry, Maryland. A little
Sorry.
slower, Maryland.
Sorry, Maryland regulators say Columbia Gas Rate Settlement balances competing interests. And that was from S&P Global.
And did you rely on it in preparing your testimony?
I did.
And then AV exhibit 16, could you identify that?
Yes, that is an article entitled Utilities Are Buying Pricier Responsible Gas, but for what climate benefit?
And did you rely on that?
Yes.
I'm sorry, go ahead.
That was in the publication called DSMOG, DE_SMOG.
Thank you. Sorry for interrupting. And did you rely on that document in preparing your testimony?
I did.
And then finally, could you identify exhibit AV-17?
Yes, that's the greenhouse gas analysis model that I developed that underpins the analysis presented in my testimony.
Okay. And did you rely on that in preparing your testimony?
I did.
Okay. Thank you then. At this point, Madam Hearing Examiner, I'd like to move for the admission of CCAE Exhibit 1, including the attachments to Exhibit 1 labeled AV1 through AV17.
Any objection, excuse me, to what's been identified as
Madam Hearing Examiner, sorry.
what?
Who is speaking?
Hi, Mr. Lee. My name is Juliana Hopper. I'm also.
You want to wait till I get my offer out, please?
Yes, Madam Hearing Examiner.
Any objection to what's been identified as CCAE Exhibit 1, the pre-filed direct testimony of Ms. Batuli as affirmed by her here today? Ms. Hopper?
Good morning, Madam Hearing Examiner. And yes, Mr. Lee, this is Juliana Hopper for NMGC and Amera. Madam Hearing Examiner, of the 17 exhibits, we do have objections to 5 of them. So starting with AV2, the New Mexico Greenhouse Gas Emissions Inventory and Forecast. This was, I think, falls under the scope of your prior rulings. This has not been authored by this witness, and it's not a document that gets around the rules of hearsay in that respect. And there's nobody present in this hearing who can be crossed or asked about any of the things in this inventory and forecast. And so while we do believe it is appropriate for the witness to rely on it for her opinion, we don't believe it's appropriate to bring the entire document into the record. We also believe there's a bit of a relevance issue. I don't think that inventory and forecast says anything directly about natural gas utilities or New Mexico gas specifically. We would also object to AV-4, the New Mexico Building Decarbonization Roadmap.
Why don't we take them one at a time? Mr. DeSalen, do you have a response to that objection?
Yes, Madam Hearing Examiner. I actually have a number of responses. I have some general responses, and I also have specific responses to this document. I'm not sure how you want to handle this. My general responses cover all of them, and well, at least the objections that I've heard so far and the ones that I'm anticipating. So from that standpoint, it might make sense for us to wait, but I can respond to these individual ones if you would prefer.
Yes.
Okay. So as far as the emissions inventory is concerned, that document is a published document, and it goes to the heart of some of Ms. Vituli's testimony. She discusses it at length. It's part of the basis of her opinion, and it's also a government document. It was prepared in part through at the request of the state of New Mexico and in cooperation with a couple of state agencies. So that's my response on that one.
We haven't gotten any further. Okay.
Okay.
Go ahead, Ms. Hopper.
Well, Madam Hearing Examiner, I think it's a bit of a stretch to call it a government document. It is true that it was created to assist the state, but it was not prepared by the state. And in fact, it was prepared by the Energy and Environmental Economics, Inc. for the Center of New Energy Economy at Colorado State University. And that is not the state of New Mexico. So while it was prepared to assist the state, it is not a state document, and it is not something that they have officially adopted. It's not something that they've created any policies that directly go to the gas company on. So again, therefore, we don't believe that it gets around the hearsay, except the hearsay rule, or that it's really relevant.
Very well. Anything further, Mr. DeSalen, on to?
Yeah, Madam Hearing Examiner, I'd just like to mention, as far as relevance is concerned, a lot of Ms. Vituli's testimony, of course, goes to greenhouse gas emissions and how this transaction may affect greenhouse gas emissions in New Mexico. And that goes to the issue of public interest, which is, of course, the basis for the commission to approve or not approve the proposed transaction.
Your next objection, Ms. Hopper?
Yes, Madam Hearing Examiner. We would also object to AV-4, the New Mexico Building Decarbonization Roadmap. This document, if you look on page 5 gives a bit of an explanation as to what it is. And it says that with the passage of the Energy Transition Act in 2019, New Mexico joined several Western states in accelerating its commitment to renewable energy and electric grid decarbonization. The act raises the state's renewable portfolio standard and requires investor-owned electric utilities to reach 100% zero carbon resources by 2045. So with that background, this is a document that is in light of the Energy Transition Act, which only applies to electric utilities. And based on that, it appears that some stakeholders who are impacted by the ETA got together and created this document. And New Mexico Gas Company was not a participant in that. This document is not based on law that directly affects the gas company. And Madam Hearing Examiner, I think you can see on page 2 of that document that lists the participating organizations, that NMGC is not one of them.
So this is a relevance objection?
For that reason, yes, and also the hearsay. None of those participating stakeholders who created it are present in this proceeding. It was not authored by the witness either.
Mr. DeSalen, your response?
Yes, thank you. So also on page 2 of the document, it indicates that it was prepared in cooperation with government agencies, state government agencies. It is relevant because it goes to one of Ms. Fatuli's points that the state of New Mexico, in order to meet its carbon goals, has to expand the use of electric heat pumps for water heating and space heating. And that again goes to the issue of greenhouse gas emissions and public interest under the statute. Because part of Ms. Futuli's testimony is that this transaction will result in greater emissions of greenhouse gases.
Anything further, Ms. Hopper, on 4?
Briefly, Madam Hearing Examiner, I don't disagree that there was some cooperation from some government entities, but I do not believe that that is the same as a document that has been adopted by a state agency or by the government. So I don't believe that that is enough to get around the hearsay exception. And as far as the relevance goes, I do understand Ms. Fatuli speaks to this in her testimony, but in compliance with your prior rulings, I believe that she is allowed to do that. It just is unnecessary that this entire document be admitted.
Anything further, Mr. DeSalen?
No, there are still some general statements that I want to make about hearsay, but I'll wait until the end.
Very well. Your next objection, Ms. Hopper?
Yes, Madam Hearing Examiner, we would object to AV-5, which is the article about transferred emissions, I believe, as Ms. Vituli described it. And I think we have pretty much the same objections, which are that this was not authored by anybody in this proceeding, not authored by the witness. It's not specific to gas. It's not specific to New Mexico. And so the same hearsay and relevance objections.
Mr. DeSalen?
Thank you. Yes, this article discusses the problem of transferred emissions, which Ms. Fatuli discusses in her testimony at page 13.
Mr. DeSalen?
Yes, did you not hear me? Can you hear me? Can you hear me?
Yes.
Okay. I indicated that that this article refers to the problems of emission transmission, and that is something that Ms. Fatuli discusses. It's a main point that she makes in her testimony. And I'm not denying that this is could be characterized as hearsay, but for a number of reasons, we think it should be admitted.
Ms. Hopper?
I think it's just the same objections I had before.
Okay.
Yeah.
All right. Your next objection?
That would be to AV 14, the article entitled Maryland Regulators Say Columbia Gas Rate Settlement Balances Competing Interests. And again, similar objections. This is not authored by this witness or anybody in this proceeding. And with respect to the relevance objection, Madam Hearing Examiner, this is just from the title is about a settlement of a rate case in Maryland, which does not seem to be relevant to this proceeding.
Mr. DeSalen?
Yes, thank you. So again, this article discusses the reasons why several states have rejected renewable natural gas offsets, and that's something that's discussed in Ms. Vituli's testimony at some length.
Anything further?
Other than my general comments on her hearsay, no, I think that covers this exhibit.
Okay, go ahead, Ms. Hopper.
I was just going to comment that, again, the witnesses, it sounds like according to your prior rulings, the witness is free to rely on it. We just believe it's unnecessary for it to come into the record, Madam Hearing Examiner.
Okay, any further objection?
Just one more, Madam Hearing Examiner.
Go ahead.
That would be AV 16. And this is an article entitled Utilities Are Buying Pricier Responsible Gas, but for what climate benefit? And this article appears to be about the purchase of certified low emission natural gas. I think this Ms. Vituli on page 47 of her testimony, line 16, acknowledges that the joint applicants have not provided a specific proposal on certified low emission natural gas. So I don't think that this helps the commission in deciding the proposal before it in terms of relevance. And again, the witness is still free to rely on it in her testimony, and the same hearsay objection, Madam Hearing Examiner.
Mr. DeSalen, your response?
Thank you. So this article again discusses some of the problems with certified low emission natural gas, which is something that there's not a concrete proposal. It's nevertheless something that the joint applicants have proposed addressing as one of their commitments. And Ms. Vituli discusses some of those problems in her testimony. So, Madam Hearing Examiner, if I may, I'd like to discuss the hearsay issue more generally.
Yes, sir.
Thank you. So, first of all, as Ms. Beatles and some other people have mentioned, the commission is not bound by the rules of evidence in this proceeding, and that's in 1.2.2.35.A2 NMEC. Second of all, I would point out that this hearsay, these hearsay documents can be admitted under Rule 11-807, which is the residual exception to the hearsay rule. And that's commonly used for this type of evidence to where there isn't any evidence to indicate that the document is inaccurate or unreliable. It's sort of a catch-all exception to the hearsay rule. The third thing I would point out is the precedent of this body. So similar articles and reports have previously been admitted in PRC hearings. As you probably know, I haven't been practicing in front of the PRC for that long, but in the time that I've been here, quite a few of these types of articles and reports have been admitted into evidence. And there's one in particular that I'd like to bring to your attention, Madam Hearing Examiner. And this comes from the PNM grid modernization case from a couple of years ago. And that's number 22-00058-UT. And I'm going to quote from the transcript from volume 3. It's March 22nd, 2023, page 1040, that's 1040, beginning at line 17. And I'm quoting from the hearing examiner. And he says, turning to Exhibit 5 that was submitted, and then he gives the title of the exhibit, Leveraging of Advanced Infrastructure to Save Energy. And then he goes on and he says, I read Exhibit 5 in its entirety and thought it was a very useful document to, put the big picture in perspective in this case. And that document was written by Rachel Gold, who was not a witness, was not cross-examined. She was with the American Council for an Energy Efficiency Economy. It's a 2020 document. It was hearsay to the same extent that these documents that I'm introducing are hearsay, and it was admitted. The fourth thing that I would mention, Madam Hearing Examiner, is in other administrative forums in which I've practiced, these kind of documents are admitted routinely. And I can say the Environmental Improvement Board, the Water Quality Control Commission, the Office of the State Engineer, these things come in routinely. And typically the hearing officer, the hearing examiner will rely on Rule 807, the residual exception to the hearsay rule, which I mentioned a minute ago. Then I'll also mention the fact that, and I know other people have mentioned this, but just for the record, I want to state that these objections should have been made earlier. The joint applicants have had the revised testimony and the exhibits since September 26th of this year, and very similar testimony and exhibits were submitted and served on April 18th in the initial phase of this proceeding. And there's just one more thing I want to say, and I apologize, I'm taking up some time here, but there's a kind of a practical issue here, and that is if these articles like this are cited in testimony, but they're not made part of the record, with things being readily available online, it sort of creates an invitation for the commission or commissioner to, without really thinking about it, go and take a look at that article and potentially rely on it in the decision. And that would be potentially reversible error for a commissioner to rely on something that is outside the record. And I know of one case where this was the Water Quality Control Commission actually was reversed for several reasons. It wasn't just for this reason, but one of the reasons that the Court of Appeals gave for reversing the Water Quality Control Commission was that one of the commissioners had discussed some material that was not part of the record, and there was at least the implication that he might have used that in reaching his reaching his decision on how to vote. And I can give you the citation for that case. It's Gila Resources Information Project versus the New Mexico Water Quality Control Commission, and the citation is 2005 NMCA 139, and that discussion takes place at paragraph 42. I would also point out that some of these documents, because they were partially handled or partially prepared with the cooperation of state agencies, are documents that the commission can take administrative notice of. And in particular, that would be Exhibit AV2 and Exhibit AV4.
Madam Hearing Examiner, may I ask a few questions of the council?
Are you finished, Mr. DeSalen?
I am, thank you, and I'd be happy to take some questions.
Thank you. Go ahead, Hearing Examiner Schaefer.
Mr. DeSalen, firstly, I just want to ask, are there any limits in your mind as to what could be attached to a testimony and admitted? Can a book be attached? Could volumes of records be attached?
Sure. I think there are limits, and as far as the volumes are concerned, I think it's entirely practical. And yeah, somebody, I guess, could abuse it. I've not seen, in my experience, I've not seen that happen. It doesn't behoove the party that's introducing the exhibits to add hundreds and hundreds of pages to the record. So I think when I'm helping a witness prepare, we always try to keep that in mind and to sort of balance things. And certainly there is a relevance standard here that has to be met, and any document that's attached would have to be relevant.
But in your view, so long as any document is relevant, it could be attached.
Mr. Hearing
Are there
Examiner Schaefer,
go ahead.
Yes, I think that's correct. I think, there has to be a certain reasonableness that goes into it. I mean, it should be a document that the witness is relying on and significantly relying on, and it can provide additional context and additional background for the issue that the witness is discussing.
Just one more question. Rule 11807B, notice. The statement is only admissible if the declarant's name and address are provided beforehand.
And yes, and we have provided all that information as part of our pre-filed testimony.
The author's name and address, every author's name and address of these reports?
Oh, I'm sorry, the author's address is not included. I agree with that.
Thank you, Ms. Hearing Examiner Hurst.
Thank you, Hearing Examiner Schaefer. Mr. DeSalen, I heard you answer in response to Hearing Examiner Schaefer's question that you believe there are limits. Was that correct?
Yes, that is correct.
And what would that limit be?
I don't.
Or limits?
Madam Hearing Examiner, I don't know if I would put like a page number limit on it. I think it's going to vary from case to case, from time to time. But I mean, if the witness is discussing it, it's not going to be a huge volume, right? It's going to be a limited article. In some cases, the witness might attaches an exhibit, a chapter or selected pages. But typically it doesn't behoove the again, it doesn't behoove the proponent to try to add a huge volume of material to the record.
Well, let me ask you this. If the witness attaches everything that helped craft their opinion, as an exhibit to their testimony, then couldn't the trier of fact dispense with the witness testimony and just read all the attachments?
Madam Hearing Examiner, I would say no. I think that the witness's testimony, and part of the purposes of an expert's testimony is to bring information together, to collate it, to condense it, and to present it in a form that is most useful for the hearing examiner and ultimately for the commission.
And isn't that the point, Mr. DeSalen, that it is the expert's opinion that the commission wants to hear, and it's the expert's testimony, the live testimony that can be cross-examined by the parties and examined by the hearing examiners and the commission. It is that expert's qualification and their analysis of the case matter and whatever they choose to rely on, that is the important evidence for the commission to consider. Isn't that right?
Yes, I would agree with that, but I also believe
Then
that
why is there such importance to, if that's the important thing for the commission to consider, is the evidence from the expert, then why do we have to have all these hearsay attachments from sources and people not present to be questioned, or which may be duplicative or may contain irrelevant information to the inquiry, otherwise and potentially in conflict with what the live testimony says? Why do we need those hearsay documents?
Madam Hearing Examiner, I think what those documents do is they provide further context, further information, a deeper discussion beyond what's in the witness's testimony.
And that further information that might be considered evidence in the exhibit that hasn't been vetted, how is the commission to deal with that?
I'm sorry, you broke up there?
You just used the word evidence, that the exhibit contains further evidence. And that's my whole point. If the commission is relying on the expert's testimony in the case and the process of cross-examination and examination of the witness and their opinions, and if there is this other exhibit that is attached to the witness's testimony that contains other information which you've called evidence, then how could the commission rely on that?
The witness will be sponsoring it, and it's being introduced. I'm not real sure how to answer your question, Madam Hearing Examiner.
Okay. Very well. Anything further with regard to your general objections, Mr. DeSalen?
No, I think that I think I've made my points, Madam Hearing Examiner.
Thank you. Anything further from you, Ms. Hopper?
Just briefly, Madam Hearing Examiner, try to quickly respond to a couple of those points, if I may.
Okay, go ahead.
Rule 11807, which Mr. DeSalen cites to, I agree with Hearing Examiner Schaefer that the second part of that requiring declarant's name and address is deficient, but I would also note that there is a 4-factor test under that rule, and I don't think there has been a demonstration of any of those factors for any of these exhibits, including that these statements have equivalent circumstantial guarantees of trustworthiness to hearsay exceptions. With regard to Mr. DeSalen's points that the commission and other administrative bodies have allowed such type of articles in the record, I would point out that that is a discretionary matter for Your Honor, and that those decisions are not binding on you. And with respect to other administrative bodies, they may have other rules and things that are not applicable here. I believe that our objection is timely in terms of the proper time to object is when it's moved for admission. And Mr. DeSalen then made a point that if an article is cited to and available online, people might be confused because they can go find that article and might think it's evidence, I think is what I understood him to say. And while Madam Hearing Examiner, I would argue that the risk is greater if it's included in the record as evidence, that there is certainly a risk people rely on it. And if there's a link to it, but it's not in the record, it is much clearer that the rules of evidence did not allow it in, and that an expert can rely on it, and experts can rely on hearsay. That does not make them evidence. So I think the rules assist with any confusion on that. And then as far as administrative notice, I believe Mr. DeSalen indicated that because a couple of the documents were done with the cooperation of government agencies, that applies. And again, I disagree with that. I think that the rule, which is 1.2.2.35D, and that's subsection 1, and I believe Mr. DeSalen is referring to subsection A of that. It talks about subsection 1A, Mr. Lee, apologies. But that subsection of the rule talks about published reports of governmental agencies, not in cooperation with them. So I don't think that that applies either.
Mr. DeSalen, did you, with regard to the administrative notice on the 2 and 4, do you know if those that you claim the commission can take administrative notice of, do you know if they were comport with the 1A requirement as just set forth?
The 1A requirement?
Ms. Hopper just set forth the commission's rule on what administrative notice can be taken of, and she cited 1.2.2.35D1A, which says rules, regulations, administrative rulings, published reports, licenses, and orders of the commission and governmental agencies and other governmental agencies. Do you know whether or not 2 and 4 fit within that specific category?
I think they do. I mean, I agree that there are different ways that that wording could be interpreted. But since government agencies were involved in preparing those reports, I think they do meet that that standard.
All right. I'll take the objections and the responses to the objections under advisement. And think about whether or not the additional arguments made by Mr. DeSalen, I'll think about them. Therefore, I will take the request to admit CCA E1 subject to the objection to attachments 2, 4, 5, 14, and 16, which are under advisement. Anything further, Mr. DeSalen?
No, Madam Hearing Examiner, just thank you. And the witness is available for questioning and cross-examination.
Thank you very much. I believe that the parties that reserved time for Ms. Batuli are gas company who reserved 10 minutes. Ms. Hopper?
Thank you, Madam Hearing Examiner. Good afternoon, Ms. Vituli.
Good afternoon.
My name is Julie Hopper, and I'm one of the attorneys for New Mexico Gas Company and Emera. I would like to start on page 7 of your direct testimony. If you could let me know when you get there.
I'm there.
Starting on line 7, you say that approving this proposed acquisition is likely to lead to increased growth in residential gas customers in New Mexico, as well as increased data center development that is reliant on natural gas. Both outcomes undermine the state's climate goals, contrary to the public interest standard. Did I read that right?
You did.
So when you refer to the public interest standard, are you referring to the 6-factor test that is applied in New Mexico?
I am.
Can you tell me what those 6 factors are?
Well, the one that I relied on was the 6th factor of adequacy of protections against harm to customers.
Okay.
And I can elaborate if you'd like.
No, that's all right. Thank you. Now, you've never testified before the New Mexico Public Regulation Commission, is that right?
That's correct.
Have you ever testified in any acquisition or merger case before?
No, not in an acquisition or merger case. I have testified in other DSM cases.
And according to your resume, you live in Massachusetts, is that correct?
It's true, yes.
Have you ever lived in New Mexico?
I have not.
Now, Ms. Vituli, could you please turn to page 17 of your testimony?
Okay.
And starting on line 14, to summarize a little bit, you say that you analyzed likely GHG emissions impacts from 2025 to 2040 under 3 different scenarios: baseline, approved transaction, and meet states goals. Is that correct?
That's correct.
Now, the baseline scenario, as I understand it, is a trajectory based on current decarbonization policies. Is that right?
Yes.
And the approved transaction scenario is supposed to be what is likely to happen if the transaction's approved. Is that right?
That's right.
And then the meet states goals scenario assumed something beyond the current policies to meet the state goals. Is that right?
That's right.
So what does the term baseline mean here as you're using it?
Baseline means current situation, in a situation where Emera retains control over NMGC.
Okay, so it's kind of the status quo. Is that right?
Status quo, exactly.
Okay. Can you please turn to page 10 of your testimony?
Yes. Yes.
On line 13, you say that NMGC's 2024 Integrated Resource Plan reports average annual customer growth of 4,126 customers per year between 2017 and 2022. Did I read that right?
That's correct.
Do you know whether the company has added additional customers since 2022?
Yeah, so for residential customers, based on joint applicants' response to our interrogatory that's labeled as JA Table CCA 2-2A, for residential customers, 2,838 were added in 2023 and 3,328 were added in 2024.
Okay.
I'm sorry, 3,300 and
28. And those are
Thank you.
residential customers, which is what what the analysis relies on.
And on that page 10 for the statement about the integrated resource plan, you cite to a page of that IRP and you looked at that. Is that right?
I did.
Do you know the planning period for that IRP?
Not off the top of my head. I used the most recent one though.
Is it fair to say that it's a few years ahead?
Well, IRPs are always forward-looking, so yes.
Are you aware of whether that IRP forecasts growth for that future period?
No, for my testimony, I mostly relied on what was provided in Discovery, which was the rate of growth that was provided by NMGC in response to Discovery. So that's what I relied on in my analysis.
Okay, so you don't know whether the company is forecasting growth to increase in the future coming years.
Well, they responded to testimony and they gave us a growth projection going out from 2026 through 2030, which I did rely on. So for residential customers from 2026 to 2030, they were estimating about 4,300 a year during that time.
You use the word they. By they, are you referring to the joint applicants?
The joint applicants, yes.
So do you know whether New Mexico Gas Company, outside of the transaction, if the transaction were not approved, would forecast growth?
I'm not aware of that. So we basically went with what was given to us. We asked for this information in Discovery. We asked the joint applicants, and that's what they provided. But I do have several reasons to believe that the growth trajectory would be different if the transaction didn't go through.
But you don't know whether New Mexico Gas Company, under Emera ownership, is forecasting growth.
No, but I am aware of differences in their goals and in their situation that are relevant. So, I mean, first of all, they actually the residential numbers for the last few years, if you look between 2022 and 2024, the residential numbers are 2,500 a year. And joint applicants have said that it's going to be 4,300 a year moving forward, which is a difference, a significant difference. Emera is also publicly committed to significant greenhouse gas reductions, net zero by 2050.
Hold down a little bit. Hold down a little bit, Emera.
Sorry, Emera has publicly committed to greenhouse gas reductions to get to net zero emissions by 2050 and an 80% reduction by 2040. And they've been reporting on those goals for many years. In contrast, BCP, the joint applicants, have not made any climate commitments. Emera has listed changes in environmental law and policy, including climate policy, as a significant and material risk to their business in their annual public financial report in 2024. And listing anything as a material risk in public financial reporting signals to public markets that this risk can materially affect operations, financial condition, stock price. And under SEC rules, Emera must report on efforts it's taking to address any significant material risk. These conditions do not apply to BCP at all. So based on those main reasons, I do think that the forecast and what will actually happen will be different.
I understand you're saying you believe you have reasons for them to be different, but you don't have a forecast from NMGC is what you're saying, isn't it?
Mm-hmm. Correct. We don't have a forecast from NMGC. We have a forecast from the joint applicants.
So you don't know whether NMGC on its own is forecasting growth, do you?
No, but I do know that their parent company needs to make reductions in their natural gas use in order to make further progress on their climate targets that are very that they've made very publicly, that they've identified as a risk to their business model.
And as we were talking about a couple of minutes before, you are aware the company is growing in recent years. You said it has added customers since in 2023 and 2024, I believe you said.
Yes, when we're looking at residential customers, in 2022, they added 1,305 customers. In 2023, 2,838, and in 2024, 3,328. That is much less than the 4,300 that the joint applicants are telling us that they are going to add annually of residential customers from 2026 to 2030.
Ms. Vituli, are you aware that Emera's climate goals apply only to Nova Scotia Power and Tampa Electric?
That's not what's indicated in their documents. In their documents, they talk about it holistically.
Mm-hmm. Okay.
And their goals are set at a enterprise level.
So in this discussion, you have indicated you're aware that the gas company is forecasting adding customers, maybe not as much as you think will happen, but you're aware there is growth.
You broke up for a second. Forecasting some.
You are aware the gas company has been adding some customers.
Yes.
And you are aware that you are not aware whether they're forecasting growth. Yet in your baseline scenario, which you've indicated is supposed to be the status quo, you assume that the New Mexico Gas Company will have zero growth in its customer base. Isn't that right?
Yep.
And in fact, on page 20 of your testimony, there's a table about the baseline scenario, and you assume not only will the gas company not grow, it'll begin losing customers in 2026. Isn't that right?
Yes, I do. And I do think that is what will likely happen in a scenario where Emera keeps ownership of a gas asset that they need to make some improvements on in order to make progress towards their goals.
Okay.
That's your time, Ms. Hopper.
Thank you, Madam Hearing Examiner. Actually, Madam Hearing Examiner, would I be able to trade my time for staff witness Hohola?
Sure. How much?
I don't think I'll expect to use all of it, but I will go ahead and take the whole 10.
Okay, go ahead.
One last couple questions, or a few more questions here, Ms. Vituli. On page 11 of your testimony.
Mm-hmm. Yes.
Starting on line 3, you state that adding 4,300 NMGC customers per year until 2030 is in direct opposition to this goal, meaning the state's
The state's goal.
decarbonization goals.
Yeah.
As each new natural gas-fueled heating system precludes the installation of an electric heat pump, and the expected lifespan of HVAC, which stands for heating, ventilation, and air conditioning equipment, is at least 20 years. Did I read that right?
Yes.
So based on that statement, if the transaction does not happen, and if NMGC were to add 4,300 new customers under Emera ownership, you would still oppose that, wouldn't you?
I would.
Because adding, under that statement, adding any number of customers is bad, right? Even one.
Yeah, I mean, the numbers matter, but yes. But the point being, the point is, the job that I was given was forecast under current conditions versus if NMGC is taken over by BCP, a private equity firm, as opposed to its current owner, which is a public utility that has significant climate goals and has identified significant climate risks. That's the assignment. So what I'm saying here is that under BCP ownership, this is the 4,300 is what I'm expecting. I do not expect 4,300 new residential customers per year after 2026 if it remains in current hands.
I understand that.
If it remains
in current hands.
Thank you.
I understand that that's what your opinion is, Ms. Vituli, but go with me for a minute here. If NMGC adds those customers, whether it's owned by BCP or Emera, you oppose that growth, correct?
Yes.
And so isn't it true that really what you're opposed to is growth of the gas company?
Yes.
And that is regardless of who owns it, correct?
Correct. But I think it'll be different.
Thank you, Madam Hearing Examiner. I have no further questions.
Okay, you used 3. So that leaves you 7 for the staff witness. I do not believe that any other witness scheduled cross-examination time for Ms. Vituli.
Your Honor, this is Will Dubois.
Mr. Dubois?
I think the BCP applicants had.
Oh, you did. I apologize. Yes, you have 10 minutes. Go ahead, sir.
Thank you, Your Honor. Hello, Ms. Vituli. My name is Will Dubois, and I represent the BCP applicants in this matter.
Good afternoon.
Good afternoon. Picking up on your opinions regarding how NMGC would operate based on your understanding of Emera's greenhouse gas goals. Do you believe Emera would direct NMGC not to connect customers who would like to receive gas service?
No, but I do believe that they would be more amenable to that they wouldn't aggressively be pursuing customers as much as BCP would. As evidence in the fact that their numbers for the past few years are lower than what BCP is projecting for residential.
What you keep referring to as projections by, quote, BCP for growth are actually NMGC's projections for growth, correct?
I'm not sure. We basically asked during discovery for joint applicants growth, and there is opportunity that could have been distinguished between those two. And so what we had was joint applicants growth.
Would you please go to your exhibit AV-3? It's page 101 of the PDF version of your testimony.
Yep. Yes.
This is the interrogatory response you keep referring to as your basis for the with transaction scenario, correct?
Correct.
And do you know who Mr. Shell, the sponsor of this response, is?
Yes, I know that he's a member of the joint applicants, and that yes.
Do you know who his employer and what his title is?
I'm assuming he works for NMGC. I don't know what his title is.
Okay. And you interpreted this response as stating a scenario where the transaction is consummated distinct from one where it is not?
Correct.
Did you ask for a scenario where the transaction is not consummated?
I would need to go back and check. I'm not sure if we did.
Okay. So what reason do you have to believe that Mr. Shell was speaking as to a scenario where the transaction is consummated distinct from an answer where the transaction is not consummated?
Because we are asking, what is the joint applicant's projected growth? We asked, what are the BCP/NMGC's growth trajectory?
Wouldn't a natural interpretation of that question and the response to it to be that there are not two separate scenarios?
No, I don't think so. I think that things change when you change ownership, especially when you change ownership from a company that has significant climate goals and risks and is in the public markets to one that doesn't have any of those constraints.
So your interpretation is based solely on your understanding of Amera's climate goals as you understand them, irrespective of what was actually in the question and answer, correct?
Not solely. We also asked a lot of questions about continuation of energy efficiency programs and commitments along those lines.
Ma'am. I'm sorry, ma'am. Not solely. Slow down.
Not solely. We also asked about whether the joint applicants would commit to specific energy efficiency commitments and carrying out energy efficiency, to the extent, possible under the caps that are provided by the state, and they wouldn't commit to that. So that also tells us that they are not particularly interested in this topic. They also don't have climate goals for themselves. They don't have climate goals for any of the other natural gas utilities that they have purchased. So it wasn't just that. I think there's other indicators that BCP is not going to have the same type of climate programming that Amera does.
The baseline scenario you describe is one of your creation and not one that NMGC provided you as a
Correct.
baseline in the absence of the transaction, correct?
Correct.
What industry would you define New Mexico Gas Company as being a part of?
They're a local distribution company.
And a local distribution company is not conventionally described as being part of the quote oil and gas industry, correct?
I don't know if I would agree with that. They're downstream. They're a downstream player in the industry.
You testify at page 6, lines 4 to 5, among other places in your testimony, that you believe greenhouse gas emissions from data centers in New Mexico will grow if the PRC approves this acquisition, correct?
That's correct.
Do you believe that emissions from data centers will grow in New Mexico if the commission rejects this application?
Potentially, but not by as much. I can elaborate if you'd like.
So you think it's distinctly possible and how high a likelihood would you assign that data center growth will not take place in New Mexico in the absence of this transaction?
No, data center growth will take place. The question really is what is the source of the energy that's going to fuel that growth? And BCP has made several statements stating that they want to fuel that growth specifically with gas. They've made statements to journalists. They have made several statements on their LinkedIn page. Emera has never made any statements that I could find saying that they want to fuel data center growth with gas.
So would you please assign a likelihood in the absence of the transaction that there will be no emissions growth in New Mexico associated with data centers?
No, there will be some. There definitely will be some, but how much matters.
Is it your understanding that Emera would direct New Mexico Gas Company not to connect a data center customer to the gas system?
I'm not sure. I do know that there's lots of considerations that go into how data centers choose their energy supplier. Because of their huge loads, their potential impact on the grids, and their need to minimize energy costs as much as possible, that data centers do shop around for the best deal, for energy. And depending on how constrained NMGC is, they may or may not be open to hooking up a data center depending on what their own constraints are. But what I do know is that Emera doesn't have a stated goal to fuel the data center growth with gas. They have never said that. BCP has made several statements saying that that's their intention. And that's the difference.
How much investigation did you do as to whether Emera would allow New Mexico Gas Company to connect data center customers?
I didn't really look at that. I assume that in certain cases that they might allow that, in certain cases that they might not.
Do you believe that Emera's sale of New Mexico Gas Company would further Emera's greenhouse gas reduction goals as you understand them?
Oh, yes, it would.
I think that's my time, Your Honor. Thank you.
Well, you had 15 seconds left, but okay, Mr. Dubois.
I'll just leave those on the table. Thank you.
With that, I believe the time reserved for Ms. Fatuli. I just have a few questions for you. I think I understand your testimony, Ms. Fatuli. And you may have answered this in response to Ms. Hopper's question, but so I apologize if it's repetitive. I'm just wondering if who buys gas company if it makes a difference in your analysis of reduction of greenhouse gases.
Sorry, you cut out a little bit. Can you state that again?
Sure.
I apologize.
Does it make a difference in your analysis about who might acquire?
It does. It does, because if another public company that had similar energy efficiency and climate goal record were to purchase an MGC, I don't think that the same concerns would apply. It really matters.
Did you view the information in the application regarding the bidding process and how many actual bidders there were for gas company?
Yes.
So you know there was just BCP, right?
I do.
So what do you think the likelihood is then of some company that might be different than BCP, especially after considering your testimony at page 12, part 3, about the trend of private equity buying gas, that if there is interest in buying gas company, it might just be another private equity company.
Yeah, I mean, with respect, it's not my expertise, like, how utilities are bought and like how they're bought and sold and who might be interested is not exactly my expertise. But I would hope that even if it was a private equity company, that, there are some private equity companies that have climate goals, have energy efficiency, programming, are willing to, work within the policy context on these issues. BCP hasn't indicated that receptiveness.
Did you do any investigation or look at the recently acquired public utilities that BCP did?
Yes, we tried to, but there's no, they're very recently acquired. And so I could find no information indicating any, climate goals, any change in energy efficiency programming. There was no information that was publicly available when I was assembling my testimony indicating how that's going, because I would have been very interested in that.
Do you believe that public gas companies have the opportunity to make significant inroads into the reduction of greenhouse gases, similar to what a public electric utility might make?
Yeah, I mean, first of all, gas companies, they're going to continue to serve industry, right? They're going to continue to serve industry, including data centers for a while to come. And in addition to residential, and they run energy efficiency programs. Like gas companies, have been doing that for 20 or 30 years. So I think that gas companies could essentially extend their demand management and energy efficiency programs to identify customers that are good cases for beneficial electrification.
I'm
and
sorry,
that are good candidates for beneficial electrification. And then they could be compensated by that using the same tools that are being used to compensate them for energy efficiency and current demand management work, such as performance incentive mechanisms, or allowances for sharing and cost savings that are achieved through electrification. And then other parties have testified that gas companies also could pursue things like thermal heat and hydrogen. Those are outside of my areas of expertise, but I know that those are also things that gas companies are pursuing.
Because of, do you agree that public gas utilities offer more limited service than public electric utilities?
Sorry, more limited in what way?
Well, for example, I thought I heard testimony saying, well, you can only use gas to either provide heat or heat up water. But I'm wondering whether or not that, if you believe that gas public utilities offer, that their service is limited to few consumer ratepayer uses, if truly then the potential for greenhouse gas emissions is comparable to a public electric utility.
I see what you're saying. So, so gas utilities, so you can heat a house through gas or electric. You can heat the water in a house through gas or electric. You could make the stove work through gas or electric. Like so I don't see it as limited that way, you know, for residential. In addition, because gas is methane, and because methane has such a higher global warming potential than carbon dioxide, every therm of gas that you reduce has actually a bigger impact, bigger bang for your buck in some ways than when you're reducing electricity, because electricity doesn't generate as much carbon dioxide. So I do think that gas companies have an important role to play in reducing greenhouse gas emissions.
Do you believe that asking any gas company to that, well, I'll say a public utility gas company who's in business to sell gas, to not sell gas is against their fundamental purpose?
Well, we've been telling electricity companies for 25 years that they need to sell less electricity, and we've been paying for that by system benefits charges and performance incentives. So we've
Sorry,
created
ma'am,
a
you are
sorry.
just speaking fast. We've been telling electricity companies for 25 years that they need to
That they need to reduce the amount of electricity that they sell, and we compensate them through performance incentives and through system benefits charges. So I see this as a parallel situation, and not dissimilar to existing gas energy efficiency programs where we are asking gas companies to sell less gas. We're already doing that.
Okay. Very well. Thank you. I appreciate your time.
Thank you, ma'am.
Mr. DeSalen, any redirect for your witness?
I don't think so. No, Madam Hearing Examiner, thank you.
Thank you. Ms. Hopper, any questions based on mine?
No, Madam Hearing Examiner.
Very well. Mr. Dubois?
Yes, Your Honor, briefly.
You want that 15 seconds back. I can see it.
I don't think
Go ahead.
But all right. Ms. Vituli, you were just discussing with Hearing Examiner Hurst your understanding of reductions of sales at electric utilities, correct?
Yes.
Are you aware of programs implemented or requirements directed at electric utilities to prohibit their additions of customers?
No, and I'm not suggesting prohibiting addition of customers. I'm suggesting that the company be more open to beneficial electrification where it makes sense.
Are you aware of electric utilities who have requirements applied to them to discourage them from allowing new customers to connect?
No, there's no reason to discourage customers to connect to an electric utility.
Thank you.
Yep.
Thank you, Your Honor.
Thank you. If there isn't anything further, then with regard to questioning, Ms. Vituli, appreciate your time very much. You're excused.
Okay, thank you very much.
Mr. DeSalen, you have another witness?
Yes, Madam Hearing Examiner, Ms. Lynch will be presenting our next witness. Thank you.
Okay. Mr. Lee, are we ready for our 10-minute break or do we want to wait?
We can wait, Your Honor.
Okay, I've lost real time again.
Well, actually, I could reset my, off the record, I could reset my, internet system. I have no idea what's going on. I'm off the record.
Yeah, why don't we go ahead and take our break now, and maybe you can do that. So I don't know if hearing examiner Schaefer has lost his too.
No, mine's still functioning. Everything's great. Sound, the feed,
Okay.
video, everything's working well on my end.
Well, I can try again.
There's a delay in what I'm doing off the record, but it's coming through. And I can't tell if I've got someone here on case view.
And I just have big gaps.
If I can reset the system and I stay in the file, I should repopulate.
Yeah, why don't we go ahead and take our break? It's almost 3. We'll take a break till 3:10, and then we'll hear from Mr. Price. Remember that the YouTube is on.
Hearing examiner, our witness Jason is in the waiting room.
Yeah. Do you want me to let him in now, or do you want me to let him in 10 minutes? It's up to you. You're muted.
Oops. If you let him in now, then he'll be ready to go.
Okay, there he goes. You might let him know.
Jason, you were admitted and we are on a 10-minute break.
And a live YouTube feed.
Oh, okay.
Mr. Lee,
Judge, let me do one thing here. No, go ahead. I'm ready.
okay. Well, I had it, now it's gone.
Let me try one thing.
I have a little tiny 1-1. But up until right when you logged on, I had it.
You have it now?
No.
I'm going to change to a hotspot, and from there, I don't know why the hotspot is on. Nothing still?
No.
It's coming back in now. Now it says you're connected.
All I have is a little 1-1. Well, I don't want to hold up the,
Repopulate. I just don't know what the issue is. I pay for the best internet money can buy in Santa Fe, at least, but it is what it is.
I'll try logging in one more time. Does not like me today. Let's go ahead, Mr. Lee. Let's go back on the record. Um, and I'll go ahead and make the ruling on CCAE Exhibit 1. There's been an objection to attachments 2, 4, 5, 14, and 16. The objections are on the record previously. They are hearsay exceptions or objections where gas company asserts that there are no exceptions to hearsay. There are also relevance objections made. The responses to the objection is that that CCA believes that the attachments are admissible as under catch-all of hearsay. Additionally, CCAE argues that such exhibits have been admitted in other cases before other tribunals, and with respect to two of the attachments, CCAE asserts that the commission would be able to take administrative notice of them under the commission rules. Based upon my review and my prior rulings, I do not believe that that exhibits 2, 4, 5, 14, and 16 meet any of the exceptions under hearsay. Nor do I believe that they meet the commission's 1.2.2.35D section for administrative rule, a notice of those documents. CCA did not put forth sufficient information on that, and there's been a claim that they are not government documents. Therefore, administrative notice will not be taken. And based upon my prior rulings, CCAE attachment 2, 4, 5, 14, and 16 will not be admitted. Again, the ruling is that it is the witness's testimony, the expert's testimony, that the commission considers, to the extent the expert relies on some type of outside document or study. The witness can testify about that. And the assertion has been that the witness has testified about or has utilized the perhaps the attachments in formulating their testimony. And it's the witness we hear from. It's the witness that can be questioned, and that's the basis of the evidence in the proceeding. It's not a hearsay document that contains things other than what the witness testifies to in their testimony. I believe that the attachments not only are inadmissible hearsay, but they have the potential to confuse the record by including information other than what has been testified to by the witness. Additionally, I think there is also a potential claim that if those documents were allowed in, since the authors of the documents are not present to be cross-examined and to get testimony about, there's potential prejudice to the other parties in the case. Finally, I will note for the record, it is the witness's testimony and opinion about the subject matter that is the evidence in the case. It is not the attachment. With that, CCAE Exhibit 1 without attachments 2, 4, 5, 14, and 16 is admitted. Ms. Lynch, you have a witness.
I do. Thank you, hearing examiner.
Would you
And
call your witness, please?
Yes, you are delayed on my end, just to let you know. So if it's a, jumbled experience exchanging information with me, that's why. CCAE calls Jason Price.
Thank you. Welcome, Mr. Price.
Good afternoon, Madam Hearing Examiner.
Mr. Lee, would you please swear the witness?
Mr. Price, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter and opinion should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Good afternoon, Mr. Price. How are you?
I'm doing well, thank you.
Thank you. Can you please state your name and spell it for the record?
Certainly. My name is Jason Price. Jason is spelled Jason. Price is Price.
What is your business address?
2067 Massachusetts Avenue, Cambridge, Massachusetts, zip code 02140.
And where are you employed?
Industrial Economics Incorporated.
On whose behalf are you testifying today?
CCAE.
Thank you. Have you prepared written testimony for this proceeding?
I have, yes.
I refer you to document marked as CCAE Exhibit 3. Can you identify it, please?
Yes, this is my written direct testimony submitted on September 26th.
Did you prepare it?
I did.
Is it true and accurate?
Yes, it is.
Are there any changes you would like to make to it?
No,
Do you adopt it as your direct testimony today?
I do.
Thank you. Do you have any exhibits attached to your direct testimony?
I do. I have 5 exhibits.
Can you identify exhibit JP1?
That is my resume.
Is it accurate and up to date?
Yes.
Can you identify exhibit JP2?
It's the joint applicant's response to interrogatory CCAE 1-1.
Did you rely on it in preparing your testimony?
I did.
Please identify exhibit JP3.
That is the joint applicant's response to interrogatory CCAE 2-2.
Did you rely on this in preparing your testimony?
Yes.
Can you identify exhibit JP4?
It's a table with the title that's how called Derivation of Cost Impact per Residential Ratepayer.
Can you please describe this exhibit?
It is a table that shows some of my calculations to try to make it accessible and understandable to the reader. It includes 9 distinct columns, year on the left, and then kind of a series of data and calculations to the right for each year.
Did you rely on it in preparing your testimony?
Yes, I generated it for the purposes of this testimony.
Is it accurate to the best of your knowledge?
Yes.
Lastly, please identify exhibit JP5.
It is called Ratepayer Cost Impact Model. It is an Excel file that includes my calculations.
Did you rely on it in preparing your testimony?
Yes.
And is it accurate to the best of your knowledge?
Yes, it is.
With that, we move for admission of CCAE Exhibit 3, including the labeled attachments to Exhibit 3. CCAE now passes the witness.
Oh, hang on there, Miss
Okay.
Lynch.
Thanks.
I also reported that I'm lagging. And IT is going to try to help me.
Okay.
Apparently they're internet users in the building today. Mr. Price, if you were asked the same questions in your testimony today, would your answers be the same?
Yes, they would be.
And if I heard you correctly, your JP4 and JP5 were documents that you created.
That's right. Yes.
Okay. Any objection to what's been identified as CCA Exhibit 3, the revised direct testimony of Mr. Price? Hearing no objection, CCA 3 is admitted. Ms. Lynch, you can now pass your witness.
Thank you. CCAE now passes the witness.
Very well. I believe that gas company has allotted 10 minutes. Ms. Hopper, is this your witness?
It is, Madam Hearing Examiner. Thank you.
Go ahead, please.
Good afternoon, Mr. Price. My name is Juliana Hopper, and I'm an attorney for NMGC and Amera. How are you today?
I'm doing well. Thank you. Good afternoon.
I have a few questions for you. I would like to start on page 2 of your direct testimony, please.
Okay.
And looking at lines 20 to 23, you say, I estimate that the joint applicants planned and expected investments to expand NMGC's natural gas distribution network in the context of a likely reduction in NMGC customers due to New Mexico's ongoing decarbonization efforts will result in additional ratepayer costs, and you go on to the next page, of approximately $90 per year per ratepayer by 2040. Did I read that right?
You did, yes.
And a little further down on page 3, you kind of reiterate that idea a little bit, starting on line 8. And you say the additional capital expenditures expected for the expansion of NMGC's distribution network will increase costs per residential ratepayer, again, particularly in the context of a declining customer base as New Mexico electrifies home heating to meet its decarbonization goals. That's your testimony?
Yes, it is.
And both of those statements reference New Mexico's decarbonization goals, right?
They do, yes.
By those decarbonization goals, I think you are largely referring to the governor's executive order number 2019-003. Is that right?
I believe so, yes. I referenced the executive order in my testimony. Yes, that is the correct number. Yes.
And your opinion is that due to the goals in that executive order, it is likely that NMGC will lose customers, right?
The goals and the implementation of those goals, yes.
That executive order was issued in 2019, was it not?
I believe it was, yes.
And 2019 was about 6 years ago, is that right?
By my accounting, yes, it was.
And since 2019, NMGC has continued to experience annual customer growth. Isn't that right?
I know it's added new customers. I don't know what its net customer total has been offhand.
Well, if we look at page 6 of your testimony, can you let me know when you're there?
I am.
Starting with the question on line 1, the question is, how do these plans compare to NMGC's historical customer additions? And the answer you state is, these plans are within the range of annual customer additions for the years 2020 through 2024. During that time, NMGC has experienced annual customer growth of between 1,308 and 6,166 customers per year, according to a discovery response that you cite. Is that correct?
It is, though. You were asking me before about the total number of customers. These were, as I understand it, let me look at this. I want to look at the interrogatory real quick, if that's okay. These are the JP3s. 6,100. Yeah, as I understand it, it's my interpretation of this interrogatory response, as I summarized in my testimony, was that these were new customer hookups, not accounting necessarily for customers who may have left the system.
So do you know if NMGC has experienced much in the way of customer loss?
I don't offhand know.
So you know they've added, but you don't know if they've lost, and yet you're opining that the customer base is going to decline.
That's right, I am, because there's a question of timing. The executive order, as you said, was signed in 2019. The implementation of an order like that and the large effort to decarbonize the home heating system does not just happen in 6 years. It takes time to implement, and so as technology improves, as policies change, you see different trajectory going forward. Wouldn't necessarily be the same as it was over the last 6 years.
But you agree that the company has added customers since the executive order has been in place, correct?
It has signed on new customers since it's been in place, yes.
And you don't have any projection of when it will begin losing customers due to the implementation of the executive order, is that right?
Well, I do include projections in my testimony of the likely downward trend in customers due to decarbonization of the home heating system across the state.
Are those based on any data provided by the company?
Those are not based on data provided by the company, no.
Mr. Price, on page 7 of your testimony, line 8. The question there is, would NMGC investment expenditure in new capacity necessarily be the same under BCP ownership as under Emera ownership? And the answer you provide is no. Decisions regarding expansion of the NMGC distribution network are at the discretion of ownership. Is that right?
You read that correctly, yes.
Mr. Price, have you ever worked for a utility before?
I have not.
Have you ever worked for a utility holding company?
No, I have not.
Have you talked to anybody at NMGC about who currently makes decisions regarding expansion of the NMGC distribution network?
No.
Have you talked to anybody at Emera about who does that currently?
No.
Have you talked to anybody at BCP about who might make those decisions if the transaction goes through?
I have not, no.
Further down on page 7, starting on line 13, you're responding to the question, is there any reason to believe that expansion of NMGC's network may be more significant under BCP ownership than under Emera ownership? And you conclude that paragraph, that answer, with the sentence, considering these differences and the increase in GHG emissions that would likely result from NMGC network expansion, Emera would likely make more limited investments in network expansion than BCP. Is that correct?
That is correct.
So based on that, in your opinion, if the gas company expands at all, it's likely to increase GHG emissions. Is that correct?
Correct, yes.
And that's your opinion regardless of who owns the company, isn't that right?
It is my opinion that they would, if they bring on new customers, greenhouse gas emissions would increase. It's a question of how many customers would be brought on under different ownership groups.
But if gas company added that same amount of projected customers under Emera ownership, you would say that would be bad as well, correct?
It would have the same greenhouse gas effect, yes, assuming that there aren't other measures taken to, for example, electrify other existing customers. There's the addition of customers, but then there's also what else are they doing otherwise to reduce their greenhouse gas footprint?
But generally what you're really opposed to is NMGC expanding, isn't that right?
I don't express any opposition at all. My testimony is just stating what the estimated impacts are of expansion.
But you recommend that the commission deny the transaction based on that analysis, isn't that right?
I don't believe that I do.
Okay. So growth plans aside, you don't have any reason to oppose the transaction, is that right?
I neither support nor oppose the transaction. I was asked to provide an analysis of what the effect would be on ratepayers, and that's what I provided in my testimony.
All right, I have no further questions, Madam Hearing Examiner.
Thank you, Ms. Hopper. I believe that BCP applicants have reserved 10 minutes for questions for Mr. Price. Ms. Hardy?
Yes, Madam Examiner, I do have a few questions.
Go ahead, please.
Thank you. Good afternoon, Mr. Price.
Good afternoon.
I'm Dana Hardy, and I represent the BCP applicants.
Nice to meet you.
Nice to meet you. Ms. Hopper asked you a question about your direct testimony at page 7, starting at line 13, I believe, and I had a question about that testimony as well.
Sure.
Okay, and so starting at line 15 through really 19, you state that you believe expansion of New Mexico Gas Company's network may be more significant under BCP ownership than under Emera ownership, correct?
Correct.
And the reason you provide for that opinion is that Emera has published a climate transition plan and a net zero greenhouse gas emissions goal, right?
That is what I just described there, yes.
Okay, and you're stating here that BCP has not published a climate transition plan or made any greenhouse gas commitments, right?
To my knowledge, that's correct.
Okay. And did you listen to Mr. Baudier's testimony during this hearing?
No, I did not.
Okay. So you don't know whether he talked about BCP's decarbonization goals, correct?
I do not know.
Okay. And your analysis of potential expansion relies on the joint applicant's response to CCAE's interrogatory number 1-1, which is attached to your testimony as exhibit JP2, correct?
Correct.
Okay. And if we go to that interrogatory response, please.
Yes, I'm there.
Okay. It is provided by Mr. Ryan Shell, correct?
It is, yes.
And Mr. Shell is the president of New Mexico Gas Company, correct?
I believe that is correct, yes.
Okay. And looking at the response, there is only one forecast, right?
Correct.
The response does not include a separate forecast for growth under Emera ownership versus BCP ownership, does it?
It does not. No, the response does not.
Okay. Okay. And the question doesn't ask what the forecast would look like without the transaction, does it?
No, the question asks what are, looking above, what are BCP's plans for adding new facilities, new customers during this period? Question does not ask that. Ask about
Okay.
Emera.
right? And it doesn't ask whether the forecast would be different without the transaction, right?
No, it does not. I was considering kind of, what constraints the different companies have put on themselves, to the best of my knowledge, and what that would imply about their strategy going forward about customer acquisition.
Okay. And then if we go back and look at page 5 of your testimony, you are discussing there the projections of new customers between 2026 and 2030, right?
You said you're on page 5?
Yes.
Yes, I'm there.
Okay. And you're talking about the projections of new customers between 2026 and 2030?
Yes.
Okay. And then at the top of page 6, and I'm looking at lines 2 and 3, the question is, how do these plans compare to New Mexico Gas Company's historical customer?
How do
the plans compare to New Mexico Gas Company's historical customer additions? And your answer states these plans are within the range of annual customer additions for the years 2020 through 2024, correct?
That's true, although if you look at that, the actual data that are provided in the interrogatory response, where those numbers come from, it is overall a downward trend during that time. And then also the average projected going forward by, in response to the interrogatory about BCP and MGC expansion going forward is higher than it was during the latter part of that time period.
But when you look at the entire time period provided 2026 through 2030, you're still stating at the top of page 6 that the plans are within the range of annual additions for the past 4 years, correct?
I do state that it's within the range, but the range also, the high end of the range is during the early part of that time period.
Okay.
It declines over time, leading up to 2025.
As a regulated gas utility, New Mexico Gas Company is obligated to provide safe and reliable gas service to customers in its service territory, correct?
Of course, yes.
And are you aware of any New Mexico Public Regulation Commission decisions that allow a utility to refuse to connect a customer to reduce emissions?
To refuse to connect to control? No, I'm not aware of that. And I wasn't suggesting that there'd be any refusal of connection. It's just a question of there's a difference between passively bringing on new customers who request to be brought on versus actively pursuing new customer acquisitions.
And New Mexico Gas Company's obligation to serve customers applies regardless of who owns New Mexico Gas Company, right?
That is correct.
And regarding your discussion of capital investment in the distribution system and the cost that would result to customers, isn't it true?
Are you on that same page 6?
No, this is just a question more generally about your testimony.
Okay.
Okay. Because you talk about that, correct?
I do, yes.
Okay. And isn't it true that any investment in New Mexico Gas Company's distribution system would be reviewed by the commission for prudence in a rate case?
Yes.
And that's true regardless of whether Emera or BCP own New Mexico Gas Company, correct?
That is correct, yes.
Thank you. Those are all of my questions.
Thank you, Ms. Hardy. I believe that's all of the cross-examination that was scheduled for Mr. Price. I just have a couple of questions for you, Mr. Price.
Okay,
Good afternoon.
Good afternoon.
I understand when you provided your testimony was at the end of September, correct?
Yes, on the 26th, that's right.
And have you been aware of any of the changes with regard to the commitments that have been made by joint applicants, either in their rebuttal testimony or in their testimony live here?
I'm not familiar with the details, no, Your Honor.
One of the I believe that one of the commitments that was made in the I thought it was made in the hearing, but I don't see it in bench request 3. Yeah, it was. It's in 1. Are you aware of how gas company currently maintains its capital investment plan?
How it maintains its plan?
Well, yes, or how they well, let me ask you specifically. Are you aware that gas company utilizes a 5-year capital investment plan?
Yes.
And the way it was described to me during the testimony, I think from Mr. Shell, was that every year, like a new year gets added, so it's like a rolling 5-year plan. Is that your understanding?
I knew it was a 5-year plan. I didn't know that they had updated every year, but I would certainly, that would make a certain amount of sense.
Okay. And during the hearings, as evidenced by joint applicant's response to the first bench request, one of the things that joint applicants committed to was to, at a minimum, maintain that current 5-year capital investment plan. And that commitment was going to replace that minimum 3-year rolling average for depreciation, etc. Were you familiar that they agreed to the gas company plan and ditched the 3-year commitment that they already had?
No, it was not.
Well, now that you know, does it make any difference as far as your testimony projections about what's going to actually be utilized for their network, or does it just reinforce your projections about what's going to happen?
Yeah, I don't know that it would change my conclusions, Your Honor. It's a change in practice in terms of how they maintain their forecasts. It's not any commitment about how actively or inactively, they'll pursue new customers.
And is that the main driver for you? Is how they're going to pursue, or is it how much they're going to put in the ground?
It is how much they're going to pursue and spend. I mean, in the context of decarbonization, if they are spending a lot of money to put additional pipes in the ground for new customers, and while those new customers are joining more or leaving, that's going to leave kind of higher costs for the ratepayers that are left behind. And so if they are if they would commit to limiting new customers to those who specifically request, as opposed to pursuing new customers, that would be one thing. But if they're just talking about changing the way that they maintain their forecast of what new customers are and what they'd be spending, that while a nice gesture, wouldn't really change the conclusions I draw in my testimony.
Judge, can I have a minute?
Yes, Mr. Lee.
It's frozen.
While Mr. Lee is doing what he's doing, Ms. Lynch, has my lag sped up?
Actually gotten better, Your Honor.
I think IT is going to charge me. I think they said I got to be in front of traffic. I don't know what that means. If I have to go stand out on Cerritos Road, or
Hopefully not, Your Honor.
Well, we seem definitely to be encountering internet problems in our hearing today, at least in Santa Fe. I think last week the internet problems were in Albuquerque. And I believe in Scotland, the first witness was encountering some internet problems. Ms. Nanasi, we're waiting for a court reporter. Welcome.
Thank you. That's why I wanted to ask you. I don't know if you had a chance to look at what I filed for Jesse George's revised New Energy Economy Exhibit 2, but I was hoping that that met your requirements.
I referenced this at the beginning of the hearing this morning, that we needed to attempt to try to get these exhibits in as ordered, as expeditiously as we could. I cannot say, essentially, this was in response to Ms. Beatles and the first witness this morning. That basically we're just trying to make this as understandable as we can. And if you want, as I explained yesterday, to put a note on the front of the testimony that indicates that certain exhibits were not admitted, and so that the reader knows, and then do a strike through if it says something like Exhibit 5 attached, and if it's attachment 5, and attachment 5 was not attached, then that will let your reader know.
I'm doing that for the Sandberg testimony, but I just wanted to know if you had looked at the George testimony and made sure that it was followed your instructions, which I think it did.
Honestly, I can't say at this point, Ms. Nanasi, that I did. But after getting instruction from our court reporter that we need these exhibits in on the day that they're admitted, then, you know, I basically asked people to be as efficient as they could. I also made a clarification, and for YouTube, this is all off the record because we don't have our court reporter right now, but just for your benefit, I will say briefly, and you can see the extent of my ruling this morning, again, in response to Miss Beatles, and then later after I talked to Miss Beatles, but or answered her clarification. I made it clear for the record that the rulings that I have on attachments are not on the testimony themselves. The witness's testimony and the references to hearsay inadmissible documents and the reliance that the witness places on some type of document. That's the evidence. That's the important part that the commission considers. An inadmissible attachment is what I'm referring to as not being evidence. So, okay, there just seemed to be, as I indicated earlier this morning, there seemed to be some potential confusion I wanted to clear up with Mr. Yar's characterization of the attachment as evidence, and or that the evidence was being excluded. It's like, no, the reference to the evidence, to the attachment, is not the evidence. It's the expert's opinion. The expert's opinion is being considered as evidence in the record. It's just the attachment that's not it's inadmissible hearsay. So with that off the record clarification, for your benefit, Ms. Nanasi, we have our court reporter back. Mr. Lee, we're okay?
Yes, ma'am.
All right, sir, let's go ahead and I was talking with Mr. Price. Can you bring me back my question? My real-time fried again.
Yes, Judge. You asked if he was familiar that they ditched the 3-year commitment. And then I have, now that you know, does it make any difference as far as your testimony projections about? And then it froze.
Okay. About the potential impact on the New Mexico gas ratepayers.
So, are you going to rephrase the question, or shall I respond, Your Honor?
No, you can go ahead as you understand the question, sir.
Okay. As I understand it, I believe you're asking, Your Honor, whether that change in practice in terms of their rolling capital expenditure forecast would change my conclusions, and my response is that it would not. The change in projection methodology and practices is not, that's separate from their strategy for customer acquisition. So if they were to commit to, for example, limiting new customers to those who seek service as opposed to actively seeking service, the utility actively seeking service, that would be one thing that might change my conclusions. But if they're just changing their methodology for and their how long, excuse me, over what time horizon and how frequently they are updating their projections, that would not change my conclusions.
Mr. Price, would you say that you're an economist by trade?
For the past 23 years, my work has been in economics, yes.
As opposed to, but you also include disciplines of accountants and regulatory policy, right?
Correct.
Are you familiar with economic opportunity and incentives in the state of New Mexico?
Broadly speaking, yes. I don't know if you're referring to something specific.
Well, what I'm wondering, and you can tell me if you know, and again, my policy is if you don't know, I don't know is a fine answer. But it appears that with some of these economic incentive proposals, even in this case, as well as legislation regarding economic incentive to come to the state, that when one considers perhaps a policy of trying to get more business into the state, that reduction in utility expansion might be contrary to that goal. Do you think?
If certainly constraining it to put a limit on and to just not allow new customers who seek service to obtain such service, I think that would be counter to that. But I would say, like any aspiring business owner that seeks to open a business and use natural gas and request service from NMGC, NMGC, as I responded in my response to a question earlier, is obligated to provide such service. And I think any business that wants to move to New Mexico and is determined to use natural gas as its energy source and request such service, obviously there's an obligation to provide that.
Well, so you don't see the potential trying to get business opportunities in the state. You don't see that as contrary potentially to reduced infrastructure in public utilities that might actually be trying to serve that new business.
Well, I think as the thrust of my testimony gets at, if the utility is spending money on new customers that aren't necessarily seeking new customers and spending money to hook up those customers, and as the overall customer base declines, that will have adverse impacts on ratepayers in terms of what they're paying, because those fixed costs of the system would be spread over fewer customers. So if I were a business owner in my local utility, we're spending a lot of money on expansion, and the
I'm
context.
sorry.
I'm sorry, Mr. Lee. I can put that in. Sorry, where did I?
If I were a business owner and my
If I were a business owner and my local utility were spending a lot of money on customer expansion in the context of the overall customer base declining, that's going to have an adverse impact on me more than it would otherwise, because those additional costs are spread over a smaller number of customers. And so I'd want to be sure that the utility is using those funds judiciously and is not burdening me as the business owner with those additional costs.
And with regard to your testimony, sir, beginning on page 16, with energy burdens for low-income households,
Yes.
do you believe that it's the individual public utilities' responsibility to separate out certain classes of customer and provide special benefits for them?
Whether it's an obligation for the utility? Sorry, is that
Yes,
the word?
sir.
No. Well, certainly there's there is, and I don't know what the law is in New Mexico. Obviously, if laws or regulations require that, that is done. I think that as a matter of social policy, it's certainly sometimes appropriate to do that. I know, other states where I've worked, there are different, if not rate classes for different customers, there are different programs, for example, for low or middle income customers. And so that, that state government has decided as a body, or the commission in that case, to do that. But whether it's an obligation or not, there's a legal question there versus what society should do. And I certainly am not adverse to, society trying to help out some of those lower income customers.
But it's your testimony, if gas company were to refrain from investments, this is at page 20. You're answering the question posed at line 19 on page 19. What options exist for minimizing or mitigating these impacts to low-income ratepayers? Your answer beginning at line 1 on the page 20. If gas company were to refrain from investments in expanding its distribution network, low-income ratepayers would avoid these impacts.
Correct.
So, correct?
Yes.
And then you say, beyond this, gas company has significant flexibility to minimize energy burden impacts to low-income customers, as the recently House Bill 91 states that nothing shall prohibit the commission from approving utility rates and programs designed to reduce the burden of energy costs on low-income customers. That's your testimony, sir?
Yes, it is. It's merely pointing out here that there are tools at the commission's disposal that if it so chooses to reduce energy burden impacts on low-income households.
And then you go on to say other potential strategies for minimizing energy burden impacts to low-income households include gas company capping rates for these households at current levels without shifting costs to other ratepayers. And gas company voluntarily excluding capital expenditures on its distribution network expansion from its rate base. As to that second one, you think they're going to voluntarily not seek costs?
No, but I was just merely trying to point out here, Your Honor, that there are options that the NMGC could take upon itself if it so chose. It doesn't necessarily need to be excluding costs from its rate base, but if there are other things that it wants to do to help out low-income customers, they have the option to do that.
And I guess I'm not understanding, how is it if if gas company capped its rates for certain households, that wouldn't shift cost and create subsidies among its other ratepayers?
Well, it depends if they try to absorb those costs through, well, I said without shifting costs to the ratepayers. So the implication there is that it's basically the shareholders bear that burden then.
Oh, okay. So in both of your examples, gas company's gonna is basically going to absorb and subsidize that ratepayer class.
In these examples, yes, Your Honor, that's correct.
Okay. Thank you, Mr. Price. I appreciate that. Ms. Lynch, any redirect for Mr. Price?
Yes, I do have a few questions.
Go ahead.
Okay, Mr. Price, could you please turn to page 7, lines 10 through 12? Let me know when you're there.
I am there.
All right. Can you clarify what you meant by discretion?
Which line are you referring to specifically there?
11.
Thank you. So what I meant by that is that although any gas utility, including an MGC, is obligated to bring on new customers to request service, you know, it's at its discretion how much it wants to actively pursue new customer acquisitions versus just passively doing as it's obligated to, and hooking up new customers who request service. It's at its discretion how actively it wants to put incentives in place, market its services to new potential customers who may switch from their existing fuel source to natural gas.
Okay. And I just want to clarify, when we've been describing you, we're actually describing CCAE. So you're answering on behalf of CCAE, correct?
Correct.
Okay. Are you or CCAE opposed to all New Mexico Gas Company expansion?
To all expansion? No.
Were you present during WRA's witness Michael Kenny's testimony?
For most of it, but not all of it.
So you heard some of the recommendations that he provided for the company to expand its service?
Some of them, yes. Yes, there is this. Yes.
Particularly geothermal or thermal?
Geothermal, yes. And so I remember there was a discussion about replacing infrastructure and the like. Yes.
Okay. So do you recommend that the commission deny this transaction solely because of New Mexico Gas Company expansion?
No.
Thank you. What is the significance of the effect of continued growth of service without mitigation of greenhouse gas emissions on ratepayers?
Without mitigation of, so do you mean without mitigation by the utility or just kind of for the state?
You can both. I mean, primarily the utility in this instance, but you could speak to both.
I mean, if the utility is expanding rapidly, and doesn't feel like it doesn't, if it's expanding rapidly to sign on more customers than it would if it were trying to limit its greenhouse gas footprint, the impact on ratepayers would be higher than if it didn't.
Do you want to expand on that at all?
So basically, as I described in my testimony, and I think in the section that we were just discussing, if the utility is not incentivized, through its ownership, to limit its greenhouse gas footprint, in my opinion, it will feel less constrained to seek new customers, even though those new customers, would increase its greenhouse gas footprint. The effect of that on customers of customers in the context of a declining customer base, though, is that that would be they'd be spending a lot of money that then gets spread out over a smaller customer base overall over time, as other people within the current customer base transition away from natural gas.
Okay. With that, I thank you, Mr. Price. If you have any further questions, hearing examiners, you're free to ask them.
Thanks. Ms. Hopper, any recross?
Nothing for me, Madam Hearing
Very
Examiner.
well. Ms. Hardy, any recross?
No, thank you, Madam Examiner.
Very well. Mr. Price, thank you again. You're excused, sir.
Thank you.
Ms. Lynch, you have one more witness for in the morning?
Yes, she'll be available in the morning.
Very well. I believe then we, based on the order of witnesses, and I see that Mr. Etheridge is in the Zoom. So I will admit him. Mr. Freeman, you have a witness, sir.
Yes, Your Honor. FEA calls Dwight D. Etheridge.
Good afternoon, Mr. Etheridge. There you are. Hello, sir. You just need to unmute yourself.
Mr. Etheridge in the lower
Got it.
left hand.
There he is.
Thanks, Mr. Lee.
Hello, sir.
Hello. Good evening.
Good evening. Mr. Lee, would you please swear the witness?
Mr. Etheridge, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter and opinion should be the truth, the whole truth, nothing but the truth.
I do.
Thank you, sir.
Thank you. Go ahead, Mr. Freeman.
Mr. Etheridge, can you please state and spell your name for the record?
Certainly. My name is Dwight D. Etheridge. First name D-W-I-G-H-T. Middle initial D. Last name E-T-H-E-R-I-D-G-E.
Sir Etheridge, who are you employed by?
I'm employed by Exeter Associates, Inc., an economic consulting firm, and I am a principal and vice president with Exeter.
And in what capacity are you appearing in this matter?
I'm appearing on behalf of the federal executive agencies.
I believe you have in front of you what is labeled as FEA Exhibit Number 1. Do you recognize that?
I do. This is my direct testimony filed on September 26th in this case.
Are there any attachments to the testimony?
There are attachments to the testimony, and they are labeled on Roman numeral 2 or page Roman numeral lowercase 2. And there's 3 attachments: FEA Exhibit DDE 1, DDE 2, and DDE 3.
Was this testimony and exhibits prepared by you or under your direction?
It was.
Are there any changes or corrections you would like to make at this time to your testimony?
There are, and there's just a few. I would first like to direct the parties to page 4 of my testimony. And that's not PDF page, it's the page in the lower right, page 4 and line 17. For the sentence that, incomplete sentence that begins, then by an Amerisubsidiary subsidiary included a higher level of rate credits. After rate credits, please add the words adjusted for inflation. So it reads rate credits adjusted for inflation. My next change will be after the qualifications that are attached to my testimony. And I'll wait for a moment.
And for that, can you give the PDF page?
Mr. Freeman, I don't have the Zoom file open at the moment. Or not the Zoom, but the Dropbox, kind sir. But again, it's at the end of my qualifications. If you page to the back and just move forward through the 3 exhibits, you'll get to a page that has effectively a table of contents of the exhibits. At the top, it will say exhibits with the direct testimony of Dwight D. Etheridge. At the bottom of that page, there's extraneous references to attachment DDE-XX, 2 of them. Both should be deleted. The last 2 quick changes are in the labeling of FEA exhibit DDE3. I noticed a while ago that page 1 of 4 of DDE3 is incorrectly labeled DDE-2. It should be changed to -3, and the same is true for page 3 of that exhibit.
Are those all the corrections you have?
Just 2 more. Finally, at the very end of the exhibits, in the document that was filed, there were 2 extraneous references to FEA exhibit DDE4 and FEA exhibit DDE5. Both should be deleted in their entirety, those pages, including the exhibit and the reference at the top. And that is the end of my changes, Mr. Freeman.
With those corrections, if I ask you the same questions today as included in your testimony, would you provide the same answers?
I would.
And would those answers be true and correct to the best of your knowledge or belief?
They would.
Hearing Examiner Hurst, I move for the admission of what I recently put into the Dropbox, FEA Exhibit 1, the corrected direct testimony of Dwight D. Etheridge with the attached exhibits.
Any objection to what's been identified as FEA Exhibit 1, the corrected direct testimony of Mr. Etheridge as he has affirmed here?
And hearing examiner, I have just something briefly.
Mr. Etheridge?
The document that I provided to Mr. Freeman and that he added to the Dropbox did not include the 2 small changes that I found thereafter, where I want to change DDE-2 to DDE-3 on 2 occasions. So that's the only correction to the document that was uploaded to Dropbox.
Have you got that, Mr. Freeman?
Yes, I will make that correction and re-upload.
And I just need some clarification from you. About your exhibits, Mr. Etheridge, what you have included in your DDE-1. Did you create those 4 pages?
I did not create those 4 pages, Your Honor. I downloaded those from the source that is referenced at the bottom of each page.
And chose to put them into one exhibit?
That is correct. Referencing 4 different LDCs in order as I described in my testimony, and LDCs is local distribution company.
And what about for FEA Exhibit 2?
FEA Exhibit 2, similarly to FEA Exhibit 1, is where I've taken a single page from the 4 LDCs that from their webs or from an investor presentation for each of these 4 LDCs and put it into Exhibit DD2, and I use it to describe the capital investment discussion in my testimony by referencing other LDCs.
And with regard to DDE3?
And with regard to DDE3, I discuss in my testimony the concept of other potential suitors, creating long-term value for New Mexico Gas Company and its customers. And in doing so, I looked at the same 4 LDCs, local distribution companies, website, or rather investor presentations, and downloaded a single page from each that I felt facilitated the discussion of, in my testimony, of alternative suitors and creating strategic value for New Mexico Gas Company's customers.
And the information that you took from each of those pages that you downloaded from somewhere, you've indicated that you discussed that in your testimony and that you relied upon it to form your expert opinion?
That's correct. For example, if I'm forming my opinion on other potential suitors, I want to know the geography of LDCs. So I selected 4 in the area, in the Midwest, the South area, near to New Mexico Gas Company, and also the West with Southwest Gas. So I find the geographic representations I was able to find as valuable to me. I also
And did you discuss that in your testimony?
I did discuss in my testimony.
You discussed the information that was contained in what you downloaded in your testimony, correct?
I discussed the information in the exhibits in my testimony. Some I explicitly referenced, some I did not.
Very well. Mr. Freeman, I'm going to take FAA Exhibit 1 under advisement. At the outset, I can tell you, pursuant to my earlier rulings, regarding inadmissible hearsay contained in attachments, and the fact that the witness did not create these documents, but that these documents and the authors of these documents are not available to be questioned here. And based upon the fact that the witness has indicated that he has gleaned the information from the documents, relied on it to form his expert opinion, and that is included in his testimony, I am inclined, pursuant to my rulings with regard to the other parties' attachments in this case, to deny admittance of FEA and Mr. Etheridge's attachments that he did not create himself. Do you have a response, Mr. Freeman?
Yes, Your Honor. I think one of the things we looked at is that we didn't include the whole document and just the excerpts for what we were relying on in those excerpts. I think the other thing is, we've been listening to the rulings you've been given on some of these exhibits. One of the things that we tried to do in creating our testimony was to make the narrative form of the testimony readable and understandable. Now, Mr. Etheridge could have, within the testimony, dedicated lots of space and time to these excerpts that we attach, and put the tables in there and recreate that. But for ease and readability of the testimony, Mr. Etheridge chose to refer to them and explaining why he's relying on them, and then to attach them so they make sense in context. I would say if the hearing examiner did decide to strike the attachments, FEA is worried that it would not make total sense of what we are relying on without those attachments.
What do you say? Thank you, Mr. Freeman. I will, I will look at the attachments in again, but again, I'm trying to be fair to everybody. And, your witness didn't create these documents. And as opposed to, for example, some of the attachments that have been included today, where the expert witness actually created the attachment to the testimony, and he could be questioned on that attachment. Whereas these attachments that I believe your witness says that he downloaded, they can't be. So I'll think about it, but I think the optimal thing, as I have indicated on more than one occasion today, is that the commission looks at the sworn testimony, and the parties should be making their case in the testimony. Okay, the expert witnesses should be making the case in their testimony and not relying on some attachment to the testimony, unless, for example, again, that attachment is some kind of study or research document that they put together that supports why they're testifying the way that they are. So I'll think about it, Mr. Freeman. But again, I'm leaning toward being consistent and excluding those 3 attachments. Go ahead, sir.
Mr. Etheridge, you also have in front of you what is labeled as FEA Exhibit number 2. Do you recognize that?
I do. It's my rebuttal testimony that was filed on October 10th, 2025.
And are there any attachments to that testimony?
There are attachments to this testimony. They are FEA Exhibit DDE-R-1, which are excerpts from New Mexico Gas Company's annual supply plan, and FEA Exhibit DDE-R-2, which is proposed extraordinary cost recovery following the winter storm Uri. So it is information taken from a New Mexico Gas Company document.
Was the testimony prepared by you or under your direction?
It was.
Are there any changes or corrections you would like to make at this time to that testimony?
No.
If I ask you the same questions today as included in your testimony, would you provide the same answers?
I would.
And would those answers be true and correct to the best of your knowledge or belief?
Yes.
Hearing examiners, I move for the admission of FEA Exhibit number 2. That's the rebuttal testimony of Dwight D. Etheridge.
Any objection to what's been identified as FEA Exhibit 2, Mr. Etheridge's rebuttal testimony as verified by him here today? I'll take FEA Exhibit 2 under advisement with regard to the exhibits for the same reservations I've already expressed. Mr. Freeman?
I tender the witness for cross-examination.
Very well, sir. Thank you very much. I believe gas company reserved 20 minutes for Mr. Etheridge. Ms. Hopper and Mr. Haverly.
Madam Hearing Examiner, this is Brian Haverly. You are correct. We did reserve that time. And so if it pleases the commission and the hearing examiners, I would like to begin my cross.
Go ahead, sir.
Thank you, madam. Hello, Mr. Etheridge. How are you doing this afternoon?
I'm doing well, Mr. Haverly.
It's wonderful. Can you please turn to page 4 of your testimony? Direct.
Yes, I'm there.
Okay. On line 6, there's a question posed. Please summarize your position on the joint applicant's proposal for Saturn to acquire NMGC. Do you see that?
I do.
Did I read that question correctly?
Yes.
Okay. Part of your answer, going down to line 18, and the sentence begins, in addition. Do you see that?
I see the in addition on line 18, correct.
Would you please read that sentence for the record?
Certainly. In addition, from my perspective, Saturn represents a riskier possible parent company for NMGC compared with other potential suitors with deep expertise operating utility companies, particularly natural gas local distribution companies, in quotes, LDCS, end of quotes, period.
Thank you, sir. Would you please go to page 8 of your direct testimony?
I'm there.
You have a table there labeled Table 1. Do you see that?
I do.
And the table is labeled Natural Gas Local Distribution Companies. Do you see that?
I do.
And Mr. Etheridge, I just want to make sure I understand, are these some of the other possible suitors listed in this table that you were referencing in the segment of your testimony we just discussed?
Yes, these 4 LDCs that we discussed earlier regarding my exhibits were companies that I did primary research on to think about this case and to formulate my opinions.
And the first one you list here is Atmos Energy Corporation in that table. Is that correct?
It is.
And you state that Atmos has 3,300,000 customers. Is that correct?
Yes.
And that it operates in a number of states, including Colorado and Texas. Is that correct?
Yes.
And you state that, or strike that, is it your understanding that Atmos Energy is the largest local distribution company in Texas?
You may have read it. It sounds very familiar. Shall I go back and check?
If you turn to page 9 of your testimony, Mr. Etheridge. Lines 1 through 4.
Yes, it says on lines 3 and 4, it is the largest LDC operating in Texas.
And that's your testimony, sir?
That's my testimony.
And you believe it to be true and accurate?
I believe it to be true and accurate.
Thank you, sir. You also, going back to table 1 on page 8, you list Southwest Gas Holdings. Is that correct?
Yes.
And you have Southwest Gas Holdings as having 2,300,000 customers. Is that right?
Correct.
And is it your understanding that Southwest Gas is the largest LDC in Arizona?
Yes, I write on page 9 of my testimony, line 6, it is the largest LDC in both Arizona and Nevada.
You also, going back to table 1, you have listed One Gas Inc. Is that correct?
I did, yes.
And you list that they have 2,265,000 customers. Is that right?
Correct.
And you list that One Gas, or let me ask you this way. Do you know whether One Gas is the largest local distribution company in Oklahoma?
Yes.
Thank you. And finally, on table 1, you list Spire Inc. Is that correct?
I do.
That's one, and they have 1,700,000 customers according to your table. Is that correct?
Correct.
Mr. Etheridge, isn't it correct that Atmos Energy did not submit a binding offer to buy New Mexico Gas Company from Emera?
That's correct, because there was only one that submitted a binding offer, as we all know in this case, and that's the BCP applicants.
So it's correct that Southwest Gas also did not submit a binding offer to buy New Mexico Gas Company?
And you and I cannot be sure why they didn't, but the answer is correct.
And that would also be true of One Gas. Isn't that true?
My answer would be the same as I just gave.
And for Spire as well? Sorry.
I'm sorry, the name of that company, Mr. Everly?
That would be Spire, S-P-I-R-E, Mr. Lee. And Mr. Etheridge, I thought you were done with your answer. I apologize. Please continue with that answer.
No, that's quite all right. For every one of the 4 LDCs, I do not know why they weren't selected, because it's a confidential process. But correct, we only have one left. That was BCP, and it's unfortunate. Only one was left from the solicitation.
Do you believe that JP Morgan and Emera simply failed to contact the largest LDC operators in 3 of the states that border New Mexico to determine if they were interested in expanding into New Mexico?
Of course not.
Let's move to page 14 of your testimony, Mr. Etheridge. Let me know when you get there.
Yes, I'm there.
Question posed on line 13. Is joint applicants' proposed per customer allocation of rate credits an equitable form of rate design in this case? Answer on line 15, no. That's your testimony, correct, sir?
It is.
And just to clarify, you would prefer a rate credit allocation similar to the one used in case number 13-00231 UT. Is that correct?
I recommended that the commission in this case allocate the rate credits as they approved in the 13 merger case. And that involves 2 steps. The first important step is to allocate, as I've testified, based on base revenues by class from the prior rate case. Now, this has been mischaracterized by 2 witnesses in this case, Mr. Baudier and Mr. Schell. We are not, as FEA, nor did the commission approve in the 13 case, a volumetric allocation of the rate credits to the rate classes. That's simply false. So what I testified to in this case and what I recommended is step 1, you allocate the rate credits to the rate classes based on class by class base revenue requirements. Having completed step 1, now we need a rate because a rate has to go into a compliance filing. And for each rate class, after receiving their share of the rate credits, you divide by terms for that class and you get a rate. And that's exactly what happened in the 13 merger case, exactly what I'm proposing in this case, and it's extraordinarily equitable in terms of the share of the rate credits that go to residential and small general service customers. In the last case of the 13 merger, I heard about 94% was in the stipulation or certification of stipulation. But per capita would be 99+%. Effectively 0 for all other rate classes. That's not equitable. It doesn't reflect risk going forward of upward pressure on rates. And from my perspective, it's simply improper rate design. So again, just let's be perfectly clear. There's no volumetric allocation of rate credits proposed by any party in this rate class or in this case.
Mr. Etheridge, should I ask you about volumetric distributions?
You may not have, but regardless, I wanted to touch on something because I wanted to clarify that we have 2 witnesses that spoke in error in this case, and it's very important to us as FEA to get this resolved properly with a fair record.
Do you know what the differential will be for FEA if the commission uses the methodology in 13-00231 compared to the methodology proposed by the joint applicants for the rate credit distribution?
I do not know the differential for FEA. I do know the differentials generally for the other rate classes, and they're quite comparable, at least with residential and general service, the 2 largest classes, between the last base rate case and the 13 merger case that used the base rate case before that. Very comparable.
Would you expect that FEA will get more by using, or a higher rate credit by using the 13-00231 methodology compared to using the methodology proposed by the joint applicants in this case?
Absolutely, and it's equitable.
And when you would expect that residential customers on an individual basis would receive less in rate credits if the commission were to use the methodology in 13-00231 UT compared to what the joint applicants have proposed in this case, correct?
Correct. When you get into rate allocation, be it a rate case or with these rate credits, the allocation step is a zero-sum game.
If FEA is provided with a higher amount of rate credit, will the people in New Mexico that work for FEA share in any of that benefit, Mr. Etheridge?
No, and vice versa. We wouldn't share if it all goes to residential and small general service. Taxpayers wouldn't receive any.
Can you point to any benefit to New Mexicans that will accrue by giving the federal government, the FEA, a higher proportion of the rate credit than the joint applicants propose currently in this case?
Could you say one more time, please?
Could you read back the question for me, Mr. Lee?
Can you point to any benefit to New Mexicans that will accrue by giving the federal government, FEA, a higher proportion of the rate credit than the joint applicants propose currently in this case?
It's a minuscule benefit would be my answer, because the employees at Los Alamos, Sandia, Kirtland, the Air Force bases and such, presumably pay federal taxes. And this is something that DOE does and FEA does around the country. We protect the federal or the interests of federal taxpayers. It is equitable to allocate it to the FEA in the manner of across the board, all classes, in the manner that I've suggested. And to the extent that federal taxpayers have less of a burden, there's a small indirect effect on all federal taxpayers, including New Mexicans, but it's small.
Madam Hearing Examiner, those are all of my questions. I appreciate it.
Thank you, Mr. Haverly. I believe that BCP applicants reserve 40 minutes for Mr. Etheridge. Mr. Dubois?
Thank you, Your Honor. And actually, if I may, I would like to take 10 of those away and send them over for Dr. Blank, please.
All right, so we'll move you to 30.
Yes, Your Honor.
Okay, go ahead, sir.
Hello, Mr. Etheridge. My name is Will Dubois, and I'm representing the BCP applicants in this matter.
It's a pleasure, sir.
Likewise. Would you please go to page 2, line 4 of your testimony, your direct testimony? And there you state that you have worked on a variety of strategic and diverse projects related to things that include mergers, correct?
Correct.
Would it be correct to understand that your resume identifies only one merger on which you worked?
There were 2 mergers on which I worked. The first was Sierra Pacific Resources and Nevada Power Company merged. At the time, I was reporting to the CEO of Nevada Power Company. I was not on the internal confidential team that worked on those negotiations. I subsequently, after the merger was announced, because I was working with the CEO and a direct report to him, the only non-officer direct report to the CEO, I participated in merger integration meetings between Sierra Pacific Resources officers and Nevada Power Company officers and me. And that went over a period of meetings and months. That was the first merger. The second merger I was involved in is when I got a call from Mike Nigley, the subsequent CEO of Nevada Power Company. When I was on vacation, he said, come back, we've got a project for you. And then I was on a confidential team that submitted the successful bid to acquire Portland General Electric from Enron Corporation. That's noted in my testimony, but it doesn't state Portland, nor does the other merger explicitly stated, because I was working for the CEO on merger issues.
You believe that's a variety of mergers?
I have extensive experience with the two particular mergers, in depth as an employee, feeling the effects of a merger from an employee perspective, but also from the perspective of being exposed to the officers involved in those mergers. It's not the same as, for example, an investment banker or a lawyer that advises utilities. But for example, I was in a conference room with our investment banker and our CEO when we're discussing the Portland General Electric merger.
Can you spell Nigley or Migley?
Sure, Nigley is N-I-G-G-L-I.
Thank you.
I'll try again. Mr. Etheridge, are you telling us that that is a variety of mergers?
It's the two. I'm not going to choose the choice of adjective.
On page 3, line 20, you state that you, quote, provide FEA's position, correct?
Yes.
Do you have authority to determine FEA's position and bind the federal government as to the application in this matter?
I do not have the authority to bind the federal government in any way whatsoever. For example, from a negotiations perspective, I am hired by the Department of Energy as a contractor, and my testimony and positions are approved by the Department of Energy. And in this case, when we're working on intervention work, it's approved by the Department of Energy Office of General Counsel. Jelani Freeman works in that Office of General Counsel.
Did someone else tell you what the federal government's position is?
And by is, I'm assuming you mean this case here.
As to the application in this matter, yes, thank you.
No one at the federal government or at the Department of Energy, where I am a contractor to the Department of Energy, told me what to put in this testimony. It is my own.
Do you know who did approve your testimony as being the federal government's position as to the application in this matter?
I would say that the best answer is that it was filed by the Office of General Counsel, my testimony on behalf of the FEA.
Would you be unable to provide an answer as to the federal government's position on any matter that is not already explicitly stated in your testimony?
And again, on this case, I'm trying to make sense of the question because it's broad that it doesn't necessarily relate to this. I advise the government on many energy issues.
I'm sorry if you thought I might be referring to some other case when I said your testimony. I'll clarify that my question is whether, as you're testifying in this case, you do or do not have authority to answer questions as to what FEA's position is as to any matter that is not already explicitly stated in either your direct testimony, which is FEA Exhibit 1, or your rebuttal testimony, which is FEA Exhibit 2.
I don't believe that's correct.
Well, it was a do or do not, so could you please state what you do think is correct?
That's not correct.
Can you tell me what's not correct, Mr. Etheridge?
You're saying that I am limited, as I understand your question, to each word put in my direct testimony and my rebuttal testimony and have no authority to opine beyond that. And that is incorrect.
I did not tell you that, Mr. Etheridge. My question to you, I'm asking you questions, sir. My question to you is, do you or do you not have authority to speak on behalf of the federal government as to matters that are not already explicitly stated in your direct testimony, which is FEA Exhibit 1, or your rebuttal testimony, which is FEA Exhibit 2?
Objection, Your Honor.
Mr. Freeman?
I believe the question has been asked and answered, and we also object on the grounds of relevance.
I don't think he specifically answered the question. He told Mr. Dubois that he was incorrect, but I don't know. They were trying to clarify the question. Now, with regard to relevance, that's something different, Mr. Dubois.
Your Honor, given that the basis for this testimony is to be stating the federal government's position on the application, and certainly there have been times where people have been testifying regarding things that arose subsequent to their testimonies or where they go beyond the exact words in their testimony. I think it's important to be able to understand where the boundaries of Mr. Etheridge's ability to testify as a witness on behalf of the federal executive agencies are, and to understand how his answers should be interpreted and weighed. I think it's extremely relevant, and I don't know. I'll stop there for the moment.
Mr. Freeman?
Yes, Mr. Etheridge is hired by the Department of Energy as an expert. I think with his written testimony and him testifying in his hearing now, he's here to provide his opinion. I don't think getting into the mechanisms and the structure of how the federal government makes decisions is relevant here. And I would include that I think Mr. Dubois can ask him about his opinion, but certainly I don't know if he should be asking him or any other witness if they can agree to anything, understand?
No, we ask witnesses that all the time. There have been instances in this case where it appears that the witness has changed their testimony. And that's the basis of the bench request responses to 1 and 3, where actual commitments had been made by BCP and the joint applicants in this case. So, it happens. So, I don't know if I'm able to discern structure versus changes that have occurred. So, I will sustain the objection, Mr. Dubois, but with the instruction that you can ask him questions if something has changed since he has filed his testimony, if he has an opinion on it. Go ahead, sir.
Thank you, Your Honor. Mr. Etheridge, I'll refer you to page 24 of your testimony, please.
FEA 1?
Of FEA 1, yes, Your Honor. Thank you.
Yes, I'm there.
And page 24 is one of the passages of your testimony where you discuss your opinion as to Atmos, Southwest Gas, One Gas, and Spire's relative attractiveness as purchasers of NMGC, correct?
That's correct.
Does the federal government have a preference as to which of the four should purchase NMGC?
No.
Did the federal government reach out to Atmos to encourage them to make an offer for NMGC?
No.
No, it did not. You know that?
I don't know that. So let's clarify this a second. With regard to these four LDCs, you asked me whether these were LDCs that, I'll paraphrase how I've read my testimony, were potentially attractive suitors. Now, I don't know everything or for New Mexico Gas Company. I do not know every conversation a federal employee may have had in discussions with BCP, Atmos executives, or anybody else. And so I correct my prior answer.
Do you think it is the New Mexico Public Regulation Commission's role to identify a preferred purchaser of a New Mexico utility?
I think they need to examine potential purchasers of New Mexico Gas Company or any utility in New Mexico over which they have jurisdiction to examine the potential purchaser, the qualities of the potential purchaser, and the likelihood or form an opinion as to whether the potential purchaser will create value for New Mexico Gas Company customers or any other utility customer. And I've been particularly focused on synergies and shared services. And so one of the five bidders after the first round that Emera held, for example, noted something that I can't address at the moment. It's confidential, but it involves shared services.
Your Honor, I'm going to interrupt the witness on purpose, please. I don't think this has anything to do with the question I actually asked. And this is not the first time Mr. Etheridge has gone on for some time on a subject that's beyond what I asked.
All right, you think that the answer is non-responsive? What was your specific question?
My specific question is whether he believes it is the role of the New Mexico Public Regulation Commission to identify a preferred purchaser of a New Mexico utility. And he's talking about synergies and his evaluation of synergies in this transaction.
Mr. Etheridge, did you understand the question? Did you answer? Do you believe that that you answered this question?
I believe the question is, should the commission look to the qualities of potential purchasers of utilities in New Mexico? And I think absolutely the commission should look at what a potential acquiring utility brings to the table. And that's how you're going to figure out a variety of potential benefits, public benefits, you need to find comfort that they can operate this utility safely, reliably.
Hang on just a second, Mr. Etheridge. Tell me again, Mr. Dubois.
I have asked Mr. Etheridge.
Does the commission have the
role of identifying a preferred purchaser of a New Mexico utility?
I think it's a yes or no answer, Mr. Etheridge.
As regards identifying a preferred, it's no. Yeah. You don't get a choice.
Go ahead, Mr. Dubois.
Do you believe the commission should evaluate and compare hypothetical alternative purchasers versus what is before it in this application?
Absolutely. I think the commission should look at potential suitors and decide, is this the right suitor for this company or not?
Has the commission ever done such an evaluation before?
I don't know if the commission has in the past.
Did you look into New Mexico cases to determine whether it has?
I have not looked into New Mexico cases to determine whether it has, but I feel it's important to making a decision.
Is your testimony, is the opinion you offer based on your understanding of New Mexico law and this commission's precedent?
No.
But you offer one of your key conclusions without having done any evaluation of what the commission's precedent or what New Mexico law is on the subject?
I don't believe that's correct.
Can you identify which cases you looked at to determine whether the commission does a comparison with other alternative hypothetical purchasers?
I'll try and keep this short. I simply am familiar with the various factors the commission looks at. And in determining public benefits, they can say, or the totality of those factors, they can say yay or nay on a potential acquirer. And if it's not a yay, meaning that they do not approve an acquisition, then it can proceed forward and there may be another solicitation, just like Public Service Company in New Mexico that's changed its name.
Is that a no, you did not investigate any other opinions?
Yes, I've looked at opinions from the commission that have formulated factors that I've weighed in my mind in thinking about what the commission should do in this case.
What in those opinions did you see that affirms for you that the commission can or should do a comparison with hypothetical alternative transactions?
It's a qualitative decision. That's what I'm suggesting the commission do. To be prudent in what you're doing in terms of making a decision regarding an acquirer, particularly one that's the only one from a solicitation that resulted, it might be prudent, and that's my opinion, that's what I'm expressing in my testimony, to become knowledgeable of potential other acquirers.
Is that a way of saying that there is no such support in those opinions?
Again, I was referring to what I learned from the opinions and how I view this case and the opinions I'm trying to offer this commission.
And my question is, please identify what in your opinion, what in those opinions you saw that tells you that the commission should perform an evaluation of this application relative to hypothetical alternative transactions.
I'm going to leave it be as the commission should make its own decision regarding this applicant. And there's nothing explicit in these other orders that tells the commission how to deliberate and make the decision in this case.
Is that a way of answering that you have no such support?
He answered the question this time, Mr. Dubois. Move on.
Okay. Is it your understanding that Emera has pursued, quote, maximum potential synergies at NMGC during Emera's ownership of NMGC?
I do not know if they have or not.
Did you conduct any sort of evaluation of that?
I have not conducted an evaluation of the efforts Emera has put in to create efficiencies and downward pressure on New Mexico Gas Company's rates.
Isn't it true that one of your objections to the application is that Saturn has not identified that it would achieve maximum potential synergies at NMGC?
I am concerned that when you take a startup entity like BCP with its Delta Utilities and puts together a service company of 150 employees in a very short period of time, that there's risks to federal facilities and New Mexico Gas Company's customers if this acquisition goes through, because it just may be that the service company's costs as quickly put together would be higher than some other potential service company in another company, like some of the LDCs I talk about.
Do you recommend eliminating finance positions at NMGC and consolidating them with operations of other utilities?
There's a net, yes, in terms of seeking maximum synergies, I can see multiple positions that BCP has suggested go to New Mexico might be better housed elsewhere in
Do
an
you
existing
recommend,
service company.
do you recommend
Sorry, sir, the
eliminating,
last part of your answer.
Certainly, Mr. Lee, in an existing service company.
do you recommend eliminating some or all of New Mexico Gas Company's human resources function that's located in New Mexico?
I do not.
So you don't believe that would be a potential synergy for Emera or for the other purchasers that you would like to see?
When I go back to the question you just previously posed with the financial and now onto HR, there are situations, even in a well-run LDC with a service company, where certain positions are going to be out with the op company. And I should have said operating companies. Not everybody will be in the service company. So there may be plant accountants out with the operating company and not in the service company. They could be located potentially efficiently with the operating company. Whether it makes sense from an HR perspective, that's more likely to be entirely in a service company. And just as a note, one of the bases for this discussion, I've looked at PNM's or Public Service Company New Mexico's organizational chart, utility in New Mexico, and every single position in that org chart, every single one. I know every position in the service company, every position in the op company in New Mexico, and every position in the op company in Texas. So I'm familiar with how these organizations look.
Do you recommend eliminating the local New Mexico Gas Company Board of Directors to save money?
Not to save money. I do not think certain suitors, but I can't be sure of this, who were looking at New Mexico Gas Company would have said, we're not going to have a local board.
None of the, what you referred to as other potential suitors, or I'll start over. So
No,
we're clear.
you
None of Atmos, Southwest Gas, One Gas, or Spire use a business model that has a local board of directors for an individual operating utility that is consistent with the use of such a local board of directors at New Mexico Gas Company, correct?
That's what my research has indicated, correct?
You are aware, correct, that Atmos Energy has over a 9.8% authorized return on equity and the ability to recover capital expense through riders in Texas, correct?
I have not researched their rates or their recent rate orders, sir.
Are you aware that Atmos Energy overall has a blended allowed return on equity of 9.8%?
Same answer as before. I have not looked at the recent Atmos rate cases and determined what the orders were in those cases.
Please take a look at what you attached to your testimony as FEA Exhibit DD1, page 1 of that.
I only have a question first before I do, Madam Hearing Examiner. To the extent that this isn't part of this testimony, how do we deal with this?
I'm going to strike the question because I'm going to strike the exhibit. Move on, Mr. Dubois.
If hypothetically, the Texas utilities you prefer have 9.8% and above returns on equity and the recovery of capital expense through riders, would you recommend that New Mexico adopt both of those for New Mexico Gas Company?
I've not testified on what rate-making mechanisms from other jurisdictions should be applied to New Mexico Gas Company. It's beyond my testimony.
Do you believe that a 9.8% return on equity and guaranteed recovery of capital expense, if the New Mexico Commission allowed it, would make New Mexico Gas Company more attractive to your preferred purchasers, or the federal government's preferred purchasers? I'm sorry.
I think there's those factors that would potentially make a target utility more profitable and with a more stable source of cash flow would make it more attractive to suitors. Regulatory climate does matter in terms of how acquiring entities view jurisdictions, just as do policy at the state level.
So does the federal government?
There's a lot of factors that would go into how one, as a potential acquiring utility, would look at a potential target utility.
Does the federal government recommend that the commission deny this application and grant New Mexico Gas Company a higher return on equity and guaranteed capital expense recovery in order to attract Atmos, Spire, Southwest Gas, or One Gas as a substitute purchaser?
That is not my testimony.
Does the federal government have an interest as to whether New Mexico Gas Company jobs are located in New Mexico or in another state?
The federal taxpayer does not per se have an interest in any of the various jurisdictions around the country on that specific issue. We are large employers of federal government in New Mexico. We care about New Mexico. We have large facilities there. We have employees that are New Mexicans. So we care about the state. My testimony is focused on efficiencies, primarily in shared services to save federal taxpayers money, and also on the rate credit to represent federal taxpayers equitably.
Thank you. Thank you, Your Honor. Those are my questions.
Thank you, Mr. Dubois. I believe the other party that had reserved cross-examination for Mr. Etheridge was staff. Mr. Rossi, Ms. Lang, Mr. Friedman, who
Yes,
has
Madam
this
Hearing
witness?
Examiner, this is Ryan Friedman speaking on behalf of staff. I do have some questions for Mr. Etheridge.
Okay, go ahead, sir.
Looks like we have a hand up. I don't know if you want me to proceed.
Mr. Harris.
You're on mute, Mr. Harris.
You're on mute.
I would like to ask a few questions on cross. It will be less than 5 minutes.
Okay, you can go after Mr. Friedman.
Thank you.
Go ahead, Mr. Friedman.
Thank you, Madam Hearing Examiner. Good evening, Mr. Etheridge. My name is Ryan Friedman. I'm representing the PRC staff in this matter, and I do have a few questions for you. I'll try to keep this as brief as possible. These questions will mostly surround your testimony regarding the Severe Weather Fund, just to give you context. First question being, for the $12.5 million initial sum that staff advocates to be placed in the proposed Severe Weather Fund, do you agree that it is the BCP applicants who would provide this funding through a redirection of money they have offered in this case?
Staff's proposal is to use a redirection of 12.5 million that's on the table. and offered by BCP for the purpose of the severe weather fund.
Correct. Do you agree with that?
Yes.
And do you agree that no NMGC customer class would be responsible for initially funding staff's severe weather fund proposal?
There will be no cash flow taken from any rate class explicitly and given to sales customers to fund this severe weather fund. But there is value, monetary value that I'm proposing be spread equitably that would be that's the rate credits. I'm sorry, the 5 million of economic development that's included in my rate credit proposal. Staff is saying, let's take that and redirect it. So there is a loss, an economic loss to customers that are transportation customers with that proposal.
But my question is specifically to the 12.5 million initial sum that BCP has proposed.
Yes, staff's theory in your question is whether cash will flow from rate classes to fund that. My answer is not explicitly, but what will happen with staff's proposal is money will be taken out of what I'm proposing as an additional 5 million in the rate credit and redistributed away from transportation customers and only for the benefit of sales customers. And I don't believe that's equitable. That's implicit funding.
To your knowledge, is there any commission rule or state statute that requires monetary benefits associated with the purchase or sale of a utility company to be equally allocated to each customer class?
I don't believe that is the case, nor do I believe that in rate cases, the commission is bound by anything other than its belief in setting just and reasonable rates for all classes.
I'm not talking about rate cases, though. Specifically, I was asking if there are any commission rules or state statutes that you are aware of that requires monetary benefits to be equally allocated to each customer class.
In this case, which is a acquisition case, to the extent there are monetary benefits, the commission has jurisdiction and authority to do almost anything that it thinks is just and reasonable. And that's why I've offered an opinion to persuade the commission to do something equitable.
Do you know what percentage of NMGC's total customer base are sales customers?
In the look that I first performed to prepare this rebuttal testimony, the documents that I looked at suggested about 50-50. I've looked back at some other documents, possibly in some of Mr. Yardley's testimony and exhibits in prior cases. That percentage may be slightly higher, but that's the extent of my research.
Did you say Yardley?
I did. Yardle, Mr. Lee.
Thank you.
You're welcome.
Do you have FEA exhibit number 2 in front of you? If not, can you pull that up?
I do have it.
I'm going to refer you to your rebuttal testimony there on page 3, lines 4 through 6.
I'm there.
Would you agree with me that in these lines that you mentioned the concept of risk faced by NMGC customers?
I do.
Is the risk of extreme swing gas prices a risk faced only by NMGC sale customers?
Yes, the customers that are affected by price volatility in terms of New Mexico Gas Company's costs are the sales customers, and possibly to an extent to which it affects balancing charges for transportation customers.
Would swing gas prices affect any other customers besides the sales customers class?
The sales customers aren't a class. They're a group of customers that purchase from New Mexico, purchase commodity natural gas from New Mexico.
A group
Gas
of customers.
And it's my understanding that they're the ones that would benefit because they pay the purchase gas adjustment clause rate. Transportation customers do not pay that rate.
Mr. Friedman?
I'm reevaluating some of my questions here, Examiner Hurst, if you can just give me one moment. Would you agree that transportation customers specifically buy their own gas and then pay New Mexico Gas Company to use their infrastructure to move that gas where they want it?
The transportation and distribution infrastructure, correct.
I have no more questions, Your Honor.
Thank you, Mr. Friedman. I just have a few questions so that I understand your testimony.
Guys, you want to let Mr. Harris go first?
Oh, I'm sorry. I did forget Mr. Harris. Mr. Harris, go ahead with your questions.
Thank you, ma'am. Sir, Brian Harris with the New Mexico Department of Justice. I've never met before, but it's a pleasure. Earlier, you testified about employees of the federal agencies in New Mexico. Do you remember that?
I do.
Do you agree that some very high percentage of those employees are New Mexico citizens?
I would believe that's the case, yes.
Would you believe or agree that many of those citizens are also ratepayers?
Yes.
So any benefit beyond what they get as federal agency executives would also apply in their role as ratepayers, correct?
We didn't clarify what they get.
Well, can we assume that they might get some
I'm not sure.
It's somewhat.
Yes.
benefits, such as rate credits or a rate freeze or severe weather funds? It's not dependent on the fact that they're federal employees. Is that correct?
With that clarification that monetary benefits resulting from this case that flow to New Mexico Gas Company ratepayers or New Mexicans will find their way to federal government employees in some fashion.
Thank you. That's all I have.
Thank you, Mr. Harris. Mr. Etheridge, I just have a couple of questions with regard to understanding your testimony. And if I look at your direct testimony on page 5, line 12, the question posed is, what are your recommendations? And you begin your answer on line 13, and you say, I recommend that the commission deny the joint applicant's revised application. That's your testimony, correct, sir?
It is.
And then at line 19 on that same page, you pose the question, if the commission was inclined to approve Saturn's acquisition of gas company, then do you have recommended improvements to joint applicants' proposed value proposition that would, comma, in your opinion, comma, more equitably position New Mexico Gas Company's customers relative to Saturn's investors? And then the answer to that begins on page 6 at line one and you say, yes, I do, and then you have 3 bullet points. Is that correct, sir?
That is correct.
And what my question to you is, if the commission were to adopt your 3 recommendations on page 6, then would you support joint applicants acquisition of gas company?
If the commission decides to approve the application, then these 3 bullet points on page 6 are what we've asked for in the alternative. It's up to you to weigh the evidence and make your own decision in your report, and let the commission make their decision on the opinions of the experts in the case, applicants and others. And I just want to point out, I am concerned about achieving synergies that will create long-term value for New Mexico Gas Company customers. And that's been a focus of my testimony.
So then truly this is an alternative proposal based on the commission's approval, not that if joint applicants were to agree to these 3 things, then you would support the application.
I believe that if Jelani asked me after this case, how did we do? What did you think? These 3 points were important, and I might offer some other advice to Jelani. Well, what's the effect on the federal executive agencies? One effect, if you approve it, and in fact, the synergies don't result, means we're going to spend more time fighting in rate cases, trying to prove that the joint applicants could have done better than what we had with Emera. That doesn't mean we're going to say, well, this was terrible and whine about it for years. Of course not. All I'm saying is that after you make your decision, we obviously live with it. We're just offering opinions. And my opinion is that I'd be a little bit concerned about whether you think this acquisition produces the best value for New Mexico Gas Company customers. And that's what I'm testifying to. If you say it works, that I'm pointing out the 3 things that I thought made sense at the time I wrote this rebuttal.
One of the responses that you indicated pursuant to a question one of the cross-examiners asked you had to do with a clarification to the record on what FEA's proposal was with regard to rate credits. Do you remember you testifying to that earlier?
If you're referring to when I testified that both the applicants, Baudier and Shell witnesses, testified incorrectly regarding the allocation of rate credits, then yes.
Can you tell me for the record how you would recommend that the commission, should they decide to approve the application, would account to the ratepayers for any type of rate credit?
Your Honor, and by account, meaning explain or
distribute?
Oh, in my direct testimony, I said there's 2 steps. Allocate the total dollar value of the rate credit based on base rate revenue requirement by class. That's the allocation that produces that 94% that was listed in the 13 merger order and attached certification of stipulation. That's going to happen again if you approve FEA's proposal. I've testified, I've researched it. It's approximately the same percentage of the rate credits will go to residential and small general service customers, and a small equitable share to other customers. The next step answers your question, but the first step is critical, and it's what everybody's been missing. The next step is, once you've allocated the rate credits to the rate classes, each rate class has a bucket of dollars. You got to get the bucket of dollars in the hands of the consumers. You do that by dividing it by the therms, annual therms for each rate class, and you get a rate, a per therm rate credit for each rate class, exactly as it was done in the 13 merger, exactly as New Mexico Gas Company filed in its compliance filing following the 13 merger, which was approved by the commission.
Very well, sir. Thank you. Appreciate that. Mr. Freeman, any redirect for your witness?
I did. I had at least a couple questions, maybe. Sir Etheridge, do you recall earlier, Mr. Haverly asked you whether it would be reasonable if Emera and JP Morgan Chase wouldn't have solicited neighboring LDCs?
I remember we discussed that.
I believe you answered it wouldn't be reasonable. Do you have any opinion on why those LDCs would have rebuffed JP Morgan Chase and Emera?
Objection, Your Honor, Brian Haberly.
Mr. Haverly?
Misstates my question, Madam Hearing Examiner. I did not ask him about reasonableness at all.
Mr. Freeman?
That's what I have, Your Honor. I have that Mr. Haverly asked that, would he think that it wouldn't have been reasonable that Emera and JP Morgan Chase would have solicited neighboring LDCs?
What was your question then, Mr. Haverly?
I asked him if he believed that Emera and JP Morgan failed to solicit them. The word reasonableness never entered my mouth, is my recollection. I just asked him if he believed that they had missed doing it.
Not to quibble, Your Honor, I can restate the question so we can move
Okay,
on.
go ahead, Mr. Freeman.
So as Mr. Haverly just said, he asked you whether they had failed, both Emera and JP Morgan Chase, to solicit neighboring LDCs. Do you have any opinion on why those LDCs, if they were reached out to by Emera and JP Morgan Chase, would have rebuffed the offer?
And to clarify, I'm going to answer that, but I just want to clarify the question. They didn't rebuff the offer per se. I agree with Mr. Haverty that JP Morgan would have reached out to a large group of people on behalf of Emera, or a large group of companies on behalf of Emera, and Ms. Hutt has testified to that. Then, in terms of what caused individual companies to not submit a bid, is something I can't know for sure. I wasn't on the insides of the conversations between Emera and JP Morgan and potential acquirers that caused potential acquirers to say, this is not for me, I'm not moving forward, leaving one left.
Thank you. That's the only question I have, Your Honor.
Thank you, Mr. Freeman. Any recross? Mr. Haverly?
No, Madam Hearing Examiner, I have no recross for this witness.
Very well.
Appreciate the opportunity, though.
Thank you. Any recross, Mr. Dubois?
Thank you. No, Your Honor.
And Mr. Friedman?
Nothing on behalf of staff. Thank you, Your Honor.
And Mr. Harris?
No, thank you, Your Honor. I'm good.
Very well. Thank you. Mr. Etheridge, we appreciate your time, sir. Thank you for appearing here, and you are excused. Wait, Mr. Yar?
Oh, I'm just preparing for the procedural end. I had some questions. I don't mean to interrupt, Madam Hearing Examiner.
Okay. Thank you, Mr. Etheridge.
Thank you, Madam Hearing Examiner.
Mr. Freeman, I'm ready to rule on the attachments. pursuant to my former rulings, I do not believe that FEA 1 attachments DD1, DD2, DD3, which were not prepared by your witness, but were downloaded from somewhere per his statement. I believe they're inadmissible hearsay and they need to be struck from FEA Exhibit 1. With that, is there any objection to FEA Exhibit 1 without attachments DD1, DD2, and DD3? Hearing no objection, FEA Exhibit 1 as ordered is admitted. With regard to FEA Exhibit 2, the attachments DDER-1, DDER-2 are also denied. They are documents that are actually excerpts of testimony in other commission cases where the witness is not even available. So both of those exhibits are struck. Again,
Sorry,
Mr. Lee.
I didn't say anything, Judge.
I was,
Oh,
sorry, Jelani Freeman. Just want to make sure that we're on the same page. So for FEA Exhibit number 2, you are referring from the excerpt from New Mexico Gas Company, right?
the rebuttal testimony, DDER-1, at the bottom of that, it says source, direct testimony of a witness in case number 24-00222.
Okay, I just wanted to clarify. I see that. Thank
Yes.
you.
And the DDDER-2, on page 1 of 2 at the bottom says source, direct testimony of a witness in case 21-00095. And I do not allow documents where the witness is not available to be cross-examined on other testimony in the case. As previously explained, the commission orders or the recommended decisions or certifications of stipulations as adopted by commission orders are appropriate for administrative notice, not parts of testimony. Therefore, is there any objection to what's been identified as FEA Exhibit 2 as without the attachments to be admitted into the record? Hearing no objection, FEA Exhibit 2 will be admitted per my rulings. Please get the copies of the conforming exhibits in if you can tonight. I'm finding out our testimony, our transcript can't be filed without the exhibits. I just got an email to that effect. Anything further, Mr. Freeman?
Your Honor.
Very well. Let's see.
Madam Hearing Examiner, I'd just like to reiterate your observation that for any parties that have exhibits outstanding, please submit them immediately.
Immediately.
Thank you.
Thank you, Hearing Examiner Schaefer. Ms. Beatles.
Yes, my hand is
Hi.
not up. So do you
I
have a
know
question for
it's
me?
not up, but I have a question. With our starts and stops today and technical issues, I wanted to make sure, and since I can't get on the the transcript link, I wanted to make sure that I had given you a definitive ruling on WRA. Two.
The draft report, Your Honor?
Yes. Last I heard, I was thinking about it. Is that correct?
That's the last I'm aware too.
Okay. But I had already indicated to you that I was striking, was it 13?
Yes.
Okay, so I already ruled on 13. I hadn't ruled on 4, which was the draft report from gas company that they attached as an answer to an interrogatory, and it included the affirmation of gas company witness. Correct?
Correct.
In order to be consistent with the admittance of other interrogatories in this matter, and not to be unfair to WRA, I'm going to admit Exhibit 4.
Thank you, Your Honor.
I caution parties in the future with regard to inclusion of attachments as opposed to the live expert testimony. I'm just trying to scroll through here. Here we go. All right. Okay, so WRA Exhibit 1 minus Attachment 13. Is there any objection to admitting that into the record? Hearing no objection, WRA Exhibit 1 is admitted. If you could just try to get that, Ms. Beatles, into the Dropbox.
All right, I'm going to step out because I think my legal assistant's still here and I want to catch her.
Okay, thank you. Let's see, did I have any other? Ms. Nanasi, you
Yes.
had asked me if I had had an opportunity to look to see if any Exhibit 2 conformed with my ruling yesterday. Is that correct?
Yes, Your Honor. And I wanted to make sure that you got the last version because the first version didn't have the label on it.
Okay, and that was going to be my question. It's because there were like 2 that were filed like within 15 or
minute of
20
each other.
minutes. Right.
Yeah, right.
Right. Yes. So I should consider the latest file, like we have with all these, the latest file one in the Dropbox is the correct one, correct?
Yes, yes, Your Honor.
Okay. And I did find that it was conforming. So just to confirm, any objection to NEE Exhibit 2 as ordered yesterday? Hearing no objection, NEE Exhibit 2, the latest version is the conforming one.
Also, I did during this last cross-examination, because I know that you and hearing examiner Schaefer were concerned about not having the exhibits quickly. I redid the Sandberg testimony per your order, and I think that should be conforming as well. So I did what you said, which is to put a note on the front page and then just
You have that on the front page.
red line, the parts in the testimony that said exhibit when it wasn't going to be an exhibit. And then I have a new exhibit list with them crossed out, and then only the exhibits that you agreed to.
Okay, now the only problem we have here that I just see in the Dropbox is I ordered yesterday, I went back and looked at the rule. Because Mr. Yar was going to have an offer of proof. And I went back and I looked at section M and offer of proof. And you were not here this morning, so I'll read this for your benefit, but an offer of proof for the record may be made and shall consist of a statement of the substance of the evidence to which the objection has been sustained. The commissioner presiding officer may require offers of proof be submitted in writing in question and answer form. That's what I ordered this morning. So you're going to have to take your offers of proof and submit them in question and offer form. And what you need to do is label them as offer of proof, NEE offer of proof number, and then whatever you want to call it, number 1. But it's going to have to be submitted in a question and answer format. Okay?
Yes.
All right. So this one in the Dropbox that says offer of proof, I'm not going to look at, but I'm going to look at where is his conforming testimony. I see 2 offers of proof, but I don't see a new NEE number 1, except from yesterday. Is that the one you're referring me to?
No, I just did it, and I got that one woman who's past the finish line very happy. But let me make sure I can do it again right quick.
Okay. All right. I'll take a look at that. And while you're doing that, Mr. Yar.
Madam Hearing Examiner, much of what you explained kind of answered my questions. I just wanted to let Your Honor and Mr. Schaefer know that we did file the revised testimony. The only question is there's 2 versions. There's the bad version. We can't delete. We don't have the power to delete. So I think we just filed it a couple hours ago. So I just wanted to bring that to Your Honor's attention.
Okay.
The follow-up question is a point of clarification. I think when you were discussing with Ms. Nanasi regarding the naming convention, I thought we had agreed that the offer of proof, if it's referring to a specific exhibit, in our case, it would be Exhibit 18, for example, we would say Exhibit 18-OP for offer of proof. And
I
that
think that's going to be too confusing. I
Okay.
discussed it with Mr. Lee, who I rely on as the expert
Sure,
in our transcript.
sure.
And he thought it might be more clear if you just name it NM area offer of proof number 1
Okay,
for the first one and offer of proof number 2. And then you can describe exactly what it is.
will do. That makes sense.
Okay. Again,
Okay.
all right. Anything further?
One last thing. We were confused. Obviously, we're clear that we need to upload the offer of proof to the Dropbox. Is that something that needs to be provided to records also, along with the revised testimony that we just submitted?
Probably better safe than sorry. I think, Mr. Yar. Yeah,
That makes sense.
just that's my off the cuff response to you. Is yes, hearing examiner Schaefer, thoughts on that?
I was going to say exactly what you did. Yes, I think it's wiser to file it as well, and that way there's no doubt.
And and as long as there's no confidential information in it, it'll just, yeah.
Okay.
Okay. Is that it?
Thank you. That's it.
Okay. Anything else from the parties? Like I say, try to get those in because we can't file our transcript without the exhibits, I guess, is what I'm being told. Okay. Thank you all. I really, really appreciate Mr. Lee. Thanks for staying late. Thank all of you for staying late. I feel really good that that we're going to get through our witnesses tomorrow. And again, be prepared tomorrow to let me know what you all think is an appropriate briefing schedule. Send emails to each other. Would be nice if you all could actually agree on a proposed briefing schedule. Anyway, with that, I thank you and
Judge, take a moment.
Mr. Lee.
If they upload to the Dropbox, I need whatever is uploaded sent to me so I can re-download it, just so you know. Thank you, Judge.
Okay, you're hearing that Mr. Lee saying whatever you're putting in the Dropbox as the final version, please send to him.
Can we have the your email address, please?
I'm going off the record to say this. It is CUMBRE, Cumbre, Court, COURT, one word, at Comcast.net.
Very well. Okay, if there's nothing further then, I look forward to seeing you all in tomorrow morning. And we will begin our presentation of the witnesses, I believe with Dr. Penn from CCAE, and then we will hear from the staff witnesses. So look forward to that. Have a good evening. Mr. Lee, would you please call me?
Judge, if you could use that same email address and send me your phone number, I'll do it.
Okay. Thank you. We are recessed until 9 o'clock. Thank you.